The item number 170 of your Lordship's list, well, I'm mentioning upon notice. But Lordship may remember that I had mentioned this matter and your Lordship directed to appear. Matter appeared item number 34 on the first day. Matter reached up to 33. Matter reached up to 33. Thereafter, my lord, it is gradually going down. My lord, I am mentioning on notice, my lord.
The matter goes the old age.
But kindly give me some preference any day.
Item number?
170.
What is the urgency?
Well, it is my. I am in possession of the property.
Acha, hearing.
Yes.
So it will come.
It will take not more than 10 minutes, I tell you, Lord.
Thursday, na? Yes. Hearing matters will come Thursday in up.
Thursday.
Thursday.
Any time you Lordship is
please see the cause list. I have allotted Thursday hearing matter will be taken first. Friday criminal matter will be taken first, and all other days motion and new.
Okay. I will take my chance.
Hearing matter come on Thursday.
May I be permitted to mention one urgent motion? This is new motion. It is urgency in this sense the petitioner has taken a loan of more than 1 crore, and he has to, in the absence of electricity, he is running his factory. So he has to expense a huge amount of interest on the loan. It let it appear. It was due to appear on 11th.
So what is the urgency?
Yeah, I have written.
Huh?
I have written here urgency. He has taken a loan of 1 crore, more than 1 crore from the bank. But he is to repay the loan until the factory is running.
Why the factory? There is no electric connection.
Electric connection.
Grant of electric connection.
Yes, sir. When it appears tomorrow, I have given notice to all the parties.
Urgent motion.
My lord, may I permit to mention one matter, my lord?
Urgent motion.
My lord, this matter I mentioned on 7th, my lord. Considering the urgency of the matter, because Facilitation Council under Section 18, they have terminated the reference and proceeded with the arbitration. They have no jurisdiction because there is no buyer and seller unit is there, man. It's a works contract. Supreme Court has held the works contract. It cannot be. Considering that urgency, your lordship directed the matter to appear on Tuesday, today. My lord, the file, I have sent the file here on 11th. I told the officer to list the matter on Tuesday in pursuant to your lordship day. Even then, the matter did not appear today in my list. I do not know, my lord, what is happening. Lordship, kindly, that my urgency is there, my lordship. You have considered, your lordship has considered my urgency. The record is here from 11th.
May I have your lordship?
Senior, who is the senior?
May I have your lordship kindly, my lord? But this pertains to, my lord, a political meeting, my lord, on behalf of the Bharatiya Janata Party, the party in opposition, my lord, on this Friday. My lord, as usual, it's a regular occurrence, my lord. We have to move the honorable courts, my lord, to get permission. Now, my lord, we are challenging, my lord, the inaction of the SDO and the fire authority, my lord.
Why?
Fire license, my lord, is not required under 23A because there is no wall or no ceiling, my lord. There is no pandal. It's just a dais, my lord, which is being constructed, which will be temporarily built. Now, the police is insisting that no, you have to obtain fire license. We go to the fire department. The fire department refuses to accept the form. We have annexed the form also, the application form. They supply the form. Then they say that no, we cannot accept unless the police directs us to accept. First is this. Second is, my lord, insofar as using of amplifiers and loudspeakers, the subdivisional officer, my lord, he is the competent authority. But he has maintained a stoic silence. It's a regular, my lord, feature. My lord, Friday is the meeting, my lord.
Friday?
This Friday. My lord, kindly, my lord, permit me, my lord, to effect short service and move it on, my lord, Tuesday, my lord. Move it tomorrow, my lord. Today we are on Tuesday.
So you want to move today, tomorrow?
Tomorrow, my lord. We can effect short service and come back, my lord.
And leave is granted to file and be listed tomorrow.
Grateful.
Tomorrow is urgent motion.
Matter regarding the electricity new connection. In spite of everything that has been done by the petitioner, see, money was deposited as per the quotation law. In spite of that, they are not giving electricity.
It is not in the list.
Not in the
New motion.
May I have your lordship?
New motion, huh?
May I have your lordship? I am paying for upgradation of the item number 103 and
103 under which heading?
it is under motion. So I am praying to let the matter appear under the head urgent motion.
Why? What is the urgency?
The private respondent has fled from Nigeria to Calcutta after commission of crimes in Nigeria, and the wanted notice has been issued against him. So the
What is for the writ petition? What is for the writ petition?
writ petition is that external affairs minister should give direction to Kolkata police to arrest him.
Go to the police action. Why before this court?
My Lord, I mentioned, my Lord Honorable Justice Tirthankar Ghosh has released that it is with regard to external affairs minister, so the matter will come before your Lord.
Tuesday urgent motion.
Lordship,
Tuesday urgent motion.
Lordship, I am
Which department? Huh? So what you prayed for in the writ application? So what is your prayer? Appointment letter. To whom? To whom? To whom the appointment letter is to be issued? Medical officer, marriage officer. So what is the urgency? So might be. So what happened? Put it in the new motion.
Inclusion, my lord, as per order of the honorable court, the inclusion.
All the new motion you want to include, give all the papers to my court officer. Let the new motion, my application, whatever the new motion, give to my court officer, it will be listed.
My lord, electricity matter also, my lord, within your lord.
Lordship,
With notice.
Lordship, may I be permitted to mention a restoration application? I had mentioned it on 3rd November, Your Lordship.
Your file is not reached. Whatever the restoration application reached to the court, every day it has been listed. If
my
it
lord-
is reached, it will be listed.
With my lord's kind permission, my lord.
My lord, may I have your lordships, my lord, kindly, when I am mentioning for the second time, my lord, notice on the other side, my lord, this by an order dated 11 September 2025, the Honorable Supreme Court has remanded back this writ petition. My it deals with consumption of electricity, and my lord, the electricity connection is disconnected. But I have to incur cost of the hatchery business because that's all the laborers are
What
skilled.
is the order of the Supreme Court?
My lord, this is the order.
What the Supreme Court says?
Accordingly, we set aside the impugned judgment dated such and such, passed by the revision bench of the High Court, as well as the order passed by the learned single judge in WPA number 30288 of 2024, and the matters are remanded back to the learned single judge of the High Court for de novo consideration. The writ petition stands revived to its original number and file. However, as such facts have now been considered by the learned single judge, the parties are at liberty to file additional affidavit documents, which I have already done. My the
Who is for
Honorable
the
Chief
other
Justice-
side?
my lord, WBCTCL,
Who is for the
the West Bengal State Electricity Day.
Have you issued the notice?
My lord,
Okay, yeah.
With my lord's kind
So
permission.
what is the urgency now? It is to be heard on merit.
no, my lord, electricity is disconnected, and I am incurring loss day in, day out, my lord.
Tuesday rakho. Tuesday adjourn motion mein rakho.
Tuesday, next Tuesday. Grateful, my grateful.
This is pertaining to your lordship order and lordship. 15th of December, all these challenges to the incentive revocations. They chose not to file affidavit. Made these two repetitions also appear with the other facts, followed by this challenge.
और
That order also in the other matter.
With my lord's kind.
एक काम उसको 5th December under what क्या which heading?
So there is there one. This will not come. It says matter to be listed on December 5, 2020.
Adjourn motion mein
With my lord's kind permission, my lords. My lords, this is the 4th time we are mentioning this matter. On the last occasion, my lords have allowed this matter to be listed under urgent motion. But again, my lords, this has,
file might be
my
not
lords, I'm
there.
praying for an upgradation to be listed.
Whether the file is here?
Yes, my lords.
File
Item,
has come.
yes, my lords.
What is
Item
the urgency?
one, my lords, my bank account has been freezed without any prior notice to me. I have moved this writ petition prior vacation bench, mentioned, got liberty to place matter before vacation means matter could not be heard, my lords. We have again mentioned it. I'm already,
Tuesday रखो
my lords, I'm requesting my lords to have it after lunch because my lords, I have traveled all the way from Delhi only for this matter, my lords. This is
There
fourth.
is no preference for the Delhi or
My
America.
lords, I'm only,
All lawyers are
my lords, this
equal
is
before
fourth
this.
mentioning, my lords.
Maybe-
I'm hand to mouth, my lords. My
Maybe
business
the
has
court
been,
is not sitting idle, sir.
my lords,
You might have been mentioned the matter,
lords,
and you cannot say you came from the Delhi or came
my
from
lords,
the
I'm only requesting
America.
my urgency before my lords is that my lords,
Maybe
my account has been frozen.
all are the urgency. Kindly see all the advocates are mentioning.
My
And
lords,
how you are telling that you came from the Delhi and it has
my
to be
lords have
taken?
allowed me on the last occasion.
So all advocates will engage the Delhi advocates, the matter will be taken up.
My lords have, my lords was kind to adjust the matter in urgent motion, my
I am
lords.
telling I will take on Tuesday as an urgent motion. Today it is not possible.
Next Tuesday, my lords.
Yes, Tuesday as urgent
My lords,
motion.
what, my lords, again the matter might show up in the new motion, my lords. I'm only requesting my lords to have this in urgent motion, my lords. It's my very
Urgent motion Monday कर दीजिए.
obliged, my lords.
Petitioner before you to farmers. The lordship have announced their land to the respondent authority in exchange of employment. Till date, no employment has been provided. The petitioners and their families are suffering.
So who is the other side?
The lordship have served through me.
So what is the urgency?
The lordship, no employment has been provided for last 2 years.
Employment, how the employment can be provided?
Respondent authorities have implemented a scheme. According to
So
scheme,
you are coming under the scheme.
Yes, your lordship. We have given their land. Deed of conveyance has been executed. We have complied with all our obligations.
Wednesday रखो उसका urgent motion.
My lord, under compelling circumstances, I have mentioned this matter. This matter is running in my lord's list as item number 64 today. My lord, the urgency is that I am for upgradation. For urgency is this matter is my lord previously heard in the month of July and directed us to serve the notice to the other side. The matter is, my lord, we have complied all the formalities. We have complied the quotation amount which is to be required to grant an electric connection. But till date, my lord, the respondent WBACTCL authority is not giving us connection, my lord.
Have you issued notice?
Yes, my lord, we have issued notice, my lord.
My lord, may I have your lordship's kind leave?
Wednesday urgent motion.
My lord, may I have your lordship's kind leave, my lord, to mention, my lord, that there is an urgency, my lord. My shop has been blocked, my lord, by the PWD authorities, my lord. They had obstructed the egress and ingress of my shop, my lord. They're constructing, my lord. I have made a representative until date. Nothing has been considered, my lord.
Go to the civil court, get an injunction.
My lord, I have served them since, my lord. My lord, I have only requested them to, my lord, shift the, my lord, the obstruction, my lord, which they have erected, my lord, in front of my shop, my lord. Only this is the request I have made, my lord. They have not considered, my lord. Sitting tight of the representation, my lord.
It will be listed. Give the new motion.
My lord,
Lordship, may I leave to mention?
Considering the urgency of the
Yes,
matter.
Mr.
Obliged.
146. 146.
Matter is 79 and his wife is 78 weeks thereabouts, and they are in real trouble because the son is being What are you for that? 146.
146 ना Monday रख दो. Urgent motion नहीं करो.
My lord, on the last occasion,
Yes, yes.
my lord, on last Thursday, I have mentioned the matter. The petitioner is 79 years of age. My lord, his pension account has been blocked, though he is not neither the borrower or the guarantor of the loan amount. Loan amount has been obtained by the wife of the petitioner.
You're not a surety.
No, my lord, no. I have annexed the application also. My lord, I have mentioned, your lordship, considering the urgency, my lord, please to direct to fix the matter today under the heading, my lord, urgent motion. But it is not appearing.
Why it is not appeared? File is not there. No. Monday कर दें. Monday.
Lordship, may I be?
Monday. Yes.
Lordship,
Lordship,
may I leave to mention
Monday under the heading urgent motion.
Lordship, may I leave to mention item number, my lord, serial number 142. My lord, this matter relating to the petitioner has, my lord, the MBBS degree from the abroad. My lord, he has not, my lord, entered into the practice unless, my lord, he has completed the national test examination. My lord, he has made an application for the national test examination. My lord, thereafter, my lord, this application has not been, my lord, taken out for consideration for permit to participate in the examination.
When the examination is to be held?
Examination should be held, my lord, the end of this month. My lord, the matter has
When
been
you
running
file-
in the list, my
when
lord.
you
I think
file
of
the
one.
writ application.
My lord, writ application I prayed for, my lord, seeking permission to, my lord, appear.
When you file the writ
Writ
application.
application is filed, my lord, this month, my lord, last, my
Have you
first of
served the- have you served the notice?
I have just served the notice. Thereafter, I mentioned the matter in the last week.
Ah.
Your lordship, direction matter has been appearing. Item serial number 142 under the heading new motion.
142.
142.
একটা কাম করো Tuesday করে দিন urgent motion.
May I be permitted to mention one matter?
One by one. Yes.
Lordship, may I further with electricity matters, Lordship? This matter without electricity line has been disconnected, Lordship.
I mean, electricity matter I am taking every day. It will come on. Come on Wednesday. Urgent motion.
Lordship, may I be kind? Lordship, may I kindly be allowed?
Wednesday urgent motion kori.
Lordship, may I be kindly be allowed to mention a matter, my lord? My lord, your petitioner is a small tea biscuit mineral water shop. He was running and maintaining his family for last 25 years. His building, residential building, has a cross junction of two roads at the corner plot. My lord, there is a small patch of area that belongs to PWD. My lord, what happened? This is the shop he was running for 24 years. His two sons are diploma students. My lord, what happened? Private respondents, they are utterly influential by political and muscle power. They have maintained across my residential home structures to exploit commercial purposes. And now, my lord, a few centimeters only have been left for ingress and egress. My business has been stopped. My business was running from my veranda. I cannot open the window of my veranda, and they are absolutely, I am starving, my lord. My students, my son's education is at halt, my lord. My lord, urgency is, my lord, they are now stretching their occupation, the illegal occupation, bearing few centimeters only for my egress.
Have you approached the authorities?
Yes, my lord, repeated times, my lord. I have showed you, lordship. And I have served notice upon all the parties and the lawyers also, my lord.
Thursday, next Thursday.
Lordship, may I be
As urgent motion.
To mention,
Lordship,
may I be permitted? This matter relates to a school account has been freezed by the bank. The matter was taken up way back in the 2020. After that, the COVID came, the file was not traceable. The direction was there to some documents to be produced by the United Bank of India. After that, the matter is pending from there. The matter was once dismissed what they called, then it came, it was restored, and after that the matter came. So which the account has been, the school account has been freezed till date. No.
When the account was freezed?
In the year 2020 only.
Then 5 years has been passed. So
5 years has been passed, but the problem is that the amount which has been lying there, it cannot be withdrawn.
So where is your writ application? It is in the list or not?
No, it is not in the list.
Not in the list.
I have given the notice to other side.
Okay, let it be listed as motion.
Lordship, may I be permitted to mention, Lordship, I have served a notice. The matter involved is, Lordship, a 20-year-old son of the petitioner has suddenly died out of heart attack one day. Now, the petitioner number one, that is the wife, is within the age bracket for undergoing an IVF treatment, but the father is a little above age of the ceiling age of 55 years, Lordship. The respondent authorities have, like the medical institution, has refused to perform the IVF facilities on this couple, Lordship. This involves some urgency.
Whether the husband has given consent.
It is
Husband given consent for that.
Yes, Lordship. The wife is within the age limit, Lordship.
That's why wife is in age limit. Husband has given consent for the IVF test.
Yes, Lordship.
What is the reason they are not done?
Lordship, because the father is above the age limit, without an order of this honorable court, they cannot proceed, Lordship. Any day subject to your Lordship, because the issue is very sensitive and they are also aging. Any day subject to your Lordship.
Wednesday record.
Wednesday. I'm extremely obliged, Lordship.
You issue the notice.
I have issued. I will issue another additional.
Wednesday.
I'm extremely
obliged.
Deeply obliged.
I will. Yeah.
214, my lord, is appearing in the wrong heading, my lord. This is pertains to illegal mining that is carried out in Birbhum district, my lord. There are two direction was made for spot inspection, and that has been carried out, my lord. There is some urgency, and I'm praying if this matter can.
214. This is a hearing matter.
No, my lord. There no affidavit has not been exchanged as of yet, my lord. So when I was only praying, let it be appear under.
So if the affidavit is not filed, there is a direction. What will do?
Well, one.
You do one thing, you issue the notice to the other side, hearing matter will be listed on Thursday.
Well, this will come under urgent motion, my lord.
Let it come on that day. If it is required, the affidavit is required, then I will pass a protected order. Come on Thursday. Hearing matter will be listed on Thursday.
My lord, may I be permitted to mention
Yes,
a
yes,
matter?
you are telling. Hmm. एक काम करो, ये अभी जो दिया था ना 152 अब इससे पहले एक था IVF मैटर था, कब रखा? थर्सडे की वेडनेसडे। अभी वो लेडी मेंशन करी थी ना, थर्सडे कर दो अर्जेंट मोशन 152 थर्सडे वेडनेसडे।
May I be permitted to mention a matter?
वेडनेसडे which with regard to that forest, the forest matter, SEBI matter, when yes, so which for the other side? एक वेडनेसडे अर्जेंट मोशन में कर दो, अर्जेंट मोशन।
The Clinical Establishment Commission, by passing an order, directed the Director of Health Services to suspend the license of Genesis Hospital. So, my lord, the order was passed on 10th November. By now, the order has been communicated to the director. The director, at any point of time, my lord, may issue the notice of suspension. My lord, it's extremely urgent.
So when the notice will be issued, come challenging the notice now. Where is the cause of action now?
My lord, that order I have challenged, my lord.
Which order?
The order of the commission, my lord. That order is illegal.
When you are challenged, which year the order was issued?
An order was issued in 10th November 2025. Just now. Immediately, I have challenged it, because the whole hospital can be stopped, There are so many patients, The patient will be the worst sufferer, So, kindly take up the matter as urgent motion,
Tuesday, urgent motion.
May I be permitted to
Your lordship, may I be
mention
permitted
this?
to mention a matter?
Mention this matter. Sir, this one is recalling an order passed by Honorable Justice Amrita Sinha. So,
It's by default.
yes.
Yes.
Your lordship, my matter is listed as item number
Application.
205 in today's cause list.
20?
However, 205.
Ah.
However, this writ petition is under the SURFACE Act, and my lord doesn't have the determination.
205?
Yes, my lordship.
Who is for the other side? You are sure?
Yes, my lordship.
Your Lordship, I'm appearing for the petitioner in this matter. What my learned friend is submitting is correct. This is a SURFACE application.
I am releasing.
Grateful.
204
I'm
though?
grateful.
205.
205. Record an order. 205.
205, Your Lordship.
Senate Council for the respective parties submit that the matter is connected with the SURFACE Act. Thus, this court is not having determination. Full stop. WPA 4720/2025 is released from the list of this court with the liberty to the parties to mention before the appropriate court having determination.
Your Lordship, may I have one kind indulgence? I'm suffering from fever. Can I please give the appearance online?
Yes,
Your Lordship, if Lordship permits. Grateful, Your Lordship.
Grateful, Lordship.
Yes, what you are telling?
Lord, this is a application for vacating an interim order. Lord, I suffered an interim order from the coordinate bench.
When you filed an application for vacating?
Lord, last week.
Last week? Have you served?
Yes, Lord.
Yes, so?
Lord, I have also served the notice upon the private upon the petition. I am the respondent here, Lord.
When the matter will be listed?
Lord,
what is the returnable date?
Lord, it was supposed to be listed today.
Today, it is
Lord,
not
the main file is also not here. I had given the mention. Lord, I had accepted the mentioning for inclusion, but
that's why several files are not here. What can be done?
Lord, but I am suffering. I do not have any electricity for the last 2 weeks, my lord.
Okay, you do one thing. Take the mess and Wednesday rakh lo, urgent motion.
Restoration, my lord. I have got kindly, my lord. It's an electricity matter, my lord. The coordinate bench of this honorable court had passed an order of 17th September 2025, my lord, directing that reconnection be issued upon me making an ad hoc payment of about 20 lakhs, my lord, without prejudice to my rights and contents. I made the payment, reconnection not done. My lord, I have purchased the company through the mechanism of the insolvency bankruptcy code. I am the resolution purchaser. My lord, if reconnection is not given to me, the resolution plan will fail. I will not.
So have you paid the 20 lakhs?
Paid the 20.
But they are not giving.
They are
But
saying, my lord, it has to be a fresh connection. So new formalities have to be complied with. That was not your lordship's direction.
Monday, urgent motion.
May I permitted to mention on application for restoration, my lord?
My lord, may be permitted to mention matters, my lord, for inclusion. My lord, this is regarding illegal detention of Rohingyas, my lord. Both the petitioners were completed their sentence way back in 2017. My lord. How it is illegal? My lord, they when their sentence has been over, sentence period is over.
2017, my lord.
2017.
They are still in the detention, my lord.
I think the matter was mentioned earlier.
Yes, my lord.
Yeah,
but it is not appeared
not
in the
listed.
list, my lord.
Lordship, may I permit it?
As motion में रखो. Motion.
Lordship, may I permit it?
Matter for which leave has been granted last week, because scheduled to be listed today, will have the matter pertains to one death certificate which is being issued to a living person. For that reason, I am not able to participate in my ongoing SIR process, and my Aadhaar, voter card, and all is needed and invalid.
Might be file is not here. If the file will come automatically, it will list. और ले लो. Wednesday को रखो इसको. Urgent motion.
Lordship, may I permitted to mention one matter? It was the writ in the year 2021. It was taken up for hearing Honorable Justice Saroti Chatterjee, and the respondent sought for adjournment, and subsequently that matter has not been listed. Lordship, the matter relating to my predecessor in interest intimated to the income tax office for some proposal, and subsequently the income tax officer intimated to provide reward, and the matter related reward for getting information from my client. That is why the writ petition, but reward not yet given, and the matter is pending since 2021, Lordship.
2021.
2020.
So,
Lordship,
what is the urgency? It is
Lordship,
not in the list.
my client not.
It is not in the
Not
list.
in.
Okay, motion में रखो.
Lordship,
My lord.
may I permit
Dib.
withdraw kindly put this matter to the list.
Which matter? Where is the list?
Your Lordship, I am submitted a slip, but I'm
My lord, may I be
For
permitted?
withdrawal. What is the case title? Case number and cost title. You give the fresh to my court officer in course of the day. It will be decided to be mentioned.
My lord, may I be permitted to mention two matters, my lord? Wherein, my lord, after completion of all formalities, the name of the petitioner has been recommended for the selection process to act as a notary. And my lord, thereafter, my lord, the petitioner has been deposited the prescribed fees for issuance of certificate of practice in the year 2024, my lord. But my lord, till date, my lord, the certificate of practice has not been issued.
So what do you want? What is the urgency?
My lord, for this reason, my lord, I could not, my lord, start my.
Okay, let it come as a. It is not in the list.
No, my lord.
Okay, motion में कर दो.
Motion, my lord, Monday.
Monday, Tuesday, you see the list. The file will come automatically. It will be.
My lord, the difficulty is that, my lord, the date for my lord effecting service upon the government pleader has expired, my lord. So.
Okay, let you see the list. If it is in the motion, if it is listed, then you mention and we'll see to that.
My lord, may I be permitted to mention a matter, my lord, only for the inclusion, my lord. Since
For what?
Because the
Okay, give inclusion. Huh? Why upgradation? Without electricity. Only look. Urgent motion में रख दो. Next Friday.
No, my lord, may I be permitted to mention a matter, my lord, pertains to my lord restoration of electricity supply, lordship.
Not allowed. Original side advocates will not be allowed in the appellate side.
My lord, the difficulties, your lordship, this pertains to my business, your lordship. I'm suffering since the month of September, my lord. No matter what, my lord, the landlord is somehow, my lord, is disturbing the peaceful possession of the petitioner.
So, my lord, what you prayed for?
Well, prayed for, my lord, restoration of the supply, electricity supply, your lordship.
So, Your Lordship, kindly, matter was supposed to appear last week, Your Lordship, but it has not appeared. Your Lordship, kindly include the matter.
Thursday and urgent motion में करो.
Yes, deeply obliged.
My lord, I practice in outside court. I stay in Kolkata, Durgapur for
You're not practicing inside the room. You're outside.
Delhi High Court.
Delhi.
Delhi High Court. This case is mine. My mother stays in a rented accommodation. We are about to leave because we are already started construction in our parental property. In between, in the beginning of the rented accommodation, the owner said that आप unlimited time यहाँ रह सकते हो because it is not in his possession for last 6 years. After we shifted, after 4 months, he started disturbing on certain part of like electricity. And then जब भी मेरा
What is your prayer?
My prayer is that I want
क्या चाहते क्या हैं?
peaceful allocation in that room till our construction completed.
Against whom?
Huh?
किसके against में?
Against the landlord. And मैंने इसलिए क्योंकि जब इलेक्ट्रिसिटी रिस्टोरेशन की जरूरत पड़ी ना मुझे हर बार थाना में दिल्ली से बैठ के because my mother cannot work.
क्या प्रेयर करें?
प्रेयर मैंने कहा है कि मेरा जब तक घर बन जाए जैसे आपने प्रीवियसली बोला था कि आप अनलिमिटेड टाइम वी आर नॉट सीकिंग फॉर अनलिमिटेड टाइम हमें 1 साल ही रहने दीजिए हमें वही और ही इज नॉट गोइंग फॉर एनी काइंड ऑफ एग्रीमेंट आल्सो
The writ court can do that private dispute.
I have since several times I have to call police for peaceful location police and
Order of this court. There's an order of this
yeah,
court.
this is and West Bengal
What you want now? It is to be listed.
it is to be listed मैम सर अगर कल हो जाए तो मैं
कल
कल
तो नहीं होगा.
मंडे हो जाए
Monday रख.
ठीक है मैम थैंक यू माय लॉर्ड
Monday urgent motion.
much obliged my lord
Urgent motion.
My lord, may I be to permit to mention one matter for inclusion in the list under new motion, group 9.
Yes, number mentioned.
New motion ना वो वाला. वो नहीं है urgent motion Monday कर दो. मैडम को new motion.
Lord, I mention on behalf of the respondent in the matter, my lord, the petitioner before your lordship has filed the writ petition challenging an execution proceeding pending before the district forum, district consumer forum. And taking times before that, since the writ petition is pending before.
What is the writ petition for?
Lord, this is not my writ petition.
Yes, what they have read in the writ petition?
They have challenged the execution proceeding by way of writ.
Of the consumers forum?
Consumer forum. And
Which
the
was
next date is 5th, or they are taking time before the.
When is the next date is before the
5th December.
5th December.
Any day prior to that.
Have you served the notice?
Yes, my lord. Through mail.
Thursday 27 को urgent motion में रखो. 27 urgent motion. Issue notice to the other side informing the date. Yes, call the list.
Your Lordship, I appear on behalf of respondent numbers 1 and 2. My lord, I am appearing on behalf of the petitioner.
Yes. According to the so-called notice dated 28 February 2024 and the impugned order dated 7th August 20 are set aside and quashed, the bank is given liberty to proceed against the petitioner in accordance with law from the stage of issuance of the so-called notice. And the document, if any, relied by the bank. WP is disposed of. Next.
And for petition, written instruction of the client not to proceed.
Guys. Non-prosecution. The matter is listed as to be mentioned on the prayer made by the counsel for the petition. The petition has handed over the communication dated 16 September 2025, issued by the petitioner to the advocate for the petitioner, wherein the petitioner has informed the non-advocate that the petitioner is not intending to proceed with the matter. In view of the communication dated 16 September 2025, the learned counsel for the petitioner prayed for withdrawal of the writ application. Consider the submission made by the counsel for the petitioner, peruse the communication, WPA 7445 of 2025, is dismissed as withdrawn. Interim order, if any, stand vacated. Communication dated 16 September 2025, be kept in the record. Yes.
I beg to the
My lord, Mr. Sanjeev Kumar Mukhopadhyay is appearing for the respondent number 2 applicant. My lord, I'm praying for short passover.
One filed by myself, my lord, as a petitioner, and another for the private respondent.
What is the respondent file an application can praying for recalling of the order?
Recalling the order, my lord, as per leave granted by Honorable Justice Kaushik Chandra, my lord.
So who has filed?
That is the private respondent.
Can 1.
Can 1. Can 1 is my application, my lord, for modification.
Can 3 is of your application.
Yes.
And can 2 is disposed of.
Can 3 disposed of?
Can 2 is disposed of, my
Can
lord,
2 disposed of.
on 23rd June 2025.
Yes. So, yeah.
My lord.
Ready?
Ready, my lord.
My lord, I'm praying for short passover. My lord, he is in court number 3. My lord, kindly pass over the matter for 15 minutes.
Pass over.
Then, my lord, kindly taken up is not today, my lord.
Okay, not today. Come tomorrow.
Right.
Not today. Next.
I'm grateful.
Ashok, this is my application. Ashok, this is my affidavit of service. This is my affidavit of service. And this is application for restoration. The affidavit of service. Filed within time.
Yes. Yes. Why? When? What? When?
And Lordship, regarding the main matter, Lordship.
Where is the date? Where is the order?
Lordship, order is annexed here. That is on 19th August 2025.
You mentioned the matter for withdrawal of the petition.
Lordship, yes.
Read.
Lordship.
Then you are not appeared. So now what you want?
Lordship, withdraw. The letter is
It's already dismissed for default.
But Lordship, this is dismissed for default. Lordship, withdrawal with liberty to file a fresh, Lordship.
I pay for the respondent in this matter, my lord.
Lordship, unless we get that order for filing a fresh, Lordship, I can't file.
Dismissed for default, you are not been arrested
Still,
for
Lordship,
filing a fresh.
But still, Lordship, that is why I filed restoration and let it be restored. And
I have not been served with the restoration petition.
Lordship, affidavit of services with there.
Then I'll check with my client, my lord, if it is so.
Yes. Oh, yes, service.
No, there is no service. Where is the delivery report?
Lordship, 5B item delivered 22nd September.
5A item delivered.
And 6A, that is also item delivered. And 7A also item delivered.
It's within time.
Yeah. 7 days. In fact, I am going to withdraw the application.
So
I'm the original writ application.
If it is within time, let it be restored, my lord. If the petition is filed within time, my lord, it can be restored. Yes. Because otherwise, it would again be.
The petitioner has filed the present application being can 1 of 2025. Recalling of the order dated 19th of August 2025, wherein this court has dismissed the writ application for default. Full stop. Counsel for the petition submit that though on the prayer made by the counsel for the petition, the matter was listed on 19th of August 2025 as to be mentioned. But when the matter is called, the learned counsel for the petitioner due to some personal difficulty could not appear before this. Accordingly, the matter is dismissed. Consider the submission made by the counsel for the petitioner. This court finds that the petition has shown sufficient cause for non-appearance of the petitioner on 19th of August 2025 when the matter is called. Accordingly, order dated 19th August 2025 is recalled. WPA number 15296 of 2025 is restored in its original file. Can number transaction is disposed of. Affidavit service be kept with the record.
Lordship, I'm praying for just withdrawal with liberty to file a fresh, Lordship.
Let it come tomorrow. Let the matter appear. Day after tomorrow has to be met. Come day after tomorrow.
Instruction হবে.
Yes, next.
I'm for the petitioner, Lordship.
I appear on behalf of the CSC in this matter.
Lordship, on the last occasion, the matter was moved before His Lordship Justice Kaushik Chanda. His Lordship directed me to add the landlord of the petitioner as a party in this writ petition and to serve a copy upon him, Lordship. Lordship, I have served, Lordship, what has happened. Due to track report was not available, but he has received. Now, Lordship.
Private respondent.
The added respondent, Lordship.
Who is the added respondent? There is no added.
Landlord. Lordship.
Where you added?
Lordship, that has not been carried out, Lordship.
No, then you have
Today
to
I
do
will,
that.
Lordship. Today I will carry out. Lordship, but I have served, Lordship. If Lordship desires, Lordship, I will serve again, Lordship. In the meantime,
I am fixing a date.
Lordship.
You go carry out the order.
Lordship.
And
May I file the affidavit of service, Lordship?
this complete service.
Service has been completed, but the track report has.
That's why. Come,
Lordship.
By an order dated 17 July 2025, this court has allowed the petitioner to add the landlord as respondent number 3. Counsel for the petition submitted, though the petitioner has sent the notice to the landlord, but inadvertently the name and address of the landlord has not been incorporated in the cause title of the present application, and prayed for leave to add the landlord as the respondent number 3 in the present date application in course of that.
Lordship, in course of.
In view of the submission, the petitioner granted leave to add the landlord as respondent number 3 in the present date application in course of the day, and to inform the next date of hearing to the landlord by sending a notice, and to file affidavit of service on the next date fix. List the matter on 2nd. Where is the private respondent?
Howrah, Lordship, it will take 3
Howrah.
days.
On 28th October 2025 under the same heading.
Lordship.
I'm
Grateful,
grateful.
Lordship.
My lord.
May it please the Lordship.
My lord, on the last occasion,
I'm
sought
appearing
for
for
time.
Reserve Bank of India, banking. only.
Instructions, my lord. My lord, kindly cease. My learned friend is here to say on behalf of the Reserve Bank, but I am pointing out
Who is for the petitioner?
My lord, I'm
My
the
lord.
petitioner, my lord. My lord, on the last occasion, my lord, the affidavit of service wasn't taken on record, my lord.
My lord, kindly cease page number 50, my lord. It was, my lord, it is the order of the ombudsman, my lord, Reserve Bank ombudsman. Paragraph 2, my lord. It is observed that cyber crime complaint is reported against the account of the customer from Bangalore City West CEN Crime PS. Hence, hold is suitably placed in the account. Hold cannot be removed until and unless order for removal is received from the court or the law enforcement agencies. Till date, no order is received for removal of the imposed hold. Complaint has been suitably addressed regarding the hold placed in his account by RE. RE means regulated entity, that is this bank. Therefore, as RE has acted based upon notice from law enforcement agencies, this complaint is treated as not maintainable and closed under clause such and such.
You are appearing for?
I'm from the bank, my lord. My lord, after paragraph 3, my lord, kindly sees no complaint for deficiency in service shall lie under the scheme in matters involving a dispute in which action is initiated by a regulated entity in compliance with the orders of a statutory or law enforcing authority. So we have acted in accordance with the directions that we received from the law enforcement agency, and this has been approved by the Reserve Bank of India also, my lord. And my lord, very recently, my lord, that's why I sought for time on last occasion, because if the petitioner is having some good intention, after all, he is a customer of the bank. We do not have any adversarial relationship with me, with the petitioner. So if this can be sorted out. So recently a letter has been issued to the petitioner. I have handed over a copy to this letter to my learned friend also. We have asked him to visit the bank. In the meantime, also letters were served, but that is in dispute. My learned friend was saying that no, he did not receive, his client did not receive any such letter. But this time, this letter was issued. And again, my learned friend was saying that it was not sent to the proper address. My lord, I have handed over a copy to my learned friend also.
This is not a proper copy, it's an undated copy.
No, no, dateটা হচ্ছে উপরে আমার কেটে গেছে।
So it's not a
উপরে
proper
কেটে
copy,
গেছে।
sir.
It is for your information. At least you can act on the basis of this.
No, but if it's not dated, how will I?
See, it has been sent. কেটে গেছে, এটা 16/15/11 দেওয়া হয়েছে।
It's going back as insufficient address. So
কোর্টের অর্ডার থাকবে যে আমি I have handed over to you.
Yes.
So you may visit the bank for resolving the issue, my lord. As I said, my lord, we do not have any adversarial relationship with him. After all, he is a customer of the bank.
Yes, ma'am.
My lord, so far as Reserve Bank is concerned, they had lodged 2 complaints with Reserve Bank. First time when they had lodged, we had indicated that the present status is such that under the banking ombudsman scheme, only Reserve Bank banking ombudsman can take action against the concerned regulated entity, provided there is service deficiency. But we found that there was a request for hold given by the cybercrime department, on the basis of which bank had acted. So it was not a negligent act on the part of the concerned banker, and therefore we had closed the complaint saying that unless and until there is an order of the honorable court in whichever forum, no step can be taken so far as bank is concerned, given the circumstances that there is an existing dispute. Also, as I find that they had lodged complaints with the police also, and a separate case is also ongoing with regard to that. But I am not privy to that, apart from what has been culled out from the pleadings contained in the petition, writ petition. They lodged a second complaint again on the self-sim cause of action, which again we were bound to close following the norm under the banking ombudsman scheme, because the already existing complaint was resolved, and on the self-sim issue no further complaint would be lodged. And what I find from the prayers which have been sought for, they are not seeking any direct reliefs against banking ombudsman. So the main answering respondent here is the concerned bank, and which according to banking ombudsman have been said that there has been no service deficiency on the part of the concerned banker. That's all from the end of the banking ombudsman.
my lord, on behalf of the petitioner, this is what I would submit. My learned colleague had perused page number 50. My lord, I would beseech your lordship to kindly comes to page number 46, my lord. My lord has it? 46, my lord. My lord, in the last line, the penultimate line, my lord, your lordship will see that the lien amount is 6,700. My lord, that is actually the bone of contention. And now, my lord, if your lordship sees on the top, available balance is 2,63,851 rupees and 29 paisa, my lord. That was at that point of time. My lord, in the month of April 2023, an amount of 6,700 and unsolicited credit came into my account. I am an assistant professor of University of Engineering and Management, my lord. I've been teaching in the same institution for a very long time. This is actually my salary account. My salary gets deposited over there. Now, when that unsolicited credit came into my account, I do not till now, my lord, I do not even know who had deposited that amount.
Which amount?
This 6,700. This was the bone of contention, my lord.
So which account it has come?
It has come to the account in question, my lord.
No, which account? It is cash deposit?
No,
or it has come transfer from the
transfer from some other account, my
which account it has been transferred?
My lord, that we are yet to know, my lord. My lord, kindly appreciate, my lord, this is not the only thing, my lord. Within a period, he earns 13 lakh. His net salary for annual salary is 13,50,000 odd. And for 3 months,
annual salary is
13,50,000.
Correct.
His annual salary. My lord, for 3 months, continuous 3 months, 20 lakh amount, more than 20 lakh amount was deposited and credited, deposited and debited from his account.
Correct.
That is why the suspicion was raised and complaint was lodged. And we have been.
Who has closed? You himself.
No, on the instructions of the that which has my lord has seen.
Which agency has given instruction to?
The National Cybercrime Portal. From the National Cybercrime Portal, we have received this.
But the bank itself,
Whether
there's-
the,
we have called him.
whether the National Cybercrime has submitted any report.
No report has not been submitted, but direction was issued, my lord. That's why we have called him to explain the
I was called
suspicion.
multiple
Have you been
times.
called by the cybercrime?
No, never. Not even a whisper was issued, no message, no notice, nothing was issued to me. I, on my own volition, my lord, I sent them a legal notice, my lord. It is also there in the writ application. I've annexed it. They haven't bothered to
Have
respond.
you filed the report?
They haven't
the
even
report?
come before your lordship's court.
Have you filed
We
the
have
report?
previously also we have intimated him, my lord.
No, if you're telling that on the basis of the cyber, let he add the cyber
Yes, yes.
personal.
They're added, my lord. I have
Better.
added them as a party for more than 2 years, my lord.
My lord, from my personal experience in matters like these, I have noticed that at all times it is for the honorable court to pass order, and thereafter the account is been released or made normal. This hold is removed.
So
But at no point in time the cybercrime cell is involved in the writ petition. Neither, and always it is the case of the petitioner that they don't receive any direct communication from the concerned cyber cell authority.
Yes.
Just because of this authority only, constantly similar problems are being faced in multiple matters. So if in matters like these, cybercrime authority is actually made a party, they could actually come and indicate that why
Bangalore
such
CN
a
is a party.
made.
Today the court will pass an order, tomorrow it is found that something else.
Might
What
be.
is the
My lord,
responsibility?
my innocuous prayer is, my lord,
That's correct.
let
That-
6,700 be frozen, my lord.
He is not telling the 6,400, he is telling that the 20 lakh.
This is something he has come up
But
new, my
that's why
lord.
it is coming.
I have the
It
statement
is
of
not
account.
there in the email.
That's why now, which agency, what is the
I may,
where from you got the
Bangalore CN, my lord.
Yes. This name is
that is the address?
West CN Crime PS.
My lord, that would be,
Bangalore City West CEN
my lord,
crime.
respondent number 4, my lord.
Westian crimes.
Respondent number 4.
You have made the party?
Yes, my lord. I have also served them legal notices. Even
They
this
have to
mentioning, my
come.
lord, which your lordship allowed, I sent them the notices. They haven't bothered to come up before your lordship.
Where is that?
Yes, respondent number 4.
Respondent number 4, my lord.
Inspector
number
General
4,
was-
I have made the Director General a party as well, my lord.
No, kindly see the, have you got this letter? Give the copy. This is Additional Commissioner of Police, the in charge. I don't think that will be in charge. That's why nobody is responding for that. Designation is Additional Commissioner of Police, ACP, Western Crime PS, email so you made him Additional Commissioner of Police.
Additional Commissioner of Police.
Okay.
Not the in charge. That's why nobody will be in charge over there. ACP, it is the not the rank of this.
But my lord, if the ACP is in charge,
Correct.
wouldn't
It is the in charge because the anti-corruption not below the rank of the DISP or inspector. Some state has been notified as inspector, some as per the general law, not below the rank of the DISP in the anti-corruption matters.
My lord, I actually followed their instructions, their emails, everything
Okay,
is
you
annexed
do
in my
one
writ
thing. I am
application,
giving
my lord.
liberty to make the additional commission this party and send the notice. How soon you will send? The email address is also there, mobile number is
lord.
also there, email is also there.
But my lord, I'm not against, my prayer is not with them, my lord.
No, let the court why they have issued. If they have issued, whether what is the inquiry? If it is no inquiry, then the court will pass a appropriate order for defreeze your account and you can continue with the account.
Yes,
let some report to come in the court.
My lord, that may come. My lord, it would take some time.
Not,
My lord,
I am fixing next week. You saw the notice. If they will not come, but you But you ensured that the notice should be reached to the additional commissioner of police.
Okay.
Subject to
My lord, I-
first from
I
your
have sent them
lordship,
through email as well.
if it is by way of an order of court, then I'm sure they will be bound to attend. Yes.
My lord,
Pass an order, but
Yes.
my lord, they have been informed through email as well. Through email,
Order
through
of court
mail.
bole ওরা
I have
আসেনি।
sent them. It is there. It's annexed in my
As
writ
an
application.
order, inform I am fixing next Tuesday as under urgent mode.
My lord, I shall do that in the meantime.
The petitioner has filed the present writ application, praying for a direction upon the
পদ্মাবতী আছে
branch manager, State Bank of India, Molargate branch, for defreezing the petitioner's saving account number. This number 00000602440552352 maintained in the said bank. In the said bank, save and accept to the extent of rupees 6,710 being the disputed account. Learned Counsel appearing for the respondent number 8. Submitted as per the instructions received from the agency, the account of the petitioner has been
encompassing all possible points.
Has been freezed. Learned Counsel for the respondent number 8 for the bank has also handed over a communication dated. What is the date of this communication?
My lord, 15th, my lord, 15th of November.
My lord, I'm sorry to interrupt your lordship, my lord. My lord, regarding this communication, I have a humble submission.
I am not
coming back as returned insufficient address. This is
Okay.
the communication of the bank.
Letter dated 15 November 2025, wherein the bank has called the petitioner to explain the matter so as to enable the bank to resolve the issue. Counsel for the petitioner has denied the letter and submitted that the letter has not been received by you. Full stop. This could find that it is the specific case of the bank that the bank has freezed the account on the instruction of the agency, the police. The petitioner has made the inspector in charge, West Sen Crime Police Station, having the office at west of Cord Road, 3rd stage, phone, Bhavaneshwar Nagar, Bengaluru, Karnataka. But it is found that the designated officer is the additional commissioner of police, within bracket ACP, Sen Crime PS, having emails and mobile numbers so and so. Accordingly, the petition full stop. This could find that before passing any order, an opportunity is to be given to the additional commissioner of police ACP to explain before this court why the account of the petitioner has been freezed. Why a direction has been given to the bank for freezing of the account of the petitioner. Full stop. The petition is directed to add the additional commissioner of police as respondent number 9.
10, your lordship.
Respondent number 10. And to serve the copy of the writ application along with the documents to the respondent number 9 by speed post as well as email. Full stop. The added respondent, that is the additional commissioner of police, is directed to file the report before this court on the next date fixed, explaining what are the circumstances, under which circumstances the additional commissioner of police has directed the bank to freeze the account, and as to why till date no report has been submitted whether the account of the petitioner is to be defreezed or not. Let the said report be filed by the additional commissioner of police within a week from the date of receipt of the notice, list the matter on 28th of November 2025 under the same heading.
Grateful to Lordship.
Grateful.
Next.
May it please the Lordship. I am I appear on behalf of CSC. in this matter. My Lord, petitioner is a domestic electric connection holder. He paid all the bill in time. We have annexed. All of a sudden, they disconnected the electric line.
Reconnect the supply of your petitioner.
My Lord, kindly see earlier we moved this petition before the my Lord Justice Kaushik Chandra. And there is the order. My Lord, kindly see page 17, annexure P3.
17.
17?
Yes.
17 to photograph.
18.
18.
Signing officer directed to fix the date for hearing so and so so and so. Now for the notice shall be given. Needless to mention, there shall be liberty to raise all relevant objections. The assisting officer shall pass the final order. Yes, where is the final order?
My Lord, against that, that is the final order, is the last annexure.
My final order starts from.
Yes.
My Lord, on the basis of that order, we made a representation that is annexure.
Correct. Now from where is the final order?
Final order.
Page 22.
Yes. Done in terms of the Provisional Electricity Act as amended up to the date. Regulations framed thereunder by the Honorable Welcome. Accordingly, I dispose of the matter, passing an order for final assessment of 2,81,000. 2,81,579.
My Lord, in my representation 19, we have stated that is first, second, third, fourth, last paragraph
In your
that
presentation.
I use 5 LED lights, 5 fans, 1 TV, 1 fridge, 1 pump, and 1 geyser and 1 AC. Well, it is really pump set or AC or other apparatus. This is not run for 24 hours in a domestic house. My Lord, similar circumstances, my Lord Justice Kaushik Chandra. 8 দিন পাস
এইটা প্লাস 8 এটাও দিন
Yeah.
the matter.
আমাকে একটা কপি দাও আনরিপোর্টেড অর্ডার।
কোনটা খাবে তার তো খাও।
না আপনি 3টে কপি দিলেন আমাকে তো কপি দেবেন।
যা দিয়েছে
কি 3টে কপি দিলে ভাই? না সম্ভব না, আপনি প্রেস করছেন। where is my copy?
Where is his copy?
আচ্ছা আরে
জজ খেলে
আরে তুমি দেখো
জজ খেলে তুমি
Yes.
So I
What
have
do you want to show here?
well, can you see the calculation sheet, reconnection order? I have state in the order. So I am paying at this stage. Let the line be restored upon 50%, and the
appellate authority will
consider the appeal.
But if it is there in the rules, my lord, I will not utter a single word.
This was not the order, no order.
If my learned friend has finished, I will
Have you
start.
filed the appeal against this order?
No.
Then
We have final order, they have passed under law. We are entitled to file an appeal. So upon restoration, I'll file, no problem.
Without electricity.
Because I am without electricity.
Hmm.
That is my prayer.
So you could have been first to file an appeal.
I'll file.
You do one thing. I am keeping the matter after 2 weeks. You file an appeal,
What?
make a prayer before the
No,
authority.
they are not. They are not.
Please hear the court first, then you made your mind. Before the court made up the mind, you are making the mind. You preferred an appeal before the authority and also prayed for the authority for restoration for subject of whatever it is for interim.
That
The
order.
authority will not come before this.
That order.
Authority pass an order.
May I submit my note, subject to what has fallen from your lordship? But on the last occasion when this matter came up, that was on 22nd of September 2025.
Correct.
The Honorable Court was pleased to direct both the parties to file a load breakup. Manor, I don't know whether they have filed it or not.
Acha, acha.
This is my load breakup, Manor. Kindly, Manor, may I submit?
ওই কপিটাও দিয়ে দাও, ওটা আমাদেরই কপি। ওই যে হ্যাঁ ওইটা।
এটা আমাকে তুমি দিয়েছিলে সেদিন।
তাহলে
Kindly, may I finish? Then I'll hand it over.
5 LDT, 5 ceiling fence.
Yes, Manor, why this has come up? Manor, minor will kindly see the writ petition which is there before your lordship. Kindly peruse paragraph 12. On the left hand side,
Paragraph 12.
page 12. I'm sorry, Manor. Page 12. That is the calculation sheet for order of provisional assessment.
Page 12.
Yes, Manor. It will be like this, Manor, if I'm not wrong.
Yes. 13, page 13.
That is annexure B, I think. Page 13, 12. Malad, on the left hand side, there is a box which says that contract load is 0.27 kilowatt. The last 2 points, Malad, on the left hand side are here, Malad.
That is not legible.
May I hand over my copy to your lordship?
Well, the top,
The contract load is 0.27 and the
inspected load.
Yes, it's contract load.
3.50.
Contract load is 0.27 kilowatt
Yes.
and inspected load is 3.5.
More than 5 times.
Then I think, Malad, he shall argue on my behalf.
Yes.
Manad, this is Manad, why this inspected load has arisen? Because there is pilferage.
Yes.
When there is pilferage, Manad will kindly peruse section 126 of the Electricity Act.
No, but what you're telling, because meter number so contact load is 0.27.
Yes, that is the contract load.
Acha. Okay.
Manad will kindly peruse section 126.
এই electricity act আছে কি?
যশোর একটা বই চাইছে দেখো না অল ইলেকট্রিসিটি
মাঙ্গায় নি
এটাই দিয়ে দাও আমার মার্ক করা এটাই what has fallen from your lordship in respect of the appeal, I will bow down, but it
section
is section 126. But it is my duty to point out the law.
No problem.
When I kindly see, my lord, 126 clause 5. My learned senior friend by arguing has pointed out that it cannot run for 24 hours. May I show what is the law? If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to the period to 12 months immediately preceding the date of inspection. So, my lord, in terms of law, 365 days into 24, we cannot move it. We have to calculate that. That is what we have calculated. Now, my lord, will come to section 127. The appeal, my lord. Well, they were well aware about the final order of assessment because this was passed in front of them subsequent to an order passed by this honorable court. When I kindly see 127(1). Any person aggrieved by a final order
30 days.
30 days. Well, that time has gone.
Writ petition is pending.
When a writ petition is pending, but there is no order which is obstructing them to file an appeal.
Yes.
Delhi Regulatory Commission is 8 hours.
My lord, in the Delhi regulation, we have.
And my lord will kindly, sorry, my lord will kindly come to regulation 55, clause 6.3.
Daily regulation?
Regulation 55 clause 6.3. May I hand over, my lord?
Yeah, regulation था कहाँ गया?
এটা ওয়েস্ট বেঙ্গল রেগুলেশন
হ্যাঁ তো ওয়েস্ট বেঙ্গলে আছে, ওয়েস্ট বেঙ্গল রেগুলেশন দেখাবো না?
পিরিয়ডই নাও
একটা regulation আছে না, उस दिन शुरू दिन में जेरॉक्स करके दिया था,
Regulation
क्या
আছে,
वापस
judge
कर दिया?
লিখিত।
দেওয়া আছে।
अरे फर्स्ट दिन में जेरॉक्स करके दिया था।
No, may I hand over a copy of mine? 6.3 states that the meter which has been disconnected in respect of pilferage under 126 can only be restored when the final assessed amount is paid. So, my lord, according to the regulation also, they have to pay 100%. This is West Bengal regulation. They have to pay 100%. 6.3, my lord, kindly excuse me, I have marked here.
Given one.
হয়নি স্যার, আমার হয়নি।
Supply of electricity, the bandobast supply must be dispatched
আমারে বলতে দিচ্ছিস না।
See at the earliest and positively within 40 days. From the time of payment of the assessment amount. What is the regulation? What regulation it called?
Regulation 55 clause 6.3.
This what is the-
In that regulation only, the calculation sheet which I have shown, that manner will find from clause 5.
Yes.
So, my lord, the calculation which has been made by the licensee company, they cannot divert from this regulation. And it has been made, these are all computer fed. My lord, we cannot do anything. My lord, if he wants to file an appeal, my lord, now, my lord, the appeal is time, but this is my humble submission.
My lord,
Because he has got full knowledge when the order is passed.
Yes.
My lord, several order passed by this honorable court in order to file appeal. Section 5 allows, so that can be filed.
No, there is no section
If-
5 in this matter.
If my lord did it, I will file appeal within 7 days.
No,
That
Lordship
order
was keeping the matter pending.
Then the matter will be pending. Thereafter, if my lord desires, the matter will be heard. Now, what I am saying, in order to sort the several order, I have given my lord, where 50% is to
WBSC
pay,
has been directed to
paid
frame
and the line
guidelines.
be restored. Not only the calculation, they are calculating.
If you are giving an undertaking, you will pay the total amount within certain period, and then I will pass an order to pay 50% now, and you will.
I will.
If you give an undertaking before this court that you will pay the total amount, then the court will say yes, 50% pay now and 50%
Total amount which the
whatever.
appellate
No,
authority
that
will
can. If
find.
you are telling that you're taking the both records, then sorry, this court.
No,
is
no,
not-
no, no.
Total amount which the appellate authority will find. to-
My lord, appellate will decide the how much amount I have to pay. That amount we are ready to pay.
No, my learned
But
friend
as
cannot
we-
have the cake and eat it too much.
Now
He
he
is
is-
availing two remedy in one go.
No.
And my lord, there are hundreds of
I am-
decision, my lord, which is
I am-
stating
I
that
am
100% has to
I
be
am
paid.
disposing of this application as per section 126. It is the 127 is the appealable order. You have not preferred an appeal. You preferred an appeal, and if there is a delay, the authority, the appellate authority will consider delay whether it can be condoned or not.
Well, that
Condoned.
and in the meantime,
With regard to the payment, with regard to the reconnection, you can make an
My
appeal.
lord, my lord will
before
direct
the
it.
appellate authority.
Yes,
The appellate authority will decide.
Yes.
well, usually I am doing this matter so many years. Appellate authority usually not pass any order.
Maybe.
That did.
Will come to high court.
Yeah.
if it
There
is
is a
not
further,
passed.
further remedy is there, but appellate authority is not the final authority.
24 hours. One
My lord,
Why the appellate authority's power be
And-
taken by the writ court?
Delhi Regulatory Commission, I have annexed the order. 8 hours they are calculating.
and they are calculating 24 hours.
Their calculation is 24 hours.
The petitioner has filed the present writ application challenging the order passed by assessing officer by directing the petitioner to pay rupees 2,81,579 being 579 full. Counsel for the petition submitted that that the assessing officer has not assessed the amount payable by the petitioner. He submits that only he submits that the petition is only using 5 LED lights, 5 fans, 1 TV, 1 fridge, 1 pump, 1 geyser, and 1 AC. For the set, the assessing officer has assessed that an amount of rupees 2,81,579 is required to be paid by the petitioner is arbitrary and not in accordance with law. Police. Learned counsel appearing for the police. Learned counsel for the petitioner submits that an interim order be passed by allowing the petitioner to deposit the 50% of the amount as assessed by the assessing officer, and the electric connection may be restored, and the matter can be decided on merit after exchange of affidavit. Learned counsel appearing for the CSC has submitted that on inspection it was found that 5 LED lights and 5 ceiling fans consumes 0.25 kilowatt energy, 1 TV consumes 0.5 kilowatt, 1 fridge consumes 0.20 kilowatt, 1 pump consumes 0.30 kilowatt, 1 geyser consumes 1.00 kilowatt, 1 AC consumes 1.50 kilowatt. According to the assessment, the total consumption is 3.30 kilowatt. And as such, taking into consideration, the assessing officer has assessed the amount required to be paid by the petitioner. The learned counsel appearing for the CSC submits that as per subsection 5 of section 26, it is categorically mentioned that if the assessing officer reaches to the conclusion that that unauthorized use of electricity has been taken place, the assessment shall be made for the entire period during which such authorized use of electricity has taken place. And if, however, the period during which such an unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to the period of 12 months immediately preceding the date of inspection. Learned counsel for the CSC has further brought to the notice of this court has further submits that as per section 127 of the Electricity Act 2003, the order passed by the assessing officer is an appealable order, and the petitioner has to prefer an appeal within a period of 30 days from the date of the order. But in the present case, the petitioner has not preferred an appeal before the appellate authority. Had the learned counsel for the respective parties, this court finds that the petitioner has challenged the order passed by the assessing officer, wherein the total amount has been assessed rupees 2,81,579. As per section 127 of the Electricity Act 2003, there is a provisions of appeal. But the petitioner, instead of preparing an appeal, has filed an application filed the present application. Considering the above, this court finds that the petitioner is having the alternative remedy for preparing an appeal, but without exhausting the alternative remedy, the petitioner has filed the present appeal. Accordingly, the writ petition is dismissed with police. However, the dismissal of the writ petition will not prevent the petitioner to file an appeal before the appellate authority in terms of section 127 within bracket 1 of the Electricity Act 2003. It is further made clear that if the petitioner file any application for condoning the delay and for any interim order, the appellate authority will pass appropriate order in its own merit.
Including restoration.
Restoration and the payment of the and limitation.
I'm grateful, my lord. Deeply obliged. Now, may I take back the regulation?
Yes, take back the
And the judgment we have ordered. What are going to be?
Yes. Next.
Lord, item number 9, I appear for the petitioner, my lord. May it please
Item
your
number
lordship.
9, my lord, this matter has to go before the Intellectual Property Division.
Before the
Intellectual Property Division.
IP.
Cannot be, my lord. Cannot be, my lord. This application, my lord, filed by me, my lord, challenging a notice, a public notice dated 30th of September 2025 by the respondent authority. Now, my lord, I have challenged the said notice in the instant writ petition. My lord, a coordinate bench of this honorable court, my lord, has granted a stay, interim stay, my lord, till 15th of December. My lord, the stay is still subsisting.
Yes.
Now, my lord, what we find, my lord, during the subsistence of the interim order, my lord, we have also communicated the interim order to the concerned respondent authority. And my lord, we have also requested them to take down the impugned notice from the website and not to give it any further circulation, as the legality of the same is under challenge before this honorable court. Now, my lord, despite of same, my lord, the chairperson of the respondent authority himself, my lord, is posting the impugned notice along with the write-up in his personal LinkedIn ID, LinkedIn profile. And the same has been given wide circulation. Milord, general people are commenting on it. Milord, even he has personally, Milord, invited some of the general people to make formal complaints against this petitioner. Now, Milord, what is the allegation against me? They say, Milord, I am running illegal advertisement, misleading advertisements in Facebook, YouTube, and Instagram. Milord, this is the allegation. Milord, prima facie, Milord, primarily my challenge on the notice is that it is without jurisdiction, and Milord, the notice cannot be issued against me, Milord, because I am not an entity under the Trademarks Act. Now, Milord, for the time being, Milord, my limited prayer in the can is that, Milord, let the impugned notice be taken down from the website and let there be a direction on the office bearers of the respondent not to give it any further circulation, Milord, till Milord, the issue is decided by this honorable court, Milord. Because that is continuing that, sir, I have not completed. That is not continuing, that is continuing the reputational damage of my company, Milord, thereby lowering down my sales to a marginal extent. Milord, a company which is giving Milord bread and butter to more than 700 employees. Milord, if in this way, Milord, my business has been stooped down, Milord, it will be very difficult to survive. And Milord, the most important thing is that, Milord, the same modus operandi, same business, more than 100 other companies are operating, Milord, who have more Milord, the scale of the business is much higher than me. Milord, no action against them, no notice against them, nothing.
Where is the notice?
Select
Where is the impugned
note,
notice? 30th
Milord,
September.
page number 38. Page 38, Milord.
Of the writ application.
Of the writ application, yes.
সার্ভিস করেছিল ইয়ে কোথায় সার্ভিস করেছিল ট্রাফিক যখন মামলা হয়েছিল ইয়ে করেনি এরকম হয় না সার্ভিস Who is this appearing? What is the name of the council?
Arjun Chaudhary, Jalpaiguri, sir.
Yes. There are two
Down.
notices.
Now, Milord, my primary challenge is first the notice is without jurisdiction. Second,
firstly, Milord, this has to
this
go
this
before
is
the
this
IPPR.
Milord, it should not, Milord. I will demonstrate, Milord, why it should not, because I am neither a trademark agent nor I am a trademark attorney. Milord, not the dispute is primarily with respect to, Milord, the intellectual property matter. The issue is whether this notice has yes.
It is an intellectual property matter. How this court can enter into the writ petition? This court is not having the determination of the intellectual property matter. We go before the appropriate court having determination of
Yes.
the intellectual property matter. How the this court can go into with regard to the writ or not, that is different issue. But intellectual property, that is a separate division.
But the issue is primarily not on intellectual property. The issue is whether they have the jurisdiction to discipline me or not.
Correct, but it has been issued by the authority, so yeah, it is coming under the Intellectual Property Act. You challenge in without any jurisdiction. Let the court decide having the jurisdiction of the intellectual property matter. How this court can decide this, sir? Please go through the determination and all these things. Whether this court, other I will release. Please consult with the determination.
He has to get a new number and then file before the intellectual property court, Milord. That is the route, Milord.
There is a intellectual property.
Milord, Milord, let me come back tomorrow, Milord, with respect to that, Milord. Then
Go through.
Lordship. I'll come back to you.
Counsel for the petitioner press for time to take instruction. According case is adjourned. Let the matter appear tomorrow under the same heading.
I'm grateful.
I'm so grateful, Milord.
Yes, call.
My lord, I am for the petitioner. My lord, this is my affidavit of service, and yesterday also we have given them the notice.
Who is appearing? You are
for the corporation.
Huh?
Corporation.
Corporation.
Vidhannagar Municipal Corporation.
Vidhannagar Municipal Corporation.
My lord, this relates to a notice inviting tender issued in terms of the Great City Mission Project, my lord, of Ministry of Great City, Green City Mission.
Green City.
Green City Mission, my lord, where, my lord, the roads, my lord, are fitted with LED lights, my lord. Now, my client, my lord, is one of the persons, my lord, company who had participated in the tender. My lord, in the past also, my lord, he has executed more than 500 tenders, my lord, successfully, my lord. Now, the tender inviting notice was issued on 4th of March 2025. In terms thereof, we participated, my lord. Then, my lord, 18th April 2025, the tenders were submitted. Tenders were reopened, my lord, on 17th October 2025 after a period of 6 months, my lord. When the tenders were opened, my lord, 6 tender participants were there, my lord, out of which, my lord, 3 tenders were accepted and 3 were rejected, my lord. The reason was assigned on the website, my lord, that documents not satisfactory in the technical bid. No reason was assigned, and the other 3, it was being accepted. Immediately thereafter, my lord, we wrote them in the letter that please intimate what are the documents which are not there, because we fully qualify, we are eligible in terms of the notice inviting tender. Secondly, my lord, we also came to know that the 3 persons to whom the in respect of whom the technical bid has been cleared, my lord, have formed a cartel, and my lord, in fact, they do not fulfill the eligibility criteria as is specified in the notice inviting tender. But by letters galore, my lord, of 17th October, 18th October, 21st October, 27th October, 29th October, we made them representation. We produced them before them the documents showing that in this manner, the persons who have been given the allowed to participate in the financial bid, the next round, and have been qualified for the technical bid, they do not even qualify for the technical bid. Firstly, no reason has been assigned for my rejection of my tender, save and accept a cryptic ground that the documents not satisfactory. And secondly, the persons who have been allowed to participate in the tender, my lord, they have not fulfilled the important eligibility criteria, my lord. My lord, may I just place some of the documents?
What is a player now?
My lord, I want, my lord, work order should not be issued to any of the parties. My lord, I shall satisfy why I am
When
saying
the
so.
tender was open.
Tender was opened on 1st October 2025, technical bid.
Correct.
And my lord, thereafter we have made the representation. We do not know whether, my lord, when the financial bid has been opened.
Work order has been issued, work has commenced.
Work could not have been commenced, my lord. It is after filing of the writ petition. Kindly, I said so. Even if it has been done, my lord, if it is act something for illegal from very inception, and when objection has been raised by my client, my lord, from immediately after the opening of the technical bid, my lord, the authorities concerned had completely ignored the same. They did not choose to cause any reply. And my lord, have proceeded with the opening of the financial bid, my lord. And my lord, and the writ petition was filed before this honorable court. In order to make this writ petition infructuous, my lord, a submission is being made, my lord, that the work order has been issued. Now, my lord, I shall satisfy or show to your lordship how can these persons, I don't know, the 3 successful persons in the technical bid, how they become eligible to participate in the financial bid when the technical bid criteria of the notice inviting tender is not satisfactory, my lord. My lord, just kindly come to.
Where is the tender notice?
Yes, tender notice is, my lord, at page P2. Next P2, it is, my lord, at page 18.
Page 18. 4th March 2025.
4th March 2025.
Yes.
My lord, they were sitting tight over the tender for 6 months. And now suddenly it has become so hurry that they have started, the work has been commenced.
So you
Now, my lord, why the criteria which has been infringed, my lord, I'll come straight to that. Kindly come to page 20.
Yes.
It is under the head, at page 19, eligibility criteria for participation in the tender. Kindly come to page 20. 18. Bidders must be certified by the OEM of page 20 of LED manufacturer of reputed brand. The NIT number and date must be mentioned in the certificate. OEM authorization certificate has to be signed by the regional manager or any officer of its upper position. 20. OEM authorization / warranty to be signed by the regional manager. To avoid any duplicity or forged documents in authorization by OEM, it is hereby instructed to the bidder that the OEM should also send a separate digital communication to this office mail regarding authorization to the contractor agency in their valid letterhead. Now, my lord, kindly see what document has been submitted. Page 50. Page 49, my lord. My lord, first, before that, my lord, kindly come to page 47. Lord, you will find the tenders of 3 persons have been found to be accepted. Manturam Infrastructure Private Limited accepted technical. All documents are okay. 17th October. Yes. Mandal Enterprise rejected. Technical documents not satisfactory. Mrs. Enterprise rejected. Technical document not satisfactory. PP Electro Power, my client, my lord, on 18th April 2025, rejected. Technical documents not satisfactory. Then, my lord, next 2 names, RD Industrial and SM Construction. So far, number 1, 5 and 6.
3 are okay or
3 have been rejected. Now, my lord, kindly come to the next page, page P4. Page 49, my lord, kindly see.
Yes.
This is a certificate, my lord, alleged to have been given by Signify Innovations India Limited, formerly known as Philips Lighting India Limited. So, my lord, this is a certificate which is to be given by the Philips. Now, my lord, kindly see. Signify Innovations India Limited, formerly known as Philips India Limited, will stand warranty for 5 years as per tender terms from the date of supply, which as per requirement of the subject line tender. Who is signing it, my lord? Identify me one advocate with scribbles. It has to be by regional manager, my lord. I have shown your lordship the clause. And this is in respect of SM construction. Then, my lord, kindly take the next page, page 50.
So it is SM construction.
SM construction.
SM
The
construction is
serial number 6.
6 years.
Then we will take numbers, page 50. This is with, first one is with regard to the Philips brand. The second one is with regard to the Magic Lighting. Now, my lord, it is identical government, identical document on the same date, identified by the same set of lawyer, my lord. A notary is same and the same certificate. It is not from the regional manager, SM Majumdar. Then, my lord, kindly come to the next page. This is with regard to the SM construction, then page 51. It relates to, my lord, Manturam infrastructure. It is identical.
Yes.
Same certificate, same set of lawyer, same notaries, and same sort of affidavit, not by regional manager. Page 52, Manturam infrastructure for Magic Lightings, identical document. Similarly, my lord, for page 53, my lord, you will find for RD Industrial, Philips, and page 54 for Magic Lighting.
Yes.
So, my lord, this cannot be treated to be a certificate from the regional manager of the Philips and Magic Lighting. It is a document, my lord, to whom my concern has been given by the one advocate, my lord, which has been notarized.
Yes.
And this has been accepted by the authorities concerned, my lord, in terms of the eligibility
Have you
criteria.
submitted your certificate?
Yes, Havel brand.
Where is your certificate?
My lord, I have submitted all the documents online, my lord, all certificates. There is no dispute with regard to that, my lord. I've got the documents. I have submitted, my lord. They have not said that my documents were not there.
Why they have not accepted your?
My lord, that is, we don't know. The reason has not been given. It simply says documents not satisfactory. My lord, in fact, after the technical bid, the further documents which they required, we had also supplied them. Then, my lord, we have written them the letter. Kindly come to page 17. Sorry. Kindly come to page 81, my lord.
Yes.
Then, my lord, please, with reference to our tender, please note that you have just rejected our bid with remarks, documents not satisfactory. In this connection, we observed that the technical evaluation done by your department is incorrect, not properly evaluated, and misleading to the department. And not only this, they have completely overlooked while checking and evaluating bid of other under-mentioned bidders. Please note that your office have not followed any rules, regulation, guidelines of the government of West Bengal while evaluating the tender. They have clearly violated all clauses in illegally qualified specific bidder of their choice with insufficient documents. Then, my lord, we have mentioned the name of the three parties, my lord.
As per your contention, the page 47 is the only document which you got that they have not accepted your document.
Yes, apart from that, no reason has been assigned, nothing.
And you are making out a case that as per the company has to give the certificate. That certificate has not
been given
by the private.
And, my lord, my client has given the certificate for the Havel brand, my lord, for which he has testified, my lord, OM, the LED lights which were ready to supply. Then, my lord, in this letter, my lord, I have also pointed out several criteria, my lord, which were not being fulfilled by these persons, my lord, as per table 16. My lord, this was being pointed out. Then, my lord, kindly see page 82. As per table 16 under test report point 10, OEM must have their own ISO 9001-2015 certificate manufacturing unit. Certificate must have in the name of OEM related documents to be submitted, but all three ISO is invalid, expired of make Philips.
Okay, you have made a representation.
Then, my lord, second, thereafter again we made the representation 18.
Okay, now.
Then, my lord, thereafter on 25th again we made the representation.
Correct.
Then 27th also we made the representation again on 29th. My lord, they have not taken into consideration any of our representation. And today, my lord, when the petition is being filed, my lord, immediately thereafter, my lord, on 29th, my lord, we have filed the petition before this honorable court. On, my lord, 3rd November, my lord, 2025, my lord, and it was duly served upon them on 5th, my lord. My friend today is contending that they have issued the work order, my lord. Even if the work order has been issued, my lord, if the tender conditions are violated, my lord, are not being adhered to, my lord, then it cannot be such act on the part of the respondent authority becomes illegal, my lord. In this connection, my lord, your lordship knows the law very well, but my lord, I am relying upon the two judgments, my lord. The original judgment is, my lord, the leading judgment is in the case of Ramanna Dayaram Shetty, my lord, reported in 1979, volume 3 SCC, page 489. The relevant paragraphs are 10, 12, 14 and 34. And my lord, a very recent judgment, the
10, 12,
14 and 34.
yes.
वैसे करके मेरे को दिखता नहीं है मतलब just
Yes. Then
my lord, may I just it contains, my lord, the guideline. Then my lord, paragraph 10, just I place on, my lord, the now there can be no doubt that what paragraph 1 of the notice prescribed was a condition of eligibility.
yes, okay.
These are the guidelines, my lord. Yes,
okay, no problem.
and my lord, similar, there is another judgment, my lord, which is reported in 2020, volume 17 SCC, 577, my lord, which also says, my lord, that the tender document cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. And my lord, given the fact that in the present case, an essential tender condition which had to be strictly complied with was not so complied with, the appellant would have no power to condemn lack of such strict compliance. Any such condonation, as has been done in the present case, would amount to perversity in the understanding or appreciation of the terms of the tender condition, which must be interfered with by a constitutional court, my lord.
Which paragraph you are referring?
My lord, I am referring to paragraphs 14 and 16, my lord, two paragraphs.
Yes. That's all?
These are my submission, my lord. So, my lord, the work has to be stayed, my lord. Firstly, because I have been disqualified without assigning any reason, improperly, without considering, pointing out which are the documents I am lacking, because the petitioner has successfully participated in more than 500 tenders. He qualifies. Then the persons whose tenders have been accepted, my lord, are of the same set in order to form a cartel, my lord. And so many representation we have given them, but nothing has been considered.
Yes.
Therefore, my lord, I am praying for stay.
Before addressing Millard on the points of merit, Millard will kindly take up the cost title, Millard, page 1 of the writ petition. Millard, here, Millard, a partnership is before Millards through a partner, one of the partners. All partners are not before Millards, only the partnership and one of the partners are there. Millard will now kindly take up page 16.
Yes.
Page 16 is.
Leave aside, I am not going to the technicals, come to the merit of the matter.
This is important, Millard.
What is the important?
This is signed by somebody called Ashok Kumar De, Millard.
Ashok, we come to the last page.
Yes.
Attorney.
Yes, Millard. I will be showing that, Millard. Millard will kindly, this is not paginated after page 105.
I am again telling, I will not go into the
Millard
technical.
will only see 106 once.
You show me the what is the flow.
Millard, I am showing. Millard will only see 106 the power of attorney once. Who is the power of attorney giver? The partnership firm has not authorized this person to act on behalf of the partnership firm. Millard will see the this attorney has been executed by one Om Prakash Jhajaria. He is one of the partners maybe, but in his personal capacity, he has appointed Ashok Kumar De as his attorney.
Okay.
Ashok Kumar De is alien to the partnership firm, Millard.
Okay.
Millard, this is the first submission I have.
Yes.
Millard, the second submission is, Millard, on 17th of October, the rejection was made. Millard, the rejection was on 17th of October.
Yes.
Thereafter, Millard, the writ petition was filed on 3rd of November. It was served upon us on 6th of November with the indication that it will be taken up on or after 10th of November.
Which page?
Milord, the affirmation is page 16, Milord. Page 16 will see, Milord. Milord, page 47 shows that 17th October is the rejection.
Page 47.
47.
Ah,
47 is the rejection.
Correct.
Milord, thereafter, Milord will kindly take up page 16. That is the affidavit, Milord.
Yes.
That the affirmation took place on 3rd of November. Milord, the covering letter which has been served upon us, Milord, it says it will be taken up on or after 10th of November. Milord, that perhaps is not there. I can hand over for a.
I've given in my affidavit of service. It is there.
Yes, yes. So, Milord, that is there, Milord. So there is a substantial delay, Milord. They did not move. It is not that the moment they filed a writ petition, we have issued work order. It was in process. We issued as it was supposed to be. Milord, the second point is on merit, Milord. Milord, the allegation is that we have relied upon the affidavit signed by an advocate. That is not the fact, Milord. The fact is, Milord, Milord, I am submitting, Milord. This is one set of certificates, Milord, which is there. Milord, the petitioners have chosen to disclose few documents which favors them.
Yes.
But not all the documents which is there. Milord, will see the first is, Milord, RD Industrial. Milord, this is a
Can I have a
certificate
copy of
from a
it?
company. I'll hand over this. Certificate from a company called, Milord, the Magic Lighting. Milord, it has been issued in the correct format, addressed to the corporation, Milord. It has been issued in favor of RD Industrial, who is one of the successful bidders, Milord, as per page 47. If Milord takes up page 47.
RD Industrial.
Yes.
Given this.
RD Industrial is serial number 5 in page 47.
Correct.
Milord, will kindly take up the next paragraph, next page, Milord.
Now, who has given this certificate?
This certificate is issued by Magic Lighting, Milord. Milord will see.
Magic Lighting.
And it has been signed by somebody higher than the regional manager, that is the director, it appears.
Participate about tender validity and given validity fixes shall be supplied by the extent of complete technical support. Yes.
Milord, and this is signed by somebody higher than the regional manager, Milord. Milord, another point in that page, Milord. Milord, will see in the penultimate paragraph, we say, we hereby declare the materials against the said tenders will be warranted for 5 years against any manufacturing defect under normal operating conditions complying the NIT clauses.
Correct.
So this is the main criteria because we need 5 years of warranty, Milord.
Correct.
The next page, Milord, this is the certificate issued by Magic in favor of SM Construction.
Yes.
Which is serial number 6 in page 47. And Milord, thereafter, then another next page, Milord, it is to Mattura, Milord, which is Montura, Milord, which is serial number 1 in page 47.
Yes.
Milord, this is one set of. Sorry, Didi, extra chilam. So, Milord, we have considered these certificates. Thereafter, only we have gone ahead and approved. And
what is the certificate submitted by the petitioner?
Milord, I'm sorry.
What is the certificate submitted?
Milord, the latches on the part of the petitioner is.
You have to show that only.
Milord?
You have to show that only. You have not complied.
Yes, Milord, that particular documents we have not brought, Milord.
Not documents, but you might have been taken the instruction.
Yes, yes, Milord.
Because page 47 says the document not satisfactory.
Yes. Which are documents, Milord? I am just indicating.
Show me that.
Milord, there is a technical problem. Milord, here it says that the unsuccessful bidder was rejected for the following reasons. One is non-submissions of the ROHS certificate duly authenticated by the agencies having ISO certificate, Milord, which is as per a NIT clause. Second is non-submission of valid PWD approval.
I'm noting it down.
Copy the rich.
Non-submission, not submitted?
Not submitted ROHS certificate duly authenticated from
ROHS.
ROHS.
What is that?
I'm indicating that from the tender.
Okay. ROHS certificate and?
Which does not have near the ISO certified number, which is required.
ISO?
Second, ISO.
Yes.
Second is non-submission of valid PWD approval. And third is, Milord, single OEM manufacturer authorization is not approved by PWD as per the NIT clause. So the PWD approvals and the ISO certificate was not there. That's why we did not consider.
Yes.
This is the short point, my lord. Nothing else.
When the work order was issued?
Work order was issued on the 12th of November.
12th November.
12th November. There was no hurrying, my lord. On 17th, we opened the technical bid. It was in process. On 12th, we issued the certificate.
That's
it. Yes. And it's not maintainable, my lord. I have shown from the cost title and from the.
Now, my lord, to this document, my lord, I can have an answer, my lord. Yes, my lord.
Sorry, my lord. Another point I missed, my lord. There are 3 successful candidates, my lord, who are not before, my lords. The parties will be affected. The rights of the parties will be affected.
Not made a party.
Not made a party, my lord. I'm so sorry.
Very well, actually. The party kindly keep it day after tomorrow, my lord. I shall serve them. I'll aid them a party, my lord. I shall aid them a party because I was not aware when the work order was awarded.
But they were
that is why I did not. That is why I have not made them.
Take that, yes.
I'll aid them a party, my lord. It's not so.
Yes.
Now, my lord, with regard to this, my lord, kindly come to clause 20, page 40. Page 20.
Page 20.
Yes.
Yes.
Now, my lord, kindly look at clause 17 and 18. For rejection of my tender, my lord, one point that has been taken is that they cannot accept single OEM. This is one of the points that has been taken. Now, my lord, kindly see a declaration of warranty of luminaries for 5 years from an OEM shall have to be submitted by the bidder through an affidavit on government stamp paper. Bidder must be certified by the OEM of LED manufacturer reputed brand. My lord, it does not say, my lord, that I have to submit OEM of more than one brand, my lord. And, my lord, N OEM indicates, my lord, singular and not plural. It can be one, it can be more than one. So, my lord, I have submitted, it is not disputed that I have submitted with regard to the HON'BLE brand, my lord. And, my lord, so far as this document is concerned, my lord, kindly see clause 20. And, my lord, all these certificates have been produced, my lord. Clause 20, kindly see OEM authorization warranty. This clause 20, my learned friend has produced a letter of magic. When it has been issued, my lord, it is issued, my learned friend is showing date of 2nd April 2025. But kindly read the clause 20. OEM authorization warranty to be signed by regional manager to avoid any duplicacy or forged documents in authorization by OEM. It is hereby instructed to the bidder that the OEM should also send a separate digital communication email to this office mail, Bidhannagar Municipal Corporation Tender gmail.com in between 11th March 2025 to 7th April 2025 regarding authorization to the contractor. Authorization mail should come from person designated as regional manager or above and should be from their official email ID only. This will be treated as a confirmation document, my lord. So, my lord, this document is not sufficient. This document does not show, my lord, that this document has been sent by email. In fact,
I did not understand this was required.
In fact, my lord, the one of the condition, my lord, it says that in order to avoid duplicacy or forgery, my lord, an email from the official website, email ID of the company ought to have come. Now, my lord, this is a letter, my lord, that is of, they say it was produced 2nd April 2025.
This is the attachment in the email. The email is there.
It does not show, my lord. Let my learned friend.
No, it is not the email there. I don't disagree. This is the attachment we have produced. We did not think that this point will be taken or is going to not be.
No, certainly I've indicated these are my points, my lord. And so far as the points which have been given in the tender number point number 6 letter of page 81, my lord. Kindly see. Page 82, my lord, kindly take the page 82, kindly find, my lord. As per table 16 under test report warranty point 3, the manufacturer of the luminaries must have its own R&D wing. No document uploaded of Magic brand. As per table 16 under test report must be submitted, but 45 watt and 90 watt fitting is missing for Magic brand fitting. Okay. This is most compulsory report but was overlooked. Then my lord, table 16.
Yes, you're shown.
These, and my lord, kindly see the ISO what my learned friend has said as per table 16. Under test report warranty point 10, point 8, ROHS certificate from ISO 9001 certified lab must be submitted along with technical bid, note uploaded by Philips brand. As per table 16 under test report warranty point 10, OEM must have their own ISO 9001 2015 certificate manufacturing unit. Certificate must have in the name of OEM.
Yes.
But all three ISO is invalid, my lord.
Lord has asked for the full form of ROHS. It is restriction of hazardous substance.
The petitioner has filed the present writ application on the ground that the respondents have rejected the tender document of the petitioner without signing any reason. On 4th of March 2025, who has issued the tender?
The tender has been issued by the Mayor Bidhannagar Municipal Corporation. Commissioner,
Chief
no,
Engineer.
on behalf of the Commissioner, Chief Engineer Bidhannagar.
Bidhannagar Police Corporation, Municipal Corporation has issued the tender. For the project under Green City Mission. The petitioner has participated in the said tender, but by a communication dated 21st of October 2025, it was informed to the petitioner the document submitted by the petitioner not satisfactory, and accordingly technical bid was rejected. Full stop. The petitioner has drawn the attention of this court to clause 18x5 of the tender document and submits that as per the said clause, the bidder must be certified by the OEM of LED manufacturer of the reputed brand. It further some reputed brand, but in the present case, the respondent have not the other bidders whose bid has been accepted by the authorities have not submitted the said document. The petitioner has relied upon the affidavit affirmed by Philips Lighting, Magic Lighting, Philips Lighting and Magic, MAJIK, Lightning, and submit that the authorities have accepted the affidavit affirmed before the notary public, but the authorities have failed to consider the condition number 18 of the bid document. The contention of the petition that when the petitioner came to know that without assigning any reason, only to the effect that the document was not satisfactory and the tender of the document was rejected, the petitioner has made a detailed representation to the respondent authority and to the Mayor, Bidhannagar Municipal Corporation on 17th October 2025, and subsequently several reminders calling upon the authorities that the bid document, the bid accepted from the firm have not complied with the tender documents, but the authorities have accepted the tender document of the said firms. She submit that in spite of the receipt of the representation, no reply has been sent to the petitioner. Accordingly, counsel for the petitioner prays for an interim order restraining the authority from giving any work order to the alleged successful bidder with respect of the said work. The petitioner has relied upon the judgment in the case of Ramanna Dayaram Shetty versus International Airport Authority of India and others, reported in 1979, Volume 3, SCC 489, and submits that the Honorable Supreme Court, way back in the year 1979, has categorically held that under the constitutional mandate of Article 14 of the Constitution of India, the administrative law not permitted the executives to act arbitrarily in accepting the tender which is not in conformity with the tender document. The counsel for the petitioner further relied upon the judgment in the case of Vidarbha Irrigation Development Corporation and others versus Anoj Kumar Agarwal and others, reported in 2020, Volume 17, SCC 577, and submits that the tender document cannot be ignored or treated as redundant on superfluous. They must be given meaning and their necessary significance. She submits that in the present case, the petitioner has submitted the document, but ignoring the document of the petitioner, the respondent authorities has relied upon the document of the alleged successful bidder, which is not in confirmation of the bid document. Full stop. Per contra, an advocate appearing for the, you are appearing for all?
For the corporation,
for the Vidhan Nagar Municipal Corporation, submit that the on opening of the.
But I am not appearing for respondent number 8.
8
for 1 to 7. I am
1 to 7. 1 to 7. And submit that on opening of the technical bid, it was found that the petitioner has not submitted the document.
Can you give me the document which you say the conditions
for
my client? No, you mail me.
Altogether 6 firms
You
have
give
been
me on my number.
participated in the said tender. And opening of the technical bid, it was found that
No, that is a letter you are relying on.
3 firms have
relied upon.
Have submitted the documents which has been accepted by the authorities, and 3 firms, including the petitioner firm, have not submitted the document which was not satisfactory to the tender document in terms of the tender document. Accordingly, their tender has not been accepted. Full stop. Counsel for the municipal corporation submit that after find that Mr. SM Construction work order has been issued to whom? All
for different
that all 3 firms who have been qualified in terms of the tender document, the separate work orders has been issued to the said firms. He further submits that he has handed over the document to show that in terms of clause 18, the firms have submitted the certificate from the concerned authority, wherein it has been declared that the materials against the said tender will be warranted for 5 years against any manufacturing defects under normal operating conditions complying NIT clauses. Full stop. Counsel for the municipal corporation submit that the firms have complied with all have submitted all the documents as required under the tender document, and accordingly the authorities have accepted the tender and issued the work order. He further submit that the petitioner has not submitted the document in terms of this tender document, and as such the case of the petitioner was rejected and tender of the petitioner was rejected.
My lord, my learned friend had read out a letter, my lord, which indicated 3 conditions my client could not fulfill. My lord, so my lord, I shall be given a copy of that.
Counsel for the Respondent further submits that on opening of the tender, it was found that the petitioner has not submitted RHS certificate, ISO certificate, valid PWD certificate, due to which the tender document of the petitioner was
And single OEM authorization, another point which he has said.
Of the petitioner was rejected. Had the learned counsel for the respective parties perused the materials on record, the petitioner has specifically relied upon the affidavit affirmed by the Philips Lighting and Magic Lightning before the notary public, and submit that this affidavit is not in conformity with the clause 18 of the tender document. But at the time of argument, learned counsel for the respondent has handed over the documents, which shows that the Magic Lightning
and not by the Philips.
Magic Lightning has forwarded the letter to the chief engineer, Vidhan Nagar Municipal Corporation, certifying that they have authorized the RD Industrial, SM Construction and Manturam Infrastructure Private Limited on behalf of the said Magic Lightning to participate in the said tender on behalf of the Century LED Limited. And in the said communication, it was also given an undertaking that the materials against the said tender will be warranted for 5 years against any manufacturing defects under normal operating conditions complying NIT clauses. This court find that the document which the respondents are relied upon and on the basis of which the respondents are accepted the tender of the successful Buddha is in conformity of clause 18 of the tender document.
Clause 20 kindly, email is not there. It has to be.
Petitioner submit that though the documents are relied by the respondent, but there is no email to certifying that has been issued by the concern authority of the Magic Lighting. This court sitting in the writ jurisdiction cannot discover or cannot verify the documents of the tender submitted before the tender authority. Tender authorities are the specialized to whether the document is to be accepted or not. Unless the court finds that the document accepted by the authorities are mala fide and arbitrary. This court finds that there is no mala fide for accepting mala fide act on the part of the authorities for accepting the said document. Accordingly, this court finds that there is no merit in the writ application filed by the petitioner. Thus, WPA number so is dismissed.
So far as the petitioner's disqualification, my lord, nothing has been disclosed. No document has been given, my lord. Let it be recorded, my lord, that I have not been supplied.
Already, first I have recorded.
No, orally they have submitted, but I must have a copy of it, my lord. The document.
You asked the court cannot give any order. Yes.
My lord, I have been contradiction.
करेक्शन करके अपलोड होगा ना. Yes.
My lord, as per your lordship direction in earlier occasion, your lordship directed me to serve the copy of the application, my lord, to the private respondent, and my lord, I served all. And my lord, in earlier occasion, respondent number 14 appearing before your lordship, and I also served the copy of the writ application to her.
But I appear for the state respondent in this matter.
6-2?
State respondent.
State respondent.
14 in earlier occasion already appeared before your lordship. 15 to 18, your lordship directed me to serve. Only 15, my lord, regarding track, dispatch, 16, 17, 18, my lord, all received.
You are for the state?
Yes,
Who is for the private respondent?
Private respondent 14, my lord, in earlier occasion appeared before your lordship. And your lordship directed me to serve again another notice to 15 to 18.
Have you served?
Yes, yes, I served.
Where is the delivery?
Delivery male regarding 15 only item dispatch, other delivered. 15, 16, 17, 18, my lord already delivered.
Yes.
Well,
What is your contention?
My lord, matter regarding to my lord 0.8 acre pukur that was by filling up and construction has been done by the respondent number 14 to 18. And my lord, if your lordship kindly say the Khotian information of the Khotian, page 21 is the RS. My lord, that is 2918, that is pukur, nature of land pukur. And LR, my lord, page 28. Page 23. Page 23, my lord, that is 2918, that is nature of land is pukur. And the respondent number 14 to 18, my lord, that is they are the recorded owner of this pukur, owner of the co-sharer, page 25.
What is your case?
My lord, that is they are by filling up the pukur, the construction has been going on by the respondent number 14 to 18. I made representation to the BLRO authority. In earlier occasion, BLRO, as per my representation, written representation, page 28, hearing has been done, but no order, nothing has been done by the BLRO. If your lordship kindly see page 28.
28, what is this?
28.
Is a notice.
Yes, notice by the BLRO.
Correct.
পুকুর ভরাট না করার পরিপ্রেক্ষিতে নোটিশ দেন পিটিশনার ফাইল 163 application before the learned executive magistrate, page 29. There are also specific direction passed by the learned executive magistrate, that is my lord, উভয় পক্ষ কোনো নির্মাণ কার্য বা জায়গার প্রকৃতি ও চরিত্র পরিবর্তন করিবেন না. In presence of all, order has been passed. They did not, my lord, stop anything. Then I made representation before the authority, all the authority concerned. Again, page 30, that was not taken into consideration by the competent authority. That is
given this
page 31. That is district magistrate. Page 31. And they received. I also made annex track report. All received on 29. And I also annexed the picture, what they done. Page 39. This is my lord only allegation against the respondent number 1418. If your lordship direct.
What I see from the annexures in the writ petition, they have approached the district magistrate, who is the concerned authority under the Inland Fisheries Act, to take the application forward. The prayer is also such. Prayer A at page 11 and 12.
Correct.
And your lordship on the last occasion was kind enough to ask the state respondents to file a report. Initially, we had filed a preliminary report, which is there in your lordship's brief. This report is the present report, which is there before me is coming from the additional district magistrate. But I have the report which suggests something, but until and unless the district magistrate, being a competent authority, takes out a proceeding under section 17 my lord, of the Inland Fisheries Act, my lord, probably my learned senior friend's client would have no other remedy. But the report I have with me, may I place that report for your lordship's kind consideration? But one additional thing, my lord, the report had one incorrect statement with regard to the construction of story. This is a revised part. Just now it has been, my lord, supplied to me. My lord, the findings at second page of the report.
Yes.
And
the earthen road exists in the bank of the flood, which is used by the neighborhood. No data plot is created.
I may be excused that my lord, the report has not been paginated, my lord.
Yes.
My lord, this is what has come up.
Have you got the report?
No, my lord.
No, my lord.
It was just to be placed.
Serve the report.
I shall.
My lord, if as per my lord these notification, the district magistrate is the competent authority. If
Correct.
your lordship directs the district magistrate to
See, if we direct the district magistrate also will call the report.
Same
So
report.
the report will not change what the report is filed here. So that's why you go through the report. If you are accepting the report, I am passing. This court will dispose of your writ application. If you say you will take exception to the report, you file the exception to
Yes,
the
yes.
report. The court will decide its own merit.
And-
This is your choice.
And probably, my lord,
You will
my
accept
lord, then
this.
my lord, if the additional district magistrate report that there is no filling up the pond, my lord, then I have to file
Go
exception.
through.
and my lord, probably, my learned senior friend is seeking for an proceeding before the district magistrate, which is under law,
Yes.
section 17.
No, that's why I'm telling.
Yes.
If because in the before the district magistrate also he has to call for the report and the pass appropriate order hearing all the parties. I don't think that district might be before the district magistrate some other report will be there.
His report comes from the BLRO
Correct.
and thereafter.
District magistrate so moto will not collect. He will call for the report from the ADM or the BLRO.
My lord, here the additional district magistrate and my lord report.
You will take exception to the report.
My lord, I will file exception because my lord, my written complaint is.
Petitioner has filed affidavit of service. Let the same look up to the report. In spite of service of notice, none appears on behalf of the private respondent. Learned Counsel appearing for the state has filed report after serving the copy to the Learned Counsel for the petitioner. Counsel for the petitioner prays for time to take exception to the report. Let exception be filed within.
My lord, within 10 days.
Within 10 days, after serving the copy to the Learned Counsel for the state, list the matter on on 4th of December.
4th and 5th, my lord, kindly excuse me for
Okay,
the
then 8th of December.
grateful.
My lord, under the same heading. Under the same heading. Grateful.
8th of December.
Yes.
My lord, review service kept on record. That.
Lordship, I'm for the petitioner. I'm being led by Advocate Choyan Gupta in this matter. Advocate Choyan Gupta in this matter. Lordship, I've been instructed to fix this matter at 2 p.m. He's in court number 6.
You persons are mentioning the matter, bringing
Yes, Your
the
Lordship.
matter on report on in the list. Then when the
Okay.
matter is called fixed, so other advocates are also waiting.
I absolutely bow down to your Lordship. Man, lord,
What's the
kindly.
matter about?
Man, lord, this is the badminton players.
The
man.
badminton, tennis.
Yes, absolutely. 2 players have been suspended without any formal inquiry.
Yes, they have taken instruction.
Lord, without going into the other aspects of the matter as regards maintainability of the writ petition, or that not he has come up with unclean hands, or that there is no joinder of causes of action. But there is a robust architecture within the parameters of the rules of our association, which provides for a disciplinary committee to take an expeditious decision once this interim suspension is made. But there are severe allegations. While representing the state, these 2 persons made ruckus at night in the hotel of Jharkhand. But there was an FIR sought to be lodged. Then we intervened and somehow assuaged the situation. Be that as it may, this writ petition can be disposed of without deciding the issue of maintainability.
My lord,
Directing
kindly
the
2 p.m. My lord, kindly
directing the
at 2
disciplinary
p.m.
committee to
My lord.
expeditiously.
2 p.m. My lord.
2 p.m. available. 2 p.m. matter is fixed.
My lord, this will take 5 minutes, my lord. After that.
Which matter is there?
After
Sir?
that.
I don't know. Thereafter today, what is the date? Yes, after fixed matter ke baad we'll see to that. Okay, pass ho.
Pass.
Next.
I'm for the petitioner, my
lord. I appear for the state of West Bengal.
appearing
By
on
the
behalf of wetland.
General, because the virus is
Viruses.
under challenge.
My lord, I always come with the virus. Yes, just a minute. This supplementary, my lord.
What your challenge? So the all the
Yes, ma'am. This is very important one. I'm also covered by
bring all these big shots before.
Yes, ma'am. But your lordship, I'm so short. I'm so short. They'll come. But your lordship, can you come to page 272 is the input order.
Yes, Kolkata wetland conversion.
Yes. But can you see? Can you see the order?
Where
My
is
lord,
that?
at page 272, can you see? My kind is appointed by 276.
276.
Yes. My lord, sorry. But they passed the order for demolition of the entire building structure under section 9 of the, is in violation of the West Bengal East Calcutta Wetlands Act and Rule 4 of the New Central Rules 2017. This is their order. Your Lordship, can you see?
Should I appear for the state? But I'm astonished that Mr. Roy is moving a matter incorporating my opinion as the evidence. The writ petition should be dismissed for that only. It cannot be.
My advocate general, I got it by the RTI.
No, it
I
can't
got
be.
it by RTI.
You may submit, but you cannot read.
I got it by RTI, my lord.
Let him remove
And
it
then
and
then I'll remove it. No problem. I'll remove
No,
it.
it can't
earlier-
be.
But RTI, I got by
The
RTI.
courts have never entertained this.
But then the Your Lordship, don't rely upon this. And this
No, it cannot be part of the
But
record.
Your Lordship can appreciate other matters. I have produced it.
You
And
cannot.
before the court.
You can. That's why I'm
This is I
surprised.
got it by the RTI. Their officers given. Advocate general should say.
Authority has made a mistake, but the advocate should not.
RTI, my lord, in earlier, but I am not produced. There are many matters. Yes. If the advocate general says, I'll remove it. But you also can allow me to place the case?
No, this should be dismissed.
My lord,
This writ petition
Well,
cannot
kindly
be.
say, tomorrow is my order of violation. Mr. Advocate General, he knows that the other 19 matters. He appeared. I only concluded my argument. He did not appear. What is he saying? Can you allow me? But this is demolition of the 2,000 flats. But I'm covered by the orders of the division bench also. Can you?
So whether you paid for interim order?
Yes.
What interim order?
Not to demolish because I'm covered by the division by order of the division. Can you allow me to place? I'll remove this. I'm giving. If the Advocate General says, I'll remove it. But can you choose? My lord, Your Lordship, kindly see page 272. And see that this is urban Sabujayan. Got it, my lord, the input order in respect of urban, the company is urban Sabujayan. Got it, my lord? So they passed the order for violation of section 9 of the East Calcutta Wetlands Act, the State Act, and section rule 4 of the new Central Rules 2017.
When is the demolition date?
They said, they said 30 days time, but now they have given a notice for disconnection of the electricity. This is my supplementary evidence. So my junior mentioned before also. My lord, this is there, 30 days is given. I got on 4th.
Yes, 30 days is there.
But they have given the notice on supplementary for this.
Where is the supplement?
This. I served for you. Can you see this? This is very sorry affairs. My lord, Chief Technical Officer wrote to the country page 4, my lord, Chairman CSC, and tomorrow is the date for disconnection of supply. At page 7, my lord. They wrote a letter to CSC, wrote a letter to police of the police is the party, my lord. CSC is not the party because
yes, for the 30 days, why the electric?
May I place, my lord, the order? My learned friend has not placed the order.
No, look, I'm not.
Now they are seeking equity before this court without appearing before the authority.
No, that I'll show why. That will show.
On the,
I have given all documents.
Please.
On the ground that 12 writ petitions are pending before.
Not only that, I have given all the injunction I have given.
First is.
My lord.
I will
hear you. Let.
Please take my page 272.
Yes.
This is
the police case started, etc. I don't trouble your lordship with all those, my lord. At page 273 at the bottom, my lord, the writ petition numbers, my lord, has been mentioned.
Yes.
Apropos, my lord, the cases. Then, my lord, if your lordships may kindly comes to, my lord, page 275. Where at the top, hearing. Instead of appearing in the hearing, the secretary of so-and-so submitted a letter claiming that since the aforesaid 12 cases are pending before the Honorable Calcutta High Court, in which the Honorable High Court, through order dated 12/7/2024, observed that this court does not have determination to take up this matter, by challenging the provisions of EKW, he would not appear in the hearing. However, the EKWMA through here the hearing notice number so and so dated 18/9/2025 provided a further opportunity of hearing to the secretary for appearing in another hearing on so and so. The hearing notice was sent to the aforesaid address to which the previous hearing notice was sent by post. Then, my lord, he discusses the laws, Ramsar site, etc. Where we'll deal with that. Finally, kindly take now 276. Conclusion. Taking into account all the aspects and deliberate non-appearance of the secretary in the hearing, the chief technical officer is of the opinion that the violators illegally constructed a residential complex and boundary wall surrounding the area in Dag number, etc., which falls within EKW area without any permission from EKWMA. Resultantly, the residential complex is illegal and violates the provisions of section such and such. Now, the final is that today, my lord, it is their obligation. Kindly see, the violator is therefore directed to restore the land to its original character or mode of use within 30 days of receiving this reasoned order, or else action would be taken. Therefore,
My
lord, I do not know when he has received. Today, my lord, up to the 30th day from the receiving, it is their obligation to remove. If they don't remove, of course, my lord, the law will take its own course. Yes. Therefore, today, my lord, as of today, my lord, I don't think, my lord, he can get an injunction on an obligation that has been cast upon him.
No, with regard to the electricity disconnection of electricity, so if you file the affidavit, okay.
Supplementary দিয়েছে?
I've given, he said, this is very চলছে কিভাবে কে জানে?
And subsequent order passed by this court. It is not given to this.
How soon you file affidavits?
But there 17 matters. Already I conclude my arguments. Mr. Advocate General, last occasion, he did not appear.
Same order?
No, the same matters. I'm sure the others, I'll place everything, my lord. The division bench also views, my lord, I suppose that you also can allow me to place, then my lord also can, why it was on many different matters.
No.
But yes, they will file affidavit, I'm no.
If it be before the 30 days, because your decision on 4th of
Where I'm sorry, my lord, again, my lord, Mr. Roy has not been instructed properly. Please look into the supplementary affidavit. Page 4.
Oh, yes, that matter, yes.
Just a minute, just a minute.
Oh, matter is order.
Let me point out, I may be wrong, you will correct me if I'm wrong.
You are absolutely, you can't say wrong, you are not properly instructed.
The date is 4th of November 25. Kindly see the reference. Reference is order dated 6/3/2024 of the Honorable Calcutta High Court in WPA number 17905 of 23.
Yes, I'll show you why.
Request to comply with the referred direction of the Calcutta High Court.
My lord, that I'm not the party. On the basis they passed this order. Kindly, there's no order.
My lord, my learned friend has projected as if, my lord, pursuant to
I'm not a party there. Please.
Impugned order, my lord, the disconnection notice has been issued.
Notice
my lord, this is, my lord, with respect to a senior advocate, wrong portrayal of facts.
I'm not wrong. I'll show you. If I make a wrong portrayal, my lord,
this amounts to, my lord, misleading the court.
Aspersion against me.
This amounts to, my lord, I say with all responsibility.
Punish me.
Please, one.
My lord, this is, my lord, I am not
expecting
of you.
Let when I make a statement, I go by that statement and I owe the responsibility.
Yes.
Where my learned friend should have told the court that this disconnection notice, which is page 4 of the supplementary affidavit, is not pursuant to the order of the authority dated 4th of November 2025. It is pursuant to or in compliance with a direction of this honorable court passed in a 2024 matter. Now, my lord, please consider, my lord, how the court is being misled.
Yes.
My lord, had your lordship, my lord, stayed.
Have you challenged this order 6th March?
Can you allow me that what Mr. Advocate, at least I have to such a Mr. Advocate General that I'm not wrong. Can you also allow me? Then I'll come to that matter. What happened? So order was passed on 4th November 2025. Because you can see it is passed. The independent order was passed. My lord, but its independent order was passed. Notice I'm coming. At first I made the merit of the case. Then my lord. So order was passed. Here, my lord, they passed the order for violation of section 9 of that state act and rule 4. My lord, I have, in this matter, I have challenged, your lordship, can you come to, you go to the back, page 38 for a moment. Then I. What's my prayer? My lord,
Yes.
I say that State Act is otherwise to Article 253. This is my first prayer, A, my lord.
Yes.
Second, my prayer is that new rules has come to force, that Act become redundant. This is my second prayer. Alternatively, third, I ask for the not to give effect to this manuals regarding quashing of this statutory quashing of this improved order. Now, my lord, under what basis I'm done and I did it. If you also can see, so this is my prayer. Your lordship, I just on merit I press, then I'll come to your lordship. My lord, this the State Act. This I annexed in the petition. If your lordship kindly come to press that. Yes, can you come to page? Can you come to page 52 for a moment? No, before that I just place it, my lord. I've been, my lord. Can you come to page 42 for a moment? Well, this is Convention of Wetlands of International Importance, especially in Wetlands Habit, Ramsar 2 to 1971. This is international convention. And Iran and India is one of the signatories, my lord. And in case the page 43, my lord, Article 1, wetland is defined. I'm not going to that. Now, my lord, now can you come to page 51 for a moment, my lord? The East Calcutta Wetlands Conservation and Management Act 2006 has been legislated. Can you say statement object at page 52? Can you see page 52? Paragraph 2. East Calcutta wetlands situated in the eastern fringe of the city of Calcutta was declared as a Ramsar site in 2002 in consonance with the Convention on the Wetlands held in Ramsar in 1921. So it is admitted fact that on the basis of internal convention, the state has legislated this act. And kindly see the constitution.
How soon you can file affidavit?
Well, kindly,
I have got to make, Milord, this is Ramsar site, where it has got an international impact.
Correct.
Now,
Other matters he has already argued.
Now, Milord, this Supreme Court is also insisting over it. Supreme Court has directed, Milord, the Honorable the Chief Justice to constitute a bench to look into all these Ramsar site matters which are going on.
I have all the orders.
Yes.
Kindly see these orders. Just I wanted to submit.
But I have given a list to Milord the bench, which is taking up where
So I'm releasing and you mentioned.
yes,
This is the
Because of protection of.
can you allow me this? Ramsar, I'm not. I challenge the State Act. Can you see? This is a Supreme Court says regarding the Ramsar, the new rules in 2017.
Okay, I am releasing it when all the matters are pending.
They will demolish the electricity.
Electricity here, no. If you want to pass an order in electricity, then I will pass an even difficulty.
Yes.
I
come with a clean hand. This is a 6-month order.
No, can you allow me?
Not challenge the order.
No, this is not in this order. No order against me. Can you allow me to place? They are trying to avoid it. Can you allow me to place? Then can you who is cost?
Sir, I've already once the matter is pending before the other court, I am releasing.
Before the this is bench will be constituted. Can you see here? I am challenging, but there are other matters in pending before the other courts.
So
This is not that bench. This is regarding 2017 rules. I am challenging here the act.
What is the matter heard before the other bench?
Other bench, at the same point, there's one order of the Supreme Division bench. Can you see? In the same matter, can you see? Then, my lord, I'll show you.
Milord, may I say this, Milord? Milord, any order in favor of my learned friend's client in this proceeding would, Milord, ultimately, Milord, be something which will impinge upon the Ramsar side. Because my statute may be there, my statute may be declared ultra-virus, whatever it is. But so far as the concern of the Supreme Court that there should not be any unauthorized structure at the Ramsar side, that will get affected.
Ramsar side, that, what am I challenge? The state, all are, they are trying to, can you allow me that I just press it? Then you also can do it. Can you see to the, can you come to the 15? Can you come to the 15, my lord? My lord, can you to the 15, 255, my lord? That time, I am arguing on merit, they will answer it. Then the 255, my lord, for a moment. The division, same point, other public file, division bench says, can you see 255? Court says.
Yes.
The court said, but the same on a public decision file, then there are 255, my lord. Our Chief Justice bench says that let the matter go out of this liberty granted to learned counsel to mention a matter after disposal or repetition which have been filed challenging the virus of the relevant enactment. I just place it, but then my lord, you also can read this. Can you there? But so this is same point. Our High Court passed this order. It's pending. On the urban solution, they filed this public decision. I just place it, but then you also kindly Advocate General, Solicitor General will submit. Can you say urgent? And there's a party there. But what they are saying, I am not the party there. This order, no, report does not include me. I just place it, then only lost it.
Yes. Have you gone through the 9th January order? 9 January 2025.
Which one?
9 January 2025, passed by Justice Tandon and Justice Person.
Yes. Supplementary one?
Go through.
Supplementary one?
No.
No, just it has been handed over.
But in fact, pursuant to this, Milord, I have with my research given a list of maybe around 50 cases. More than yes. Thereafter, Milord, Justice Sujoy Pal, Division Bench, Milord, had directed the Registrar General to trace out all other matters in relation to Ramsar side. But therefore, Milord, what I respectfully submit is, Milord, Milord, intervention in this order, Milord, will scuttle the process over there.
Is also worrying about that.
The Honorable Supreme Court and our High Court was to protect the Ramsar site.
Yes.
Unauthorized construction.
I'm not going to this. Can you see? This is a public interest litigation is constituted. In those matters, my state act has not been challenged. In the other 19 matters, the state has been challenged. So can you allow me that? So this is regarding Ramsar site under new rules. This is not under Ramsar site under the state act. Can you see? I just place it. So this is the new position of law. But can you see? My challenge is the state act.
Correct, but how this code part can be taken?
But these are other. Can you see for a moment? They have not placed. These are matters. I just place it, madam.
Okay, I am fixing on Monday. Let's give the total list. What are the
Yes, we'll assist. We'll assist.
For a moment, can you see page?
They will give the list. You can.
I have here. Order is here. Come to page 200.
Page
200. Madam. But these matter, can you see page 200? These are all the pending matters. Virus has been challenged.
Yes.
Can you see that next page? 201. Since Mr. HON'BLE has already concluded his argument on behalf of the petitioners. Concluded. Then, my lord, can you see? Mr. Kandi, next order, 2002, 2003, my lord. State response is represented by Mr. Bandyopadhyay. Mr. Bandyopadhyay has started arguing on behalf of the state but does not conclude today. On the pair of made in state, let this matter be adjourned and again be discussed on 14. Yes.
So
then
let this petition be heard along with this. Why not?
I
want this matters to be heard by this court.
Yes, but I have mentioned just I guess I am ready. Can you see page 204?
Yes.
Then, so lack of determination matter was released. Now the court has got the bench. Determination, we have mentioned there. I have no, Your Lordship, here, man, all the matters, I have no.
No, not here. I will release. Let the Chief Justice work.
My Lord, he's they are trying to say what I'm trying to say. My Lord, they are saying on the Ramsar side new rules. And what I'm telling you, my Lord, State Act. Can you see? This is not, they are trying to intermingle because to foil my argument. What I'm saying, I'm not challenging the 2070 rules.
Which court these matters are pending?
Now, this matter was heard by Justice Rai Chattopadhyay. All of a sudden, this is not part of my landlord has to come to argue.
Where these writ petitions are pending?
Now I mentioned my Lord got the now determination. We mentioned before Lordship all this matter. So now the bench is not available. So here much is independent matter. I am, can you see, Your Lordship, can you allow me to place it? Then, my Lord, this order, they are showing, my Lord, this is not related to me. This is absolutely non-application of mine. Your Lordship, can you allow me? Well, I just place it, then Your Lordship, can you take the decision?
I am releasing it.
My Lord,
for the Honorable Chief Justice. Honorable Chief Justice.
My Lord, can you see, my electricity will be disconnected. Can you see? Electricity will be disconnected.
Let go before the appropriate bench. Let the Chief Justice, you mentioned before the urgent, before the Secretary to the Chief Justice, he will constitute.
Well, tomorrow is the tomorrow is the day. Electricity. Kindly, my Lord, this order, electricity, this order does not say any. Justice Sinha does not say anywhere. Can you see? This is my electricity.
Yes, can you go to the Justice?
Yes, I show. But this subject before that, before Your Lordship, kindly come for a moment.
Yes.
And come to pay my petition.
Six page.
I come before that, my main petition and come to page 263. Can you come to 263? My main petition. I'm coming to that. I'm coming, my Lord. I'm 263, my Lord. I got a notice.
263.
Yes. Hearing number under notice under section 11 of the East Calcutta Act. The applicant can number 5 in the above number matter raise a complaint against the unauthorized construction in the urban subdivision. So a complaint was given and they asked me for hearing. This is a notice. But this notice in relation to the WPA number 17901 of 2023, the matter which has been, my Lord, referred to. My Lord, WPA number, this is by before Justice Sinha, my Lord, there the virus has not been challenged. Their request was filed for enforcement under the State Act. So this is no virus and no point is there. So when this notice was given, when this notice was given, can you see my next kind of my manifest? I did not appear. Can you see page 265? On 265, I gave a thorough representation and all orders. I said that all the division benches said can you see page 265 to 271. And I said specifically, my Lord, that upon hearing the said, can you see rule at page 269. I have given on that one rule filed the public interest litigation alleging construction building in the housing complex of urban subdivision by encroaching wetland. A copy of the deed petition without any expertise and annexure is enclosed. Then I said, Bholabhai on behalf of the urban subdivision filed the opposition. Upon a said public division bench was pleased to pass an order that this order, I annexed at page 255. That court division bench says that, can you see 255, division bench says that this public will be hard. Can you come to 255 for a moment, my Lord? That this of deed petitions which have been filed challenging the violations of the relevant provisions. Everything I brought to the notice of them by all annexed documents. They said letter, this is not a letter. I given which are all pending because Justice Rai Chattopadhyay said anything. Now, my Lord, one matter, I moved another bench, my Lord, this is for the stay. 256. Can you come to? Same 256. Identical in the same place at 256. I challenge the demolition order in the same place, Jagati Pata in the same
premises.
That's why kindly come to the 255.
255.
You come to that.
Yes.
Let the matter go out of the liberty is granted to the land council to mention the matter.
Till this were the retribution which have been
the relevant rules.
So
enactments.
till this was my lord, that matter was heard by Justice Rai Chakravarti.
Correct.
Then my lord, this new matter at page 256, same identical matter. I got the stay. This is 256 in the same area, same Jagadipatha. There's an order of demolition. Court gave the stay, and this is still extended. And Justice Hina extended it. Can you see page 256 of order passed by Justice Sarkar? Same demolition order on the same rules, and this question has been raised. And they have not filed affidavits. They stay, my lord. I brought everything to their notice. And can you see?
Correct, that's correct.
And 260, can you 260, my lord?
Problem now, this court, how this court can once.
Now you also can no, but because electricity, I'm coming in. Can you see, my lord, I brought it. Now this order was challenged, 30 days was given time. By this time they asked for electricity connection. Now I can come to supplementary. Can you see? Can you see the letter of the chief technical officer? He passed the order here. On the same day, he wrote a letter to the no, sorry. Page 4
It's a soft target always. For us also.
No. I do. I get to
Yes.
Sorry, no, this is our. This is page 4. There, the chief technical officer on the same day passed the order.
Correct.
Independent order was passed. That for demolition. When even that was not received, this is communicated to my only landed advocate, not to the petitioner. This is my. On the very same day, he wrote, with reference to the order 6/3/2024, enclosed, Honorable High Court WPA number in the matter of the Shamal Kumar Lahiri, necessary to disconnect a power supply of the following construction. He had, on the one hand, he passed the order for demolition. On the other hand, he has asked the letter. Can you see the order of division bench, single bench? Page 5. Page 5, can you see? From the said report, it appears that 505 complaints are filed alleging unauthorized construction, out of which 403 cases charge sheeted. My case is not here, but because they passed the independent order. I'm not the party in the Shamal. This is a case of the connection of the Shamal Kumar Lahiri. Chief technical, he's a misnomer. There's no chief technical officer. He won and he passed the order. On the other hand, he take the shelter of this. This matter, I'm not the party. There's no specific order for this kind of supply electricity in my case. But they have taken benefit of this. You also stay this one only, at least.
Okay. That's all.
But you also, even a party, and see, my management can say, out of these 505 complaints, I'm not there. My case is independent. That is, they have passed the order, notice has been given.
Okay. Yes.
Today, my lord, the interim order which my learned friend is seeking, my lord, if that interim order is passed, then, my lord, it will militate against another order of this court, dated 6th of March 2024.
That is not there.
No, 6 months, this is not, I'm not the party. My lord,
may not be a party.
Advocate is trying to intermingle. Can you see? This is better. My lord, what I'm my submission.
The situation is the same.
No, but I'm not party there. This is not arising out of this. I'm an independent order, my lord. Can you see? If this court says,
what will happen to the other matters? You satisfy this court whether pending other matter before the other court, can this court pass an order?
Well, I mentioned the matter day before yesterday.
Where
the
you
bench had
mentioned?
Justice Rai Chakravarti, my lord. And my lord,
How you mentioned the Raja? She's not here.
Oh no.
She's not here.
Thursday I mentioned. Thursday mentioned was there, but bench is not available. Because I concluded my argument there. The question varies. Advocates.
So you do one thing. I am fixing a matter next week. You ascertain from the Secretary of the Chief Justice whether it has been assigned. It is not assigned. See that.
Yes, and the electricity not to discourage electricity, my lord. This is a 50 to 5,000 people, 15,100 plus, my lord. And is a
why the illegal construction?
These are not illegal because before act. But I show you, my lord, this act does not. Act is absolutely, my lord. I saw my place, people lordship in the thing.
Act is bad.
Milord, my learned friend in that case should produce his sanction plan.
That I'll produce. I have.
6/3/2024 order records that
My lord,
they are unauthorized.
Unauthorized,
And there is no appeal carried from that.
That I'll show. My lord, this is about my I know that they can raise this question. I brought the affidavit. I brought the affidavit of this.
Petitioner has filed the present application challenging the challenging the amendment as ultra virus to the article challenging the provisions of East Kolkata Wetland within bracket Conservation and Management Act 2006 as amended are ultra virus to the Article 253 of the Constitution of India and allied prayers. Full stop. The petitioner has filed supplementary affidavit disclosing the notice issued by the Chief Technical Officer EAWMA, wherein
complex
the electricity of the petitioners will be disconnected. It is informed by the advocate appearing for the parties. There are several matters, several connected matters are pending before the other bench, and some of the matters have also been taken up for hearing. Full stop. Full stop. In view of the matter, the petition is directed to ascertain how many matters are pending and which benches is pending, and to inform this court on the next date fixed. As the petitioner has challenged the virus of the act of the amendment, in the act, and this is to be heard after on affidavit. But in the meantime, the authorities have issued the notice for disconnection of the electric connection. On the other hand, the learned Advocate General has stated that the order of disconnection has been issued in terms of the order passed by the bench of this court, WCA number 17901 of 2024.
So Justice
of March 2024, and the said order is not been appealed against, and thus this court cannot pass any order for restraining the authority for disconnection of the electricity. Per contra, learned advocate appearing for the petitioner submitted in the said case the petitioners are not the parties, and the 505 complaints which is mentioned in the said order, the petitioner is not in the said 505 persons, and as said the petitioner has not been given any opportunity for disconnection of the electric connection. Considering the above, this court find that in the order dated 6 March 2024, the petitioners are not the party, and now the petitioner has filed the present application challenging the virus. But it is found that the several other connected applications are pending, and the application is to be heard on merit. Considering the above, this court find that for the time being, till the next date of hearing, the respondents are restrained from disconnecting the electric connection. Let the matter appear on 4th of December 2024 to assert, and the petition is directed to file the list of the connected cases pending before the with the appropriate bench, so that appropriate order can be.
Can you give me liberty?
Matter appear on 4th of December.
Well, CAC is not the party. Can you give me liberty to file the CAC? CAC is not necessary party, but proper parties now. Can you give me liberty to?
The petitioner is given liberty to add the CESC as party respondent in the case and to serve notice upon the CESC.
But the Lordship will kindly keep the liberty open to pray for vacating on the next date.
Yes,
this interim order is only passed only for the interim measure. The authorities, any of the parties are liberty to take appropriate step vacation of the interim.
I'm grateful.
Now we'll go and outside the friends.
But only one thing. No, not on merit, not Javeda. There is a This is before the court of law, the learned advocate general and my learned senior friend also has targeted me as a soft target.
No,
He's always a soft target.
He's a very sweet person, my lord.
That is good. Some person should be a soft target.
Yes.
If all the will be the hard side, then it will be a
sweet person.
Yes.
Your Lordship, before my learned friend starts, I have no problem with the starting the matter today. I've just got briefed at 12 o'clock. So I can be allowed to respond on the another day. That's all I wish. Otherwise, I have no. Because I've just got it today. So no, they have served, and I know for a fact that it was matter we were served. Even
Yes.
Then your Lordship.
I'll leave it upon your Lordship. Your Lordship, I'll be peaceful, or we can do it tomorrow if your Lordship.
Not tomorrow. Please. Thursday, Friday, please. Please. I really, there's some personal difficulty tomorrow day after. So
If your Lordship, he's wanting Friday if your Lordship permits me to. I am ready. It's just that whether your Lordship hear it out piecemeal or you want your Lordship would like.
It is better the one day it can be finished.
That's what I thought.
Friday क्या fix है? Friday देखो. One person will be very happy if this case is adjourned.
He's next.
Fix, na?
I'm just keeping a proposal to my learned since he's appearing and he is very prudent. But on the face of it, this order appears to be contrary to the contract. If you can give us another chance, we are ready to move.
Your Lordship, I will take instructions. I'll take instructions. I'll take instructions.
Then we have to go back again for taking instructions.
No, I will take instructions.
कब खाली है? 2 बजे कोई खाली है? कौन सा डेट में खाली है? दो बजे 3 बजे. How much time will take?
15 minutes. At least for me.
With that contract.
The contract
Insurance.
consideration is completely due on the contract. As an authority, they should act fairly. That is my submission.
I have to actually.
Monday 2 p.m. Monday नहीं है, fix नहीं है. Monday
2 p.m.
24. 2 p.m.
Yes, very much.
Though the matter is specially fixed today at 2 p.m., but due to personal difficulty in London Council for the respondent, the case is adjourned. Let the matter appear on 24th November at 2 p.m.
Your Lordship, the affidavit service may be taken.
Affidavit of service filed by the petitioner be kept with the.
I will be much. Much of that.
Item number 30 password.
Two petitions.
They are the two badminton players who are under the West Bengal Badminton Association. They have been suspended for 6 months. Not on some news.
Mr. Majumdar has given a proposal for sending the matter to the executive committee for deciding and take appropriate decision.
But my suspension, if I may be proved guilty. Only
take a decision within fortnight, within 2 weeks, whatever it may be.
Yes, my lord.
Registrations for the tournaments have started. So, this month, huh?
1st December tournament registrations have already.
1st December tournament, the registration has started already, and the last date in one is 24th of November. But all I may, just to cut short the matter, my lord, I do not mind going to them. Only thing, my lord, they might after that hearing or after the inquiry find me guilty, might find me not guilty. But may I participate in this? If I am found guilty, they can always suspend me.
So what will happen to the, if any,
My lord, yes.
No, they can suspend me for 6 months thereafter also.
no, if you have played knockout tournament, whatever it may be,
No, my suspension may be from a particular date. I suppose my lord, the tournament starts from the 1st of December.
when the tournament starts,
But I've indicated that, my lord. Your lordship would kindly have a look at page 68. I've indicated that. This is the difficulty why, my lord, I was mentioning for, my lord, upgradation, my lord. Kindly see page 69.
this not in 22nd December.
My lord, there are time.
No, date of tournament is 11th. Date of tournament is 11 December.
Tournament is 2nd December.
And my lord, the last date of receiving entry is 1st November. Drawing of fixture is 25th November.
So that is, my lord, 1st November is already, my lord, expired.
No, date of tournament or 2nd to 6th.
My lord, now there's one more, page 68. Your lordship would kindly have a look at the previous page, 68.
Yes,
My lord, the revised dates are 22nd to 28th November.
correct. No, December.
December.
Yes, 22nd December to 28th December.
Yes.
The schedule is as under.
Yes, my lord, my humble submission is, my lord, the concerned state where the badminton players had gone for a tournament have issued an email saying that things were blown out of proportion. Their own email that sorry, things have blown out of proportion. I shall trouble your lordship with only that document, nothing else. So, my lord, in that fact,
Dispute regarding that documents, my lord. The person who has issued the note mail, that person has not made a party in these proceedings.
no, I am not claiming any relief against him. That is the Jharkhand.
Yes, my lord.
Authority.
They consume alcohol. There are specific, and where there are under 17 female players are also there. In that place, the both of the petitioners consume alcohol, vomited, created loads of ruckus over there, and the hotel management wanted to file an FIR against them. We just intervene and stop them. And there's a specific code of ethics, my lord. The what says that you cannot do that thing. If you do this kind of things, then there is, my lord, the authority has the. Oh. My lord, I'll read by Mr. Shiva.
My lord, page 56, if my lord is pleased to take a look at. This is an email of 7th of September.
Yes.
They have not made a party to them.
I wanted to take a moment to clarify my earlier response regarding the recent incident involving some of the players. Upon reflection, I realized that I may have overreacted in the heat of the moment without fully understanding before raising a concern. There was certainly some miscommunication at the time, which contributed to the confusion and escalated the matter more than it should have. While a complaint was received from the hotel, in the hindsight, the situation may not have warranted the level of concern that was initially expressed. I accept responsibility for not taking a step back to assess things more calmly before responding. The players involved, to the best of my knowledge now, did not engage in any serious misconduct or create significant disturbance. Given this context, I believe they deserve a fair chance and should not be judged too harshly based on this incident alone. Moving forward, I will ensure to handle such matters with more care and ensure all sides are heard before drawing conclusions. I appreciate your understanding and hope that the players can be given benefit of the doubt in this instance. But just two things. There was no written complaint against my clients, my lord. At least we have not been given with that. We have not been permitted any opportunity to show cause. That why, what happened, give any reply, nothing. Straight away, suspension. On receiving some oral complaint. My lord, I am not shying away from any proceeding which they might initiate. I will, definitely I will have to. But all I submit that at the end of the proceeding, they might find me not guilty. Then this suspension would end up me losing a few tournaments, which will be a scar in my career. But if
So
they find,
that's why I'm asking when it starts from the 2nd December.
yes.
Correct. Today we
Yes.
are on 17.
But the registrations are an issue also. But
Okay.
if I may,
Okay, register may continue. You may register your name. That's subject to how soon you will complete the inquiry.
10 days.
well, but only one thing.
Two-tier dispute redressal forum. One is
I
the
have a right of
disciplinary
appeal.
committee. He has a right to prefer an appeal to the arbitrator also. Now, not the allegations were severe. When in a drunken state, not he vitiated the entire hotel atmosphere in the midnight. So, not we had to send our representative from Kolkata to Jharkhand in the morning of 7th. Now, I'm not under whatsoever circumstances this email might have been engineered or not. He is not a party to the proceeding. But this is an interim suspension pending a final decision by the disciplinary committee. But this is regardless of the fact that we are not a state or amenable to jurisdiction.
So, which committee? It is, you have
Sir,
made a party here.
West Bengal, the incomplete code of ethics has been enclosed.
Where is the suspension order? Where is the suspension letter?
Yes, that's at page 55.
Starting page 70.
There's a screenshot we have got, my lord.
It's a whole code of ethics.
And we have not been communicated the suspension also. This was published in the website. So they are not communicating with me, either show cause or suspension or complaint. Nothing has been given to me.
Write a copy down. Constitution down. Lordship will kindly have a look at the bylaws.
Our inquiry and their reply, page 67.
Yes.
Please come to page 5. Misconduct and to deal with. That's rule 12. Now down below that page.
Yes, yes.
On the basis of any complaint being made from any quarter or based on any report or on its own motion or suo motu, the council may initiate disciplinary action against any of its office bearers, authorized representatives of council members, so and so, players, it also includes the players, relating to or arising out of any issue of any act of indiscipline or misconduct or which is prejudicial or detrimental or tends to be detrimental to the interest, reputation or functioning of the game of badminton association, its officials or endanger or tend to endanger so and so. Please come to clause B. While the council shall forthwith refer the subject to the disciplinary committee for necessary redress, it may also, based on gravity of the charges and having due consideration, prima facie suspend the concerned person or even the member or impose any other interim sanction till final decision of the disciplinary committee, which shall make best and sincere endeavor to complete within 6 months from the date of reference. Please see, not the clause C. While the decision of the disciplinary committee shall be final, but in the event the disciplinary committee recommends removal or expulsion of any charged office bearer or authorized representative of a council member or a member, the same shall be forwarded to the general body through the council for final decision. The council shall forthwith cause issuance of due notice to the concerned member or person, along with the findings of the disciplinary committee, calling for reply within specific time frame, which shall not exceed 15 days, and also notify the date of the convened special general meeting. The members of the general body present and voting in the convened special general meeting shall take final decision through the simple majority after giving reasonable opportunity of hearing to the concerned charged person. If the charged person fails to attend the convened special general meeting, the subject issue shall be decided based on records. Any agreed person may prefer an appeal against any decision of the disciplinary committee or the general body adopted in terms of C thereof, as the case may be, before the arbitrator in terms of Rule 16. The decision shall be binding, and so and so.
Yes.
Lordship may direct this process to be expedited.
My lord, I am relying on a judgment of a coordinate bench which suspended without anything a player from the West Bengal Bridge Association. There was a suspension without any opportunity to show cause or give a reply. That was quashed, holding the writ petition maintainable. And my lord, I'm not shying away from the disciplinary proceeding. But what is my grievance today is, if they find me guilty, I will be suspended for 6 months or whichever period it's provided. But immediate suspension without permitting to show cause, that is violating my fundamental right. That is my
punishment. This suspension is not by way of punishment.
Kindly seize this judgment. Our copy.
But they had different rules.
Petition is playing. Member of
Alternative remedy কি কিছু নেই. There is alternative remedy.
pension.
Where is in your bylaws the suspension?
Please come to page 6 once again.
Yes.
Clause B. While the council shall forthwith refer the subject to the disciplinary committee for necessary redress, it may also, based on gravity of the charge and having due consideration, prima facie suspend the concerned charged person or even the member, or impose any other interim sanction till final decision of the disciplinary committee, which shall make best and sincere endeavor to complete within 6 months from the date of reference.
Where from here, right?
But please see, consider page 6, clause B. The pagination is down below.
Yes.
Now, please see that interim suspension provision vis-a-vis the punishment imposable under Rule 13.
Yes.
It has a heading of termination, suspension, removal of member by resignation or dissolution, cessation of membership due to default, for breach of any of the duties enshrined in Rule 11 or misconduct under Rule 12 or otherwise. D. The council, by exercising powers under Rule 12b, may suspend any member from participating in any of the affairs and events of the Badminton Association or impose any interim sanction until final adjudication.
This, subject to correction by my learned senior friend, would possibly be a member of the society, perhaps, subject to correction.
It says person.
Because it's a suspension of a member. Kindly sees, while the council shall forthwith refer the subject to the disciplinary committee for necessary redress, it may also, based on the gravity of the charge and having due consideration, prima facie suspend the concerned persons or even the member.
Or even the member.
Yes.
Person is
Similar
qualified
here,
by clause A, which also includes
here
players.
is no. Why I say, because this really defines a player. M. Remember, Rule 4M defines a player. So here I do not find any player to be
No, please see the last line at page 5. The last line encompasses players also.
Yes, that is why I'm saying that Rule 12 mentions players, but when it comes to B, the players is not indicated. Subject to my lord's kind interpretation, my lord, perhaps this immediate suspension of a player is not contemplated.
It affiliated clubs and players under the aegis of the
Yes, so your lordship will kindly pause here for a moment. It mentions a member, it mentions a player, coach, umpire. So when both member and player mentioned here, then your lordship, if comes to B, clause B, it does not specifically mention the player. It mentions member or other charge persons.
Concerned charge person.
Yes.
The concerned charge person cannot include the player because everywhere the player, because Rule 12A, he already stated. Kindly see the rule on the basis of any complaint being made by the quarter or based on report, motion so modo, the council may initiate action against any of the office bearers, authorized representative of the council members.
But perhaps disciplinary action has not yet been initiated, perhaps. No. Subject to correction, it has not yet been initiated. So they have not yet
members and
subject to correction.
And the players under the aegis.
Yes.
So player continued. So here other persons, whether the charge persons will not come. Concerned charge persons. So suspended with the charge of some allegation.
There is no charge till date. There is no charge till date. There is no disciplinary
no charge allegation.
Allegation is there, but there is no imputation of charge. Nothing is there till
charge will come in the disciplinary
process. So, what I was saying is, if I am suspended today and they find me not guilty later on, they might find me. But then, my career would be affected. But if, kindly see the balance of convenience, if they find me guilty, then they can always, suspend me on and from that date for a particular period.
Suppose your suspension is been installed and you have been allowed to participate.
Yes.
Tomorrow it is found that you are guilty. And what you have participated in the knockout tournament, whatever it may be, what would be the effect of
this
that?
Is not an allegation of some drugs or any other banned substance being taken.
I am not that.
So then that would be...
Side, you are telling them that you come to the second side, if you have been allowed to play the tournaments till the decision and before completion of the tournament or at
And
the
I can serve that 6-month suspension later on also. I am only on that.
and that
But
period
if
you have been, because there is a charge and that has been proved.
yes, then
discipline him to
if a charge is proved, then that suspension I can be directed to serve later on also.
So
But now
if you
today,
take the decision within 10 days, then the appellate again.
then the appellate authority is there. I am losing these tournaments.
Special committee will come.
The arbitrator. Lordship may expedite or make a time frame for
And-
this purpose.
And till date, I have not been received with any notice, any show cause, any charge sheet, any disciplinary proceeding
It's
act.
not a service jurisprudence that he has to issue a charge sheet or right
Nothing.
there.
But if there is some charge against me, I have to
No,
know.
that's why the disciplinary proceeding will issue the charge.
But
to
that
you.
has still not been done. So, now kindly sees B kicks in
But this
only.
somehow resisted the lodgement of an FIR. We persuaded the Jharkhand Association not to lodge FIR.
But B kicks in only when there is a disciplinary committee. But when the council shall refer the subject to the disciplinary committee for necessary redress, it may, based on gravity of the charge, due to having due consideration, prima facie suspend the concerned charge. So, the initiation of a disciplinary proceeding, in my humble understanding, subject to hearing my learned senior friend, of course, would be a sine qua non for imposing this anyways. I have not been served with any notice with regard to disciplinary proceeding. I do not know whether they have initiated.
Please have a language, look at the language of B. While the council shall forthwith refer the subject to the disciplinary committee for necessary redress, it may also, it means the council. Based on gravity of the charge and having due consideration, prima facie suspend the concerned charge person. So it's an interim suspension pending a disciplinary proceeding. It's like that.
But where is the suspension order?
That's at page 55.
In case of the officer or another officer would impose similar during the ongoing.
And I do not know which council had taken the decision. The date is, my lord, 2nd December 2011. Kindly see page 55. I do not know which members of the council have signed this. I have not been served with any notice. I found this in the website. They are not serving anything to me. And who has signed this? I do not know. My lord, there is nothing else here.
What is following the decision was taken in the council meeting 2nd December.
But this was the decision taken, this was the date on which it was incorporated. The provision is quoted.
Okay. And who has suspended? Who has suspended?
But the council.
Where is that?
That note we can produce. That report. If the
Everything is behind my back. There is complete violation of natural justice here. No complaint, no copy of the complaint given to me, nothing given.
Copy of the complaint is not required to be given. But this is the report on the basis of which the decision was taken.
This also I have not seen.
But all these will be furnished to him at the hearing.
Man will kindly see the third paragraph. It's a complaint from Sri Pravakar Rao. This is the concerned gentleman who had issued that email.
The incident
Subject to
occurred,
correction.
Incident occurred on 4th of September. 5th of September, we had to send representatives from here to Jharkhand to assuage the situation. We persuaded the Jharkhand Association not to lodge FIR. Then they were called back to Kolkata.
ওখানে স্যার আন্ডার 18 বাচ্চাদেরও ছিল যেখানে ঘটনাটা হয়েছে।
नहीं लिखे डेटास
Mr. Majumdar, I am staying the suspension order, issue show cause notice to him. They give the reply and disciplinary proceeding be initiated, and whatever the action be taken, if found the guilty, the appropriate action will be taken.
Only one thing, not this suspension, if your lordship will kindly take.
Because if you see, it was done in the hotel, not in the ground or in that.
Oh, please see, during the tournament.
Correct. During the tournament, the room was provided in the night. They have taken the alcohol and vomiting, and they have not vacated the whatever it.
Not there were other 18 players not who were disturbed, and not as a result of which they were in the process of lodging an FIR. Now please come to the language of that rule 12. There were women players in the hotel. Players, coaches, umpires.
Correct.
Now please see, relating to or arising out of any issue.
The problem, you have suspended for the 6 months, but until that you have not issued the notice for the inquiry.
No, please see the date on which the writ petition has been filed after 2 months. Now please see the first line of page 7, page 6. Relating to or arising out of any issue of any act of indiscipline or misconduct, or which is prejudicial or detrimental or tends to be detrimental to the interest, reputation or functioning of the association.
Correct. Correct.
Not somebody is called in, not we go in the morning of the subsequent day. We try to retrieve the situation by persuading the president of the Jharkhand Association not to lodge FIR. But what amount of ignominy did you have to face? Along with the under 18 players, girls staying there.
But you are suspended. 2 months has been passed. You are not issued any show cause notice.
That's what I am submitting.
Not issued the show cause notice, and tournament is going to be.
Not show cause notice is not required to be issued in cases of.
But how then disciplinary proceeding will initiate without the notice? How he can know about the charge?
Intimate thing that on so and so date you have been alleged of this. What have you got to say of this? It is not a regular service inquiry.
Maybe, but he has to a normal procedure is to be followed.
Kindly expedite the process.
Other.
First of all, do we have the power to suspend him by an interim arrangement or not? The answer has to be in the affirmative by reason of clause B.
Because B, if you B kindly come to the B,
yes,
12B, okay, suspension. The subject matter, subject so having considered suspend the concerned manager. But now we come to 13B.
Yes.
13D. The council exercise the power 12B may suspend any member of participating in any. Here is no concerned person or player.
No, please see. The council, by exercising powers under 12B, may suspend any member from participating in any of the affairs and events of the West Bengal Badminton Association, or impose any interim sanction until final adjudication.
Correct. Where is the player?
But
where is concerned? Member is a member.
Please see Rule 25.
Yes.
Every player shall be compulsorily required to register with the association every year through respective affiliated members by payment of registration fees. So and so. No player shall be permitted to participate in any event of the association and shall be treated as unauthorized player. To register with the association, applications in prescribed forms with detailed particulars and valid, true and correct documents, amongst others true certified copies of birth certificate and photograph, shall have to be submitted through respective affiliated district member along with the payment of registration fees per annum as may be determined by the council from time to time. In the event of failure to register or renewal within the time specified, registration may be permitted till 31st December of the same year.
Correct.
Junior players in age group categories may have to undergo required medical tests. Transfer of players from one district to another district, then inter-district transfers. No player shall participate in any unauthorized tournament without prior permission in writing. The player shall always either in any arena, court or otherwise maintain strict discipline and maintain so and so. In addition, that same clause H, the association shall have the power to inquire into the conduct of any player under Rule 12 and to take such disciplinary action as may be deemed necessary. In addition to the existing guidelines, code and regulatory provisions, the council shall from time to time may frame required further regulatory guidelines and regulations which shall, on being uploaded in the website and informed to the districts through circulars, shall govern and bind the players and others relating to playing and participating in any event or otherwise.
Yes, the association shall have the power to inquire into the conduct of the player under Rule 12.
Yes.
And to take such disciplinary action as may be. Yes. But with regard to the how the suspension 2 months has been passed, now 6 months you are suspended.
No, the 6 months is the time for the purpose of conclusion of the disciplinary committee's role.
Correct.
So, my lord, that suspension
started.
So that's why it was mentioned that 6 months being the outer time limit, it could have been passed there. But it can be earlier also. If your lordship today directs the disciplinary committee to conclude this action within 10 days time, or say 7 days time even, this can be concluded.
And what will happen to then arbitrator, then your special committee, if you find that yes is permission, then the special committee has to be constituted.
No, the appeal to arbitrator, not
no, arbitrator before.
That's only for the purpose.
Committee finds that he has to be suspended, he has to be removed, then it has to be placed before the special committee.
Yeah, only in cases of expulsion or removal.
Correct.
No, that's not probably not. We are contemplating something which is not yet seen the light of the day.
Correct.
No, two other things. Why the suspension ex facie is bad. Kindly sees the suspension at page 56, 55. This is from the website I got. I got to see this on 5th of September.
Correct.
Well, there is no date mentioned here, but kindly takes page 57, which is my letter of 17th of September to the association. Paragraph 1. Second line. At page 57, I am constrained to address you regarding the order of suspension dated 5th September 2025. I had seen that in the website, so I written this on 17th. Kindly see the date of this document which my learned senior friend handed over. Signed on 19th September. They did not have any authority on 5th September to suspend. This is signed on 19th September.
That's a report. There's a report.
No, there is no suspension order of 5th September.
Prior to that, 5th September is a complaint.
There is no suspension order. I'm only on that. There is no suspension order as on 5th September 2025. This is all which they have handed over. This is signed on 19th September 2025. That is A. B. Your lordship would also find from this that there is no reference to initiating any disciplinary proceeding either in this. They are sitting merry with me, with suspending me without giving me notice of suspension. They put it somewhere in the internet, but as on 5th September, there is nothing.
Please see the caption of this document, what my learned friend is writing. It's a manager and coach's report on the...
Yes, there is a suspension order of 5th September. There is nothing.
Suspend him?
There is no suspension order as on 5th September. How could they suspend
me? Report as to what happened from the
How could they suspend me? If I may ask this question to myself, how could they suspend me on 5th September?
No, Mr. Majumdar, how this suspension order is issued? Where there will be a decision. Who has taken the decision?
So that's uploaded in the website as per our.
That uploaded is
yes.
Uploaded might be, but there will be a document in your file.
Yes, that file we. Of course, no, that we can file and copy it.
Now they will create
file time issue. No, petition annex करनी है तो half baked annex करें.
How this decision you hand?
But I'll hand up to first thing in the morning. I shall hand up the decision tomorrow.
But if that document has not seen the light of the day till, your lordship will kindly not permit any other document to be given right now.
But he has come up with truncated documents.
I don't have documents. They are not serving me with any.
So who has signed?
Which document?
The suspension order who has signed?
I do not know.
So that's why you want. How
this is only from the website. It seems nobody has signed.
Who has signed and who has issued? How the decision is
taken? That's recorded.
They might tomorrow produce something signed.
Suspension is different thing with regard to the decision is different thing. Suspension also some.
Yes, there has to be a recording in the
recording.
File. Yes.
Some recording. You received the complaint and found that they are serious and let it be suspended and disciplinary proceeding can be initiated. 4 lines. But where is that? This does not find this document also did not find anything on that.
No, this is
only the organizer, manager, coaches, so and so. Manager have been suspended. How it has been suspended? By which decision is it has been suspended?
And here also it mentions as per the decision of the council dated 2nd December 2011.
That is
here also
is the
that is
charging provision.
But I do not want to run away from the disciplinary proceeding. I cannot. I do not intend to. All I seek is, let me participate. If they find me guilty, minus the 2 months I have already been suspended, they can suspend me from a future date. But I am at their mercy. But my lord, if my career is at stake and these are two young players, if their career is at stake, and my lord, if they're ultimately found not guilty, then this will be a bad my lord, thing for their career. That is all I humbly beseech.
As against these two persons, my lord, we have our reputation pan-India. Now, please visualize the situation.
No, that's why. But
yes, of
court
course.
has
No,
to see
I'll produce that.
procedure also.
Yes, yes. But phone
Not at this stage. I am not going on the merit of the allegation. What the procedure? If the procedure lapse, automatically it's go. If the procedure, then we have to see what
whether
is
the
to be-
person has taken the decision. That's what you're.
That's I want. How it has been taken and when it has been uploaded. So tomorrow it can be taken as a first matter.
Yes, yes. Kindly do.
The counsel for the parties have argued the matter at length. This court finds that nothing on record on the basis of which the impugned order of suspension has been uploaded in the website.
Yes.
Uploaded in the website. The Mr. Majumdar, Leonard Senior Advocate, appearing for the
respondent number 3.
Respondent number 3, prays for a day's time to produce the record to show that by which order the petitioner and the order of suspension has been issued. Let the record be produced before this court by tomorrow. List the matter tomorrow at the top under the heading adjourn motion.
But I file the affidavit of service.
Affidavit service filed by the petitioner be kept with the record.
I'm so grateful.
I am keeping this.
Yes.
And also you take the decision how soon if you find that there is a suspension on the decision, then you come with that.
My lord.
Yes, next.
কেউ নেই 58 না 50 15
Response number 6.
হ্যাঁ
My lord, in this matter, Manoj Malhotra appearing for the respondent number 6. He's not come to the personal difficulty, my lord. Kindly make it not today. Only not today.
Who is for the petitioner?
Petitioner, my lord, Mr. Devajiti Basu,
Huh?
senior advocate. Senior advocate, Mr. Devajiti Basu is appearing. My lord, he's online.
Mr. Basu is not there.
online that point
No name is there.
they couldn't
I think there is online.
No.
He's in Odisha High Court, my lord, I think.
He's in Odisha High Court.
Connectivity issue, I think.
So what is the case about?
My lord, I'm
Don't know.
instructed. So just now, so instructed.
কি বলছো what is the case about
Devajiti Basu.
Reserve Officer, Detective Department, not to give any effect. Yes. Not today.
Only not.
Only not.
Next.
Lordship, I am appearing on behalf of the petitioner. Lordship, last occasion, Mr. Learned respondent advocate was to submit that his file supply the all original documents, supply the all documents to us. But still today we have not received a single document, Lordship.
Can you lordship see paragraph 4? That a petitioner state that
paragraph 4
of the petitioner. That the petitioner state that the petitioner went to the office of the respondent number 5 for a copy of the linked deed being number such and such registered book, but unfortunately it was not found. Lordship been writing where it intimated her in 2023. My document is with me, your lordship. With reference to above, it is to inform you that the last deed number such and such is 4387. In paragraph 4 written 4758. That is that we have given the information that that is 4387. Document is with me, lordship.
No, Lordship, we don't have received any document till date, Lordship.
This is my This letter issued by district registrars or 24 Parganas.
Yes. What is your name?
Lordship, my name is Suman Sahani.
Petitioner.
Yes, Lordship.
Santoshi Mahato.
Yes, sir, Lordship.
Santoshi Mahato. Have you not received the copy?
No, Lordship.
Your petition has not received the copy?
No, Lordship. She is available in this court right now, sir, Lordship.
23 December 2012. It was informed it is not the book number 4758. It should be a 4387.
Lordship, kindly see the page number 43 of the writ petition.
43.
Yes, Lordship.
Yes.
They are only intimated us to forwarding letter. Only intimate us.
I am sending you the application so and so. This is 18 December 2012.
Yes,
8
Lord.
December 2012.
This was the dated 8/12 of 2023.
Correct.
This notice was served upon us.
Correct.
Yes, Lordship.
So you are asking only one document.
Yes, only one document.
That is the registered
Nitai-
book number. What is the registered book?
Registration number, Lordship, I'm just.
4758 of
Yes, Lordship.
1989.
Yes, Lordship.
But the authority is telling that that is not the number. Number is of 4387.
We don't have any document.
Any
How
document.
can I know that's the what is the actual deed number, Lordship?
You do
Kindly see the Lordship.
copy.
Kindly
You take
see.
this copy.
Okay, Lordship.
You take this copy, and now you got this. I will record, and you take appropriate step in terms of this.
Grateful, Lordship.
Correct.
Yes,
Anything
Lordship.
further? You go through.
Please, please.
You are the Santoshi Mahato. You are the Santoshi Mahato. Your petitioner, not you. Your
I'm
client.
for the petition.
Your client is a Santoshi Mahato.
Sir, Lordship, kindly see the page number 4 of the writ petition. That the petitioner states that petitioner went to the office, the respondent number 5, for a copy of linked deed. Deed being number 4758.
That's why their contention is that it is the 4387. And you are asking the 4758. What has happened to the 4758?
That is
Lordship.
instruction, but on this point we have no instruction.
Lordship, kindly see.
Your
It is stated, Lordship.
Your letter does not speak that the registered, that will be a book number. So only stated that last deed number is 4387. So that's why 4758, there is no deed.
Yes.
See,
Yes.
the above reference is to inform you that the last deed number registered in the book number 4387.
Yes.
So your
Yes,
number is
Lordship.
not correct.
Lordship, kindly see our annexure page number. Annexure attached P1. Annexure P1.
Page number?
Page number, annexure P1, page number 17 of the deed. Bengali deed.
Bengali deed. 17.
Hmm.
Where is the number?
In the middle of the paragraph, first paragraph, Lordship, see this.
How the paragraph in the deed there will be a number.
Yes, Lordship.
What is this deed? This is a sale deed.
Yes, Lordship, there is a sale deed. Sale deed number is such.
Where is the number?
7.
Madam, the number
Wait,
cannot
wait,
be in
sir.
the middle
Wait,
of the
Lordship.
deed.
Middle of the
Number cannot be in the middle of the deed. Number
middle
will
of
be
the
in
deed. Lordship, kindly see the page number 17 in the paragraph number, such first paragraph, page number line in the
89, yes.
yes, Lordship.
8957.
Not 89, 4758.
758. What is written? What is, you read this? I can't read.
Yeah,
Yes.
It's 4758.
No, the total, the
The
sentence. you
total
read the
rest.
sentence.
Tariq Behala. Tariq Behala.
Go to English, that is English 19 December 1989 তারিখে বিহালা sub register office registerকৃত 1 নম্বর, that is the book number. Book number 1, bearing number 4758. That is the page number, my lord.
But they are
Thank you for coming.
page number, book number 5.
Book number
4758.
Number 1, Lordship.
3 number.
Deed number?
register number.
Being registered number.
Deed number.
Yes, being registered number.
That may be a typographical mistake. Maybe, Lordship, I am not sure. Maybe
Lordship,
a
this,
typographical mistake.
Lordship, may I please?
Yes.
Lordship, this register deed is sale through before my client and Parul Bala. In this BLO, Mohestala BLO office, they are asking for such deed number which is in written here in Bengali portion. So we are asking in the RTA Act, just this deed number is available on your record or not? Lordship, kindly see our RTI questions.
Mr. You do one thing.
Lordship.
You consider this deed.
Lordship.
And page number 17 and the deed number.
Lordship.
To take instruction and submit the report whether any deed being so and so number or book number so and so
Available on the
registered.
Lordship. Lordship, I move.
What is the book number? The 19 December 1989. There is no book number. What is the registered number? Book number is there? No.
Yes, Lordship. Book number, office register number 1 at Bahari.
My lord, it is the thing is, it is the inscription is number 1, Bahir. Bahir means outside. Whether it is book number or not, that is not being referred. It is being number 1
Page
that
number
has been
such and such.
specified. But now in our normal thing, what you get to see is the book number and the page number.
That's a book number.
Yes.
Page number,
field
book
number,
page number, and serial number.
Yes, your lordship.
These are the three is required.
3 things which what you usually get to see. But this is an old version of the thing, 1989. And I believe searching has been.
The grievance of the petitioner that the petitioner has made an application under Right to Information Act to obtain report with regard to deed being number 4758 of 1989 dated 19 December 1989, which is mentioned in the this is deed of registered and this is also registered deed.
Yes, Lordship.
Page number 16, 13.
Registered deed, देखो ना.
13 to 7, 19 to what you are mentioning, 13
Yes,
to
registered deed.
in the registered deed dated
Sub-register.
15th April 2016, registered before the district sub-registered -2 Alipur South 24 Parganas, being registered number. What is the book number? Here also where is the number? Being book number 1, volume number 1602-2016, page number 119866 to 119889, being number 160204153 for the year 2016. In the said deed, at page number, which page number? Deed page number?
Page number 70.
No, deed page number.
Deed page number is not there. Page number is
4758.
No, this page number.
Page number on top of deed number page 3. Bangla deed page number 3.
3. Within bracket page 17 in the present deed application. Present application in paragraph 1. The deed number is mentioned as 4758 of 1989, dated 19 December 1989. Accordingly, who is the respondent number?
Respondent number, Lordship,
4. Who will, district registrar?
50 register.
The respondent number 5.
Respondent number
Uh,
five.
six,
Huh?
No, no.
6, Your Lordship.
Additional district.
Additional district registrar.
The respondent number 6, comma, the additional district sub-registrar, Behala. Additional district sub-registrar, comma,
Additional
Behala.
district sub-registrar of
24
Behala.
Pargana.
Respondent number 6.
Directed to submit report. To submit report by ascertaining the deed number mentioned in page 17 of the present deed application, whether such deed is registered before, whether such document is available in the, this is also the same office.
Yes, Lordship.
Yes, sir.
Available, if it is available, comma, the said document, copy of the said document be produced before this court. Let the said report be filed by how much time?
2 weeks, Lordship.
By
Lordship, may I Lordship, also add in this order, Lordship, kindly provide also Nitai Bhomik in the name of sale deed. Lordship, kindly see the page number 42 of annexure.
Lordship, in my report, kindly also consider 4387 is the last registration deed, Lordship. Thereafter, there is no registered documents available. My learned friend is bringing 4758. This
Lordship,
is not fair. That is not registered.
Lordship, I am also asking to them
typography
whether or not Nitai Bhomik, son of late Sannyasi Bhomik.
Let's know, I will come with the
Lordship,
report.
I also asking to them because in this
respondent
file,
number 5 is also directed to submit
because this Lordship, kindly see the page number 17 of the annexure.
whether deed of ownership of Nitai Bhomik, son of Sansi S.A. and N.A.S.I. Bhomik, resident
with the last number.
resident of P.S. How, what is the information you have? Kindly see what you ask for.
Lordship,
Which question you are asking?
Lordship, kindly see the
Page
page
42.
number 3 only, Lordship.
Question.
Lordship, I am asking for page number 42 of question of number 1, RTI Act, whether or not Nitai Bhomik.
Just a minute. No, okay, then also direct to submit the report whether or not Nitai Bhomik, son of Sansai Bhomik, residents of Mahestala, is the owner in relation to the property. Again, the property mentioned in the registered deed number 4758 dated 19 December 1988 in the office of the additional district sub-registrar Behala, South 24. Okay. Let the said report be filed on 5th of December 2024. Let the matter appear on 5th of December 2024.
Grateful, Lordship.
My lord, in this matter, I beg to appear on behalf of the petition.
Yes.
My lord, is kindly see the previous order passed by the Honorable Justice Amrita Sinha, as well as your lords. Since, my lord, this, in spite of, my lord, the admitted amount, which has been withheld by the authority. My lord, there is a specific direction. I have completed the work. Successful certificate has been issued. Bill has been prepared. My lord, this kindly see. I am placing my case, my lords, pursuant to the work order, page 11A. My lord, got mine? So, my lord, the construction of.
Yes.
Where is the report?
My lord, I think personal appearance is very much required.
Huh?
Personal appearance of the concerned members from the video department is very much required. On last occasion, we have been apprised that they did not found the papers. I informed them over telephone that a clear report is required in the form of an affidavit. I have conveyed the content of the order of the last order. I have been assured that I will be provided with the necessary documents. Now, all of a sudden,
I've been over telephone, I've been informed that there is a dearth of fund. That is being the reason we are not able to send any report.
Dearth of
funds. Even for that also a report is required. My lord, I am totally handicapped. I'm not being served with any report, my lord. I think this is a situation that demands personal appearance, my lord.
By an order dated 19th of September 2025, this court directed the block development officer. Which area?
Mathurapur 2, South 24 Pargana.
Block development officer. Mathurapur dash Roman 2. Development block, comma, Bakultala district, South 24 Pargana. To file a report by way of affidavit. On the next date fixed. The matter was taken up for hearing on 4th of November 2025. On the said date, no report was filed, and according learned counsel appearing for the state pressed for time to file report. Accordingly, the time to file report is extended till today. Today, when the matter is called, this court found that no report has been filed. Full stop. Learned counsel appearing for the state submit that the matter was informed to the block development officer. It was informed by the block development officer over phone that due to non-availability of the fund, the state is not in a position to release the fund in favor of the petitioner. Full stop. Consider the submission made by the counsel for the party, peruse the orders passed by this court. This court find that the block development officer is reluctant to file the report before this court in spite of several orders and the communication made there to the block development officer. Accordingly, the block development officer is directed to appear before this court through virtual mode on how far it is, how far it is.
Kindly grant us 1 week time. 1 week time,
before this court on 26th of November 2025 at 11 a.m. And also directed to submit the report through the advocate appearing on behalf of the state.
In the meantime,
it is made clear that if on that date, if the block development officer failed to appear through virtual mode and to file the report, appropriate order will be passed. The petition is directed to communicate this order to the block development officer and to file the affidavit of service on the next day.
My learned pen is appear on behalf of the state. He can communicate. He can also.
You are the authority.
He is the officer of.
My bounden duty to apprise the concerned authority, as I did already.
I am directing.
And my lord, I have made a candid submission before your lordship. Grateful, your lordships.
Same order, same pair, same block development officer.
Same order.
Only department. Good.
Grateful, your lordship.
11 a.m.
I am for the applicant. This is a matter regarding Malad.
It record.
This is a very sad story, which Malad, my wife was died, Malad. He is an ISCO employee, Malad.
What is the prayer?
Prayer is that, Malad, my husband, wife, Malad, husband service is Malad under Malad compensation. Regarding death, Malad, which tie up with Malad Bajaj company, Malad. That benefit not done, Malad, by the authority, Malad. Although, Malad, I made several representation as well as Malad appeal. They made rejection that my husband not died natural calamity. That is the allegation, Malad. You should kindly come to Malad. Police report, Malad, regarding.
What you have prayed? Where is the reputation order?
Yes, Malad.
15 July 2024. Where is the order?
15 July.
The order which you have challenged, where is that?
Page 26, if your lordship kindly comes to me.
Page 26, Malad. That is rejection, Malad.
That's why. 26.
226, Malad. 26.
26, Malad.
Yes.
P5. Sujoy Seal, Malad. That is my husband name. District Contractor Welfare Society. There, you should kindly come to Malad. verification of claim documents reveal aforesaid has submitted claim documents to avail death benefit. Under the scope of policy, death for insurance Aspicima following environmental propagation.
showing the, yes. Then
We regretting inform my
it is not covered under the death coverage.
cover for the death due to accident only, my lord.
Yes.
This is a, my lord, purely accidental death, my lord, in the course of employment, not
How he
outside.
died?
They are died suffocation, my lord.
Suffocation of?
Suffocation of, my lord, in the, my lord, factory, my lord.
In the factory.
Factory, my lord. That is the medical report as far as this case is concerned, my lord. And, my lord, I made
Where is the postmortem report?
postmortem report, my lord, that is, Lordship, kindly come to page 25. May I read? I would like to inform you that Sujoy Shil is 39 years, son of Sunil Shil, Mohisha Colony, this, was contract worker, engaged MS Test Metal Engineering under SAIL, ISP plant. He expired on 6/12/2022 at about 11:55 p.m. at Banpur SAIL, ISP hospital. After received complaint from authorized person, Banpur Hospital, Hirapur started a case by Hirapur PS case number Ato. As per endorsement, I took up its inquiry. During inquiry, it came to light that on 6th of December 2022, during sea ship duty, while working at 26 meter at converter floor of BOF department, Sujay Shil felt some discomfort and came to the storeroom for rest. When his discomfort level increased, he was rushed to the OS hospital. Then he was admitted by his colleague at Banpur SAIL ISP hospital, where the attending doctor declared him brought to death. Then I arranged for him PM examination at Asansol district at the hospital. His PM was at hospital PM examination. As per opinion of autopsy surgeon Dr. Subhajit Rai, Asansol district, death was due to asphyxia following environmental suffocation. So that is the, my lord, true fact, my lord, that is the death, my lord. But because of humanitarian and other things, my lord, that insurance authority rejecting my prayer, my lord, without any, my lord, considering my, my lord, prayer, my lord. I made representation before the authority to the manager claims Bajaj Alliance, that is page 32, and also ombudsman, that is page 31. That is silent, my lord, till date, my lord.
Yes.
My lord, it's a personal accident coverage. Death was due to asphyxia. My lord, as far as, my lord, post-mortem report, your lordship asked, my lord, there is no post-mortem report as such. My lord, my repudiation, my lord, I have, may I invite my lord, to page number 26, my lord. Perhaps my lord has gone through, my lord. My lord, we have in the bold letters, my lord, in the middle, perhaps your lordship has taken note of that, my lord, we will pay the nominees so-and-so 100%, my lord, under the schedule having the basic, my lord, wide and comprehensive during the policy. If the insured person meets with accidental bodily injury that causes death within 12 months. That's in the bold, your lordship sees, my lord. And just below that, my lord, again, my lord, definition B1, accident, my lord, that definition is there, accidental. An accident is a sudden, unforeseen, and involuntary event caused by external, visible, and violent means. My lord, none of these causes, my lord, have been hit. Number one, my lord, is death by asphyxia, my lord. Post-mortem report is not there. This cannot be treated as an, my lord, personal accident coverage. Moreover, my lord, my learned friend, my lord, has gone before the ombudsman. Ombudsman, my lord, has, my lord, received his complaint, and thereafter, my lord, till date, nothing has happened. So, my lord, matter is there, and he is coming up before, my lord, lordship.
That is ombudsman.
In the
That I made application before, my lord.
Lord, he has been made a respondent in the cause title, and your lordship, my lord, may I, if I can.
Where is the letter to the?
My lord, page number
31,
page 31 of my lord.
That is the online application, my lord. They are received on 25th of July 2024, my lord.
Ombudsman has been made a party respondent herein before your lordship, my lord, respondent number 5. At page number 2 of the cost statute, Lordship, kindly see. There is a disputed question of facts.
Well, the
matter of
insurance
contract.
authority can do this compensation because Malad, this is a tie-up, not a single policy. And as far as this case is concerned, this is going to be made sympathetically because Malad, but as far as my husband is concerned, he was died Malad in the course of employment at total tie-up with the company Malad. So Malad, my humble submission as far as this concerned, natural justice, fair play also Malad applicable because Malad,
What you want? The court
I
is to
want 15 lakh
The court is
compensation.
decide whether it is accidental or whether
This is
disputed.
the accidental death, my lord. But definition, as far as this doctor clarification, that is
That's
maybe
why there is yes.
that may be different. This is a technical term, my lord. That is violent means. This is my lord, death due to oxypyma following environmental suffocation. This is also my lord, accidental case because my lord, this environmental suffocation, other things, my lord. As per Malad, Supreme Court judgment also several judgment is there, Malad order. Any accidental suffocation, oxygen suffocation also Malad.
While working, he has suffered a suffocation cannot be termed as an accident.
Milord, the definition of
employee, Malad, poor employee.
Let him finish, Milord. Milord, the terms. Milord, the terms, Milord, accidental, violent, and external, Milord, they have been well defined, Milord.
Accidental, an accident is a sudden,
unforeseen and involuntary event caused by
external,
yes, Milord, external, visible, and violent means.
External. So it is external, visible, and violent.
Violent means.
But an accident is a sudden.
Milord, I die right now. It is also an accident.
Correct. That's what I'm telling.
So, but that doesn't mean it is external, visible, and violent, and it would not be covered under personal accident coverage.
It is. Kindly see the accident is a sudden, comma.
Lordship.
It is not and. It is not.
Yes,
and,
yes.
Comma, unforeseen and
involuntary event
caused by external.
Caused by, yes.
By external, comma,
Lordship.
visible and violent. So
Lordship.
if an accident is caused, if he is working and it's suffocation and he died, I don't know. Yes. Yes.
Milord, this definition of external, violent, and Milord, this visible, Milord, Supreme Court has clarified, Milord, what this means. Milord, if my Lord kindly allows me, Milord.
No, whether, yes, what you want. You want this court is to decide.
Yes, my lord. Yes.
You will not go to the ambassador.
Well, I am waiting for last one, and this is a question of bread and butter, my lord. My
State court can decide all.
Read court decide because Malad, this insurance regulatory authority also involved Malad.
Maybe.
So government statutory authority.
If suppose,
yes,
you are entitled to entitled to the claim. How the contempt can be decided by the writ court? How the contempt?
But that is big question.
Not big question. That is to be a.
Lord, may I suggest?
No, Malad.
Since
if
he has referred it to the
regulatory authority is a statutory authority, government by the state central government.
I am referring. Let the ambassador decide the matter. The appeal which you have filed as per the page
31.
31. Sympathetically, Malad, yes, Malad. Within certain point of
sympathetic.
Yes, Malad. Obviously sympathetically, because Malad, I have Malad, father and mother, Malad. They are not Malad. They are Malad 70 years old, Malad.
So this insurance policy is in your name.
My husband name.
That's why it's in your husband's name. It's in the name of the deceased.
Yes, Malad.
The petitioner has filed the present writ application challenging reputation dated July 2024, wherein petitioner has been repudiated on the ground that due to following environmental suffocation, and thus the policy is not covered for grant of compensation. Being agreed with the said reputation, comma, the petitioner has preferred an appeal before the embodies and by on 25th of July 2020. The same is pending before the insurance embarrassment. That is the respondent number 5. This could find that the appeal preferred by the petitioner before the insurance embarrassment is pending. According the petition is by directing the respondent number 5 to consider the representation filed by the petitioner dated 25th of July 2024 and to pass a reason in a speaking order within a period of pass a reason in a speaking order after giving an opportunity of hearing to the petitioner within a period of 8 weeks from the date of receipt of this order. 8 weeks. Giving an opportunity of hearing, pass a reason in speaking order within a period of 8 weeks.
8 weeks. Get put your lordship, my lord. I'm obliged, my lord.
For the state respondents, my lord.
Lordship Learned ASD appearing on behalf of Union of India. Lordship praying for not this week as per his instructions.
My lord, I am appearing on behalf of the petitioner, my lord. And petitioner is the, my lord, widow daughter, my lord, of a, my lord, deceased father who was the holder of a, my lord, freedom fighter position.
Is the unmarried daughter?
My lord, he's a widow daughter.
Widow daughter.
Widow daughter. My lord, my prayer is innocuous. My lord, I have made a representation.
When the mother died?
My lord, mother died on, my lord.
1972, my lord.
No.
2012.
My lord, mother died on 2012.
When you made an application for pension?
My lord,
when your husband died?
Husband prior to my mother's death.
He was a
My lord, 2005.
Correct.
My lord,
and when you made an application?
My lord, I made an application in 2024 itself. But I have made representation to the authority. My lord, annexed my lord, P22, page 49. My lord, 15th July 2024. After knowing the, my lord,
page 24.
Page 49. 49.
Yes.
My lord, after promulgation of the judgment, my lord, pronounced by the, my lord, Honorable High Court at Delhi, my lord, I have annexed also the judgment also. My lord, that is
24 you made an application.
Yes,
after 12 years.
My lord, I have explained the delay also.
Okay. Then,
paragraph 22.
So it is pending.
My lord, it is pending.
To whom you have made the representation?
My lord, Secretary Ministry of Home Affairs, Deputy Controller of Accounts, Principal, all.
Lordship Learned ASD and Mr. Shukumar Bhattacharya appearing for the Union.
Oh?
Mr. Shukumar Bhattacharya also appearing for the Union of India. Lordship praying for not this week for their instruction.
As for the prayer made by the and Council for the Union of India, case is adjourned. Let the matter appear on 27th.
27th, my lord.
Lord, may I file my affidavit of service?
Affidavit service filed with the petition be kept with the record. Yes, next.
My lord, I appear for the respondent bank in this matter.
May it please your lordship, I am for the petitioner.
For the state one. My lord, this is the exception in the bank's report.
My lord, this is a case where the writ petitioner's Aadhaar number and PAN number has been used by some XYZ unknown person to obtain a loan from the respondent bank and then buy a property in Kolkata and then not pay and vanish. In the meantime, while this had happened, the petitioner came to know about this when he had gone to buy a mobile. and he wanted to buy a mobile on EMI. So it was found by the mobile retailer that he did not have any EMI options left because of a very low CIBIL score. And on search, he found he also works in a bank. The writ petitioner also works in a bank. He found that his CIBIL score was so low because of two loans. One loan of 9 lakh, approximately 9 lakh above, and the other one was 29 lakhs from Punjab National Bank. The 9 lakh loan, the smaller loan, was by one Piramal Investments, who had been approached through an email, who found out and said that that loan did not belong to him. The same name, father's name, and his Aadhaar number. When he approached the bank at that point of time, the chief manager asked for his documents from the writ petitioner. Till such time, no proceeding was moved in the debt recovery tribunal or against the present petitioner. On receiving his original documents or copies of them, the bank waited for 10 months and then filed a debt recovery and added the writ petitioner's address in the debt recovery proceeding. In the debt recovery proceeding, my lord, we really don't know, because there has been an order that no third-party interests could be created against in respect of the property.
Contesting in the debt recovery tribunal.
My lord, he has filed a written statement saying the same thing, that I am no person, my Aadhaar number has been taken.
Lodge a complaint.
Lordship.
Criminal case initiated.
The first complaint was filed and an FIR was registered. FIR was registered. There was a second complaint, because at that point of time, one of the first orders passed by Her Ladyship, Justice Amrita Sinha, and an order of certiorari was granted, a writ of certiorari, and we had inspected the documents. It is a clear-cut case. The photographs differed. The Aadhaar, which has been the so-called copy of the Aadhaar, which has been submitted with the bank by the so-called perpetrator, does not have a proper enrollment number on the Aadhaar. It has a different photograph and an address in Howrah, clear address in Howrah, and that is in his application form, which has not been even considered by the state or the bank. The bank has not even started an internal proceeding yet. And the second FIR police complaint was made after inspection against the original chief manager of Punjab National Bank of that particular branch, Great Eastern branch. Even on that point of time, there has been no report forwarded by the bank with the police. My lord kindly passes an order of certiorari again. My lord can inspect those documents in front of your lordship. Everything is clear cut.
So what you prayed for in the writ petition?
Yes, my lord. My lord, I'll beseech your lordship to come at page number
My lord,
15,
I have prayed for
15, my lord. The prayer starts. Their main
page
prayer is prayer C.
15. My lord, there are two prayers. Prayer B, mandamus.
Wanting a respondent act to proceed in accordance with law, take steps to ascertain confirm the actual identity of the person.
Yes.
Who is illegally utilized the petitioner's Aadhaar.
Lordship.
So, and next is application for wanting respondent on the proceeding on the petition.
Lord.
Recovery has been started.
Yes, your lordship.
Lordship.
Under the 1993 Act, my lord, the OA proceedings.
The recovery has started.
They are contesting, my lord, the same averments that they have taken in the writ petition, my lord, that has been taken in their written statement. In my report, my lord, I have annexed that, and my lord, the Debt Recovery Tribunal is in consideration of that report, your lordship, of their written statement.
My lord, kindly take up my supplementary affidavit, kindly.
Yes.
My lord, page 4 of the pleadings of supplementary affidavit.
Yes. So what has happened to the FIR?
My lord, now no steps have been taken.
For
In the last report,
application for identification of the person
one
who you have
identification,
used.
Yes.
my lord,
It is the investigating only.
Yes, your lordship.
my lord, that is there. And there, one requirement is required is that my supplementary affidavit, my lord, the bank clearly knew.
Correct.
My lord, kindly comes to all the annexures of the bank. Annexure, the application on page 12 of the supplementary affidavit. It's a different photograph.
Correct. So what
Different.
the High Court?
My lord, my lord, my lord, one thing, direction is, it can be a nexus, it can turn out to be a Nirav Modi case. My CIBIL score is still down. I cannot access it. My Aadhaar number is tarnished. It has to be, my lord, in a debt recovery proceeding.
See, sir, you have initiated a complaint before you have filed a complaint case before the police authority. You filed a complaint before the police authority.
Lordship.
Police has initiated the case. It might be 468, 419, 420, for whatever the.
That is a later stage. Before,
Let the court complete. Now the police is investigating into the matter. It is the police authority who has forged the document.
Lordship.
How the writ court can say if I will call the document
Lordship.
by invoking the provision of certiorari,
Lordship.
what the court will do?
Lordship, I bow
My
down.
lord, the court, the honorable court, in two occasions can, because since Union of India is also a party over here, the honorable court through 226 can pass a direction or an writ of mandamus directing the bank and the Union Finance Ministry to conduct audit into the bank, find involvement of the bank personals, because these documents, what we have submitted in the supplementary affidavit.
Once a proceeding had been initiated before the one authority.
Lordship.
There's the police authority. If you are not satisfied with the police authority, you have a right to go before the London magistrate where the matter is pending and file an application.
I bow down before your lordship. My lord,
Lordship, that is keeping already, since the police have already registered their FIR. My lord, the police in the last occasion had made a clear before, when they had filed their report, they made a submission before this honorable court that the bank has not cooperated yet. The bank has not started anything. It's a public sector bank. It's a public sector bank.
Who is for the state? Yes. What is the stage of the criminal case initiated? What is the stage of the criminal case?
My lord, my lord, on the last occasion I had filed a report, my lord, it is dated 11th of August 2025. My lord, my lord's last order, the report was served upon the petitioner and the petitioner was to file an exception if necessary.
Where is the report? Where is the report?
my lord, if the report says something against the bank, my lord, then I need to see the report, your lordship. Because, my lord, so far as
My lord-
my instructions are there, the bank authorities
My lord,
are
we have already.
cooperating. Sir, one second, sir. Because, your lordship, if it is case of identity theft, my lord, it is the bank's money, my lord, which is going.
Report
My lord, so cases I can state the report.
My lord, over here, my lord, they had not just disbursed a loan, they have also created a savings bank.
Which date the loan was sanctioned by the bank?
My lord, my lord, I can only.
My lord, that will
That,
be
my lord, I.
the original application.
Yes,
I'm carrying
because
a
when your document was
Yes.
taken into consider by the person concerned, when the loan was sanctioned.
Lordship.
My lord.
9 lakh and 20 lakhs. What are the dates?
9 lakhs. 9 lakhs is not sanctioned by the bank.
Okay, 20 lakhs.
29.
29 lakh. Which date?
My lord, 30th of March 2023.
30th of March 2023.
Yes.
Yes. What their investigation said? 30th March 2023. Who was the manager of the bank?
My lord, one Amit Thakur.
Have you interrogated the bank manager posted on that day, or the officials against whom the case has been initiated?
Lord, again, please.
Yes.
FIR copy to
My lord,
FIR copy to.
the latest situation, my lord, is that during further course of investigation.
No, I am asking one question. On the date when the loan was sanctioned, who was the manager and the concerned officer? Whether any interrogation was done? Give the statement of the witness of the persons who have been interrogated.
on that day whether the manager was called? Who was the
Nothing,
manager?
Lordship, nothing.
Who was the
I
manager?
apologize.
My lord, I have to have detailed instructions.
Tell your officer be ready. I will keeping it. Give the total report from the date of passing sanctioning of the amount till the NPA of the account. Who are the officers? Have you interrogated the persons or not? The bank officers. That subsequently will come later.
Also,
Will come with all details.
My lord may keep it after 15 days. I will, my lord may record.
And I will not allow the hanky-fanky statement. I want the total statement with your CD.
My lord.
Each and every date of the CD from the date of registration until today, what are the CD, date to date CD, and when the officers have been examined. I will see how you cannot be traced.
My lord, only one thing.
Also,
they
my
have
lord,
given the complaint in the year of my lord 2024. On May 2024, they have given the complaint.
Lordship, that is a fact.
After my lord 1.5 years of sanction.
Correct.
My lord, only from the date of knowledge.
This cannot be happen without your officers. Correct.
My lord, if it is a case of identity theft,
If a genuine person go to the bank to obtain the loan, there were so many procedures out there.
My lord, I bow down. My lord, the bank authorities
That's why
have
I
to
want.
cooperate.
My lord,
This has been investigated.
my lord, the state has a copy of my supplementary affidavit where all the photographs, the application, the number, everything is there.
The last report, my lord, notices were served upon all those officers, my lord. And
This,
investigation was under.
this court finds that before proceeding the matter further, a detailed report along with the case diary from the police authority is to be seen. Accordingly, the state is directed to produce the case diary, an up-to-date case diary from the date of initiation of the case till today on the next date fix. Let the matter appear.
Lordship, Lordship, one thing, a senior officer should file the report.
Investigating officer.
A minimum of
Let me see. Let me
Lordship,
see whether the head constable is investigating the matter or the inspector is.
And Lordship, the exception to the report has been kept on record.
15 days.
My lord,
Returnable.
Let the matter appear on 4th of December.
Lordship.
4th of December at 12 noon.
Grateful to your lordship. Much obliged.
4th of December is Thursday, na? 3rd December at 12 noon.
Lordship, 3rd December.
At 12 noon. From the date of registration of the case till today. From the date of registration of the case till today.
Grateful.
Third, I'm grateful, Lordship.
I am for the petitioner in item 22.
I am for the private respondent and the petitioner in item number 23.
Well, my lord recalls, my lord, I am the senior citizen mother.
State in this matter, my lord.
The respondents 5 and 6. Respondent 5 is appearing in person. He is there somewhere. But before the hearing on the substantive issue can commence, I had drawn my lord's attention to the fact that the respondent number 5 has not made payment of the rupees 10,000 in terms of early order of court, the monthly payment. But he has paid for November, but he has not paid for October.
For the respondent number
So
5.
he is appearing in person.
Lord, I am for this.
November has been paid, but not October. This is the bank statement.
17. Where is the October? Where is the October receipt? ये तो नवंबर का है. अक्टूबर का कहाँ है? ये तो अक्टूबर में जमा किए हैं. नवंबर में जमा किए. अक्टूबर वाली कहाँ है?
जो मेल आया था उसमें एक ही तो लिखा हुआ.
सर आपको तो
That was after the last hearing.
कल एक तो मेल आया था उसमें
कल नहीं, that was.
हाँ तो पहले आप जमा किए तो सितंबर का है. सितंबर का.
It is mentioned that October is not paid in the mail.
अक्टूबर का नहीं है. कब पे करेंगे? हाँ?
महीना में कर देंगे.
महीने में कर देंगे.
But then, the other thing, Mulad, this is a recurring thing.
One aspect of the matter.
कल इनका मेल आया था, मेल में
कल मेल का
इनका
कहाँ
नाम
है?
10,000 रुपया देना।
Yesterday we had not sent any mail.
तो कल दिए थे, लेकिन अक्टूबर वाला दे दीजिए, तो नवंबर का दिए।
ये आपको मालूम नहीं है कि आपको
ठीक है, ठीक।
Yeah, the other thing, but if my lord kindly has a look at the order dated 18th September of Justice Sinha.
But it will
But
take time because
the main hearing is some, these are trivial things, but for the petitioners, but there, my lord Justice Sinha had said that the medical bills will be forwarded and will be shared in the same ratio. But I am handing over, my lord, to the respondent numbers 5 and 6, my lord, those bills which I have managed to collect. And
what is your writ petition?
the writ petition, my writ petition is for implementation of the order of SDO. These payments all came after I approached court. Nothing happened in the 8 months' time before the order of the maintenance tribunal and before the time I reached my lord's court. And the respondent number 5, my younger son, has challenged a portion of the SDO's order directing eviction. Then
That was my writ petition. The next one.
whether the SDO has jurisdiction to pass such an order. But this medical bill, my lord, that already there's a direction that it will be shared amongst the two brothers in the ratio of the 10-15 ratio.
Who are the two brothers? You
But this
And my client.
you are the mother.
and Mr. Mukherjee, I'm the mother. I'm the mother.
And who are the two brothers? Four and
Respondent, no, in my petition, they are respondent 5 and 6. 5 and 6.
And I am the petitioner in the other matter, wherein, Lord, if you Lordship
And
kindly-
in this
Again, maintenance.
in this writ petition, I am respondent number 6.
No.
And in the next one, I am the petitioner.
I'm handing over the bills totaling 11,771 so that they can kindly.
So far as the payment is concerned, Lord, that is not an issue. Lord, we are continuing.
I can send a mail also.
And this will be continued. But
Yes.
the question here is, Lord, whether, Lord, that the officer concerned can direct, Lord, eviction under the Act, Lord, in respect of co-owners of the property. That is not a legal question, Lord, that is to be addressed here.
Are they co-owners? The property is in my name.
Mitakshara family, Lord, I can.
Property
explain,
is
Lord,
in
how
my
it
name.
has come. We
Mitakshara
had never.
co-personary.
Maybe, but even in cases of high judgments coming from Western India, high courts of Gujarat, Maharashtra, Bombay, but eviction orders are there. And that stems, of course, from the various.
Senior completed.
Yes. Various provisions of statute.
So you want the implementation of the order, you are challenging.
I have challenged
portion.
one part of the
eviction order.
Only the eviction portion.
And you?
Proposed state, my lord. My job is to whatever the order is
You have
passed.
been both the sides. You are happy with that.
I'm happy with it.
Whichever way the court is, they tell.
Okay, I may fix the date.
As your lordship.
It is submitted. It is found that proceedings have been completed. The matter is to be heard on the date. Let the matter appear. बाबू बेटा डेट है जाएगी 2 बजे
This is the medical bill of the Senate order. In the same ratio. In the same ratio.
Same ratio. Double benefit.
Double kotha hai.
Tuesday means second December.
Not 2nd December.
Tuesday 25th.
But day after tomorrow,
25th.
এটা বেশিক্ষণ লাগবে না
26 at 2 p.m. No, 26 3 p.m. है ना 26 2 p.m. Packet আছে
26 की
26 at 2 p.m. Mr.
oblige.
26 तारीख
That payment of the medical bills, my lord.
Format that.
But also on the respondent 5.
I'll instruct my client to pay. किसका एविडेंस
किसका एफिडेविट
Everything has been mailed to him. And if he needs
और मेडिकल बिल दीजिए बाबू मेडिकल बिल देंगे आपका मदर का मेडिकल बिल दीजिए हाँ दे देंगे
my lord can imagine how elderly my client is, by looking.
Okay, okay. Next.
Good. Much obliged.
Dada, my lord, before calls the original side matter, with regards to item number 25 appellate side leads, my lord, on last occasion, Friday, my lord, 25 today's list. My lord, on last occasion, directed to the matter to be appear under the heading urgent motion. My lord, it is order printed as adjourned motion and is appearing as adjourned motion. Electricity, I am suffering. I am not having the electricity.
But I am appearing on behalf of.
25 other side is here also. Other side also is here, my lord.
You can keep it tomorrow morning, my lord, as to be mentioned, we'll do it. My lord.
Hey, 25, na? Is it lengthy matter?
My lord, this was this was taken up
Friday, my
on Friday.
Friday.
When my lord was pleased to fix it as urgent motion, it has gone down as an adjourned motion.
25 को ना? Item number 25. उसको adjourn motion में ये urgent motion में कर दीजिए 21 को 21st को urgent motion में कर दीजिए Friday.
My lord, will keep it tomorrow, my lord. My lord had reached 23rd today.
कर दो कल tomorrow as urgent motion.
Grateful.
Last matter in the adjourned motion group 26. My lord, I don't know whether.
Come tomorrow.
No, not tomorrow, day after tomorrow. Tomorrow I am not there.
Okay.
And the other side is here. Day after tomorrow.
Yes.
My lord.
With the lordship's kind.
Let's settle.
My petition number is 821. We have been wrongly evicted.
Which one?
821.
Appellate side.
Original side.
He's not.
Yes. What do you want?
I want to mention about a case. Mentioning about a case.
Why you are mentioning?
We have been wrongly evicted from our factory, foreseeably without any notice. All our material has been auctioned, seized without any notice, without following the due procedure of law. The payment by the buyer has already been.
What do you want?
I want you to hear the case as early as possible, sir.
It will be listed.
Tomorrow?
It will be listed. See the cause list.
Thank you, sir.
Very permitted to mention one matter, my lord. I am praying for leave for short service, my lord. This is an application for recalling of my lord's order passed in an execution matter, my lord. Now there is urgency, my lord. So I am praying for a leave.
My order?
Yes, my lord. In ECCOM, my lord. I am praying for leave of short service, my lord.
File it.
Yes.
What is the short service?
My lord, may it be listed day after tomorrow, my lord.
What is the urgency?
My lord, my lord has passed a direction for filing affidavit to asset by the judgment letter, that is me, within 2 weeks, my lord. Now that 2 weeks time is going
Go
to
to the regular code. No.
My lord, it's my lord's order, my lord, and recalling.
You're
is
not
to be...
recalling of the order.
Yes, my lord.
Okay.
Keep your left.
Pass an order to dispatch on 10th November 2025. The department can drop and complete the order.
I need to mention the ordinance and repetition regarding a tender. That matter was heard. If it's a complete, it's only up for hearing. It was directed to appear on 3rd of November 2025. I have urgencies that tender has been completed. Somebody else has been wrongly declared as L1 bidder. And that we are told through the affidavits of the respondent that L1 bidder, who has been awarded during the course of pendency, has also been given the certificate of award. That is the reason that is the urgency. Kindly list it on any day according to your lordship's convenience. I am on notice. This was already heard twice.
Actually, he was unsuccessful.
Yes. So I challenged it before a declaration of award.
That's why he is watching.
No,
he's present.
I am not opposing inclusivity, but the fact is that he was not successful in the bid. It was given to other. He has challenged.
Okay.
State is favoring a private party. Lordship can.
Yes,
my lord.
Any day according to lordship's
No difficulty in excuse.
My lord, an execution case. My lord, an alter ego of the judgment debtor had filed an application because of which the execution was held up. Now on the 10th of November, your lordship has passed a judgment, my lord, dismissing their intervention application, saying that the judgment has been affirmed up to the Supreme Court and there's no scope for any interference. So, my lord, now that my lord thorn has gone away, my lord, I'm only praying, my lord, for listing of the execution case so that, my lord, the money.
Why here?
My lord, no, my lord, this is specially assigned to your lordship. And my lord, the money 42 lakhs is lying with the receiver. My lord, we could then get that money because now, my lord, the impediment now is no longer there, my lord.
My lords, I appear for the
This
judgment
is
date on the matter. My application is pending
specially assigned,
still.
my lord. My lord, this is, my lord, otherwise it will come up, my lord, just on the verge of, my lord, the winter vacations. If your lordship may consider, my lord, any date. My lord, this is at Augustus.
Augustus.
My lords,
Yes, your lordship has dismissed past a detailed judgment, my lord.
my lords, my application is still pending. I appear for the judgment date on the matter. The application is coming on the 17th. Although the release are the same, the grounds on which I'm
Special
seeking.
assigned only with regard to the application disposed of. How this go? This is a special assigned total. Let us.
This, my lord, I will have to get whether
Okay, let the
only
matter appear, then we'll see to that. Let the matter appear.
if your lordship is of the view,
Yes,
my
my
lord, I have
lords.
no preference in courts. If your lordship is of the view that only that particular application was assigned, my lord, then we'll have to approach the regular.
Only the 42 lakhs is with the receiver.
With the
not
receiver.
With the receiver in the bank.
So that money, my lord, is what I want, my lord. The client is, my lord, desperate to get that money.
But original claimant is sitting behind.
Yes, my lord, he will lead me when the matter is listed. He will lead me. Mr. Moinak's boss is mentioning fees, my lord, quite substantial.
The execution fee. Otherwise, you can't go to file. Boss is mentioning fees. Kindly keep it during the Christmas vacation.
No, my lord, no. No, my lord. Next week, my lord.
No more.
This week or next week.
Okay, let the
Any
matter
day.
appear, then we'll see to that.
Your lordship will, my lord, consider. Let the matter appear.
Yes, my lord.
Great.
Obligements.
Yes, call the matter. The matter is listed as to be mentioned on receipt of the report from the assistant register attached to the degree department of original side of this court. After going through the report, it is found that in the order dated 10th November 2025, at 10th November 2025, at page number 1, fifth paragraph, and page number 2, second paragraph, the date has been inadvertently recorded as 6 August 2024 instead of 24/4/2024. 24/4/2020. In view of the above, in the order dated 10th November 2024, at paragraph 5 at page number 1 and paragraph 6 at page number 2, the date shall be read as 24/4/2024 instead of 6/8/2024. This order may be incorporated with the order dated 10th November 2024. Next.
But I had not mentioned this matter, my lord, that I am for the bank not suffering an interim order. My lord, this hearing of this writ, my lord, was concluded, my lord, not except for the reply of the petitioner. Not kindly take up these two, not last two orders. My lord.
No, Bishop. No, my lord. Kindly hear me before release. Your lordship will kindly consider. But I am trying to make a list. I've told my juniors to make a list of the matters which we substantially argued before your lordship when your lordship was sitting in courtroom number 38. But since the matters were not treated as part-heard matters, not one, several matters. So then what we have to do, we have to re-argue the matter before the bench, post change of jurisdiction. Now, this is not the only matter. There are thousands of matters in this court. And my lord, I am taking out that judgment. There was a matter which was heard, judgment reserved by division bench presided by Justice Harish Tandon. But the day, my lord, the order came, my lord, the elevation to the chief judge, he said that I have lost jurisdiction. I cannot deliver judgment on this. Matter was heard and reserved for judgment. So on a situation like this, well, today I am the petitioner in the next 5 matters. Now, what is the situation? We've argued, we've requested the judge kindly treat it as a part-heard matter. His ladyship, but I was not inclined to treat it as a part-heard matter. So now, what do we do?
Lord, both parties might have requested.
Now, yesterday I was told Mr. Sinha made a submission to court
that the matter was mentioned
Yes, yes.
before
I'll tell
Justice
you,
Sinha. Now, my lord, question, how could it be mentioned? I am the petitioner. You don't put me on notice, you mention.
I'll tell him, my lord.
Then, no, how did you do it? Question is that, did you
Yes, I've
mention
done
it?
it.
How could you have done it?
If I'm
Without
allowed
notice
to
to
make
me?
submissions, I'll explain how I've done it. My lord, this matter was mentioned not by my junior lord before your lordship. Your lordship said that if his lordship not is inclined to take up the matter, your lordship release it. So, my lord, I happened to be in court, but I merely, my lord, informed his lordship of this matter, and my lord said that in case your lordship not, if this matter is assigned to your lordship, would your lordship be inclined to take it? His lordship said yes. If it is assigned to me, I'll take up the matter. My lord, that is what I have mentioned. My lord, that not it was argued by them for about 4 days, by us for about 3 days. Fixed for argument on 22nd of September, just before vacation. They took time, my lord, on their instance, my lord, is recorded that it is being adjourned, and the Honorable Court records that the matter has been substantially argued. But the order itself records. So, not it's only their reply, my lord, which is left. Not now. I'm not a public sector undertaking. Not I'll have to restart. Not incur, not a cost again. Not for the entire hearing.
No, my lord, kindly have a look at
I
this
don't
order.
think
Your
that it's
lordship
a mere
recollects.
signature.
Your lordship recollects Kunal Finance matter. That point on order 30 of the Civil Procedure Code, partnership fund, one partner had died. Mr. Rupak Ghosh was my other said, how many days the matter was being argued? But I was supposed to give reply. Now the matter has come before the regular bench. Kindly see, this is yesterday this order was passed. So, but if today any matter is assigned regardless of any reason, the judge has to take it up. If the Chief Justice, so that is the prerogative of the Chief Justice, who I assign it to. So, there is no hard and fast rule. It has to be assigned to that judge. So, today, if today your lordship has the determination.
The assignment is not once the party is telling that the matter has been heard substantially, but
But only reply is.
There is not one matter. There are multiple matters which has been heard.
mentioning
So,
this
we've
matter,
gone
not-
around every court. Then we are going to do the same thing. None of the judges entertaining that. Now, my lord, kindly have a look at this order. Kindly have a look at this order in Kunal Finance. Yesterday, this order was passed because my junior mentioned before the judge that the matter was substantially heard to the benefit of both parties, and the other party, which is the plaintiff, opposed. And this is the order. We suffered this order yesterday. He said that unless the matter is treated as a part
But
of
I'm
the matter by
surprised,
the
brother, the
previous judge,
petitioner is wanting
I'm
to
not going to
delay
release the
process.
matter.
That's why now
So I am my respectful submission, my lord. I am the petitioner. My lord, kindly direct the matter to be listed on any day.
the court decide the matter.
No, my lord, I am opposing.
Not to bring the judges in.
Yes, my lord. I think
Yes.
let us.
My lord, your lordship has the determination to hear the matter. Whenever, my lord, convenient to your lordship, kindly post the matter in the list and hear it.
Better it, Mr. Bose, let
My
be released. Let them.
No, my lord, kindly do not release it. Why would your lordship release it? Because my learned friend is saying that the matter has been heard substantially.
The order
No,
says it is
no,
heard.
no, there are multiple orders. I am showing orders which says it has been heard. I am giving instances of matters which has been heard, reserved for judgment. Thereafter, with change of determination, judge says that I cannot pass orders.
Not,
There are not one. There are thousands of matters.
Matters
Just
have been
because
written
your
and not
prejudice
signed.
doesn't mean your matter has to be released. Today, your lordship, there is no determination, there is no advisory or any circular by the Chief Justice that any matter which is substantially heard has to go to that judge. It says otherwise. The
This is
2007
regularly
12
done, Lord.
circular
I'm
says that
surprised this
it is
submission
never
have been
done.
made.
Then
I cannot produce before lordship not the hearing, not the recording of the last hearing where we both submitted that it should be made part heard.
Then the judge categorically said, I will not treat it as the part heard matter.
Okay,
So,
I am releasing.
No, well, kindly don't release it. Well, kindly don't release the matter. Well, this is exactly what they want. No matter, they don't want your lordship to hear the matter. Why? Well, then, my lord, kindly appreciate that bench does not have the determination. Today, your lordship has the determination for hearing residuary matters. And my lord, I am saying, my lord, both parties at the time when arguments were being advanced requested the judge. Mr. Sinha will inquire from his junior. And the learned judge specifically said, I am not inclined to treat this matter as a part heard matter. Then this was
we have
before
the
the
video
vacation.
recording, Lord. If I can play for it.
Kindly play the video recording where I made the submission to treat as a part heard matter. And Mr. Shobhoshaji Chaudhary, appearing on behalf of the respondent, said that this is not the usual practice. Kindly open the recording.
Lord, I have it
Chaudhary
here.
said that this is not the usual practice.
This is shocking.
Because if
Lord,
there's
this is shocking.
it is not shocking. What you are saying is shocking.
I'm only going by the recording, Lord, made by the learned judge on 11th September, Lord. It says my submissions are concluded, fixed for
Who denies that?
On 22nd for reply. On 22nd, Lord, they say that they can't, Lord, they were not prepared to argue. The bench records that the writ petition was substantially heard by this bench and fixed for hearing on 7th November.
Well, substantially heard is not there, it was heard.
Mr. Sinha, because our determination does not speak with regard to substantially heard. Our determination, it is.
Thousands
it is
and
a part
thousands
heard,
of
it is
matter
a
have been
part heard,
substantially heard.
Especially assigned.
Yes, but for special assignment, it has to be released. Otherwise, I can't apply for assignment.
Correct.
But
correct.
unless your lordship releases not, I can't apply for assignment. But that is not what we have done in so many other matters. Not so.
Well,
so many
I
of
am
these
the
court
petitioner.
cases-
If I am the petitioner, the carriage of proceeding is on me. Well, today, if the honorable
supporting
judge,
the interim order.
well, today, you're suffering the interim order. You should have gone in appeal. You have not preferred an appeal. You did not apply for vacating. You have chosen to suffer the order.
No, I have
There
chosen
was
to
a,
have
they
the
have,
hearing
you have a
concluded.
right of intra-court appeal. Kindly fix it tomorrow, any day convenient to your lordship. We will argue the matter. Just because the matter was substantially heard, there are multiple thousands of
I
matters
think now
which
we
have been
should leave it to your
substantially
lordship
heard.
not to pass whatever order your lordship deems fit. Not, I think it's.
The matter is listed as to be mentioned on the prayer made by the counsel for the plaintiff.
For the respondent, for the bank.
For the bank, for the respondent bank, and submits that in the order dated 22nd September 2025, it is recorded by the by her ladyship that the writ petitions were substantially heard by this bench. Learned counsel for the respondent bank further submits that the matter was mentioned before her ladyship, and her ladyship is of the view that if the matter is released, then the matter can be taken up for hearing. Per contra, an advocate appearing for Mr. Bose, you are appearing for?
Well, for the petitioners. For the writ petitioners.
For releasing of the matter, submits that the matter has not been taken as a parted, and thus that the matter cannot be released from this court. Full stop. The judges cannot be made party between the parties. Accordingly, matter is.
Well, may I just give
the matter is referred to the Honorable Chief Justice to decide whether this court can take the matter or the matter can be released from this court.
Well, only one indulgence. Just record my submission that a request was made. This is my submission. The request was made, a joint request was made by the parties before the honorable judge, and the honorable judge was not inclined to treat the matter as a part-heard matter. This is my submission.
Mr. Manakbos bola na? Mr. Manakbos, an advocate appearing for the plaintiff submits that
Refuse to treat it as a part-heard matter.
By her ladyship, a request was made by the parties to treat the matter as part-heard, but her ladyship has not made the matter as part-heard, but has recorded substantially heard the matter. Full stop. As the court cannot be made a party, let the matter be placed before the Honorable Chief Justice to decide whether the matter can be heard by this court or to the
Grateful.
Melody, item number 2 and 6, where I represent the petitioner, the interim order is due to expire on 28th of November. Because of this,
Maybe around 50.
by that decided,
Maybe around 50.
just in case it's not decided by that time, I'll come and
You
talk.
come. Unless it is not decided, I am having.
Yes,
She
yes.
has not released it now before the honorable.
Honorable-
Only an extension of interim order, not in the hearing.
Item 7, my lord, is a contempt application. I appear for the.
But item 7, I used to appear for the contemners, my lord. The order was complied. We have already supplied the documents. Currently, I do not have any instructions from the contemners, my lord. One of the beneficiary, the son of the principal contemner, is now in asylum, mental asylum in Chakgodia. Thereafter, the client has taken the brief and gone, my lord. I have no instruction. As an officer of the court, I informed the same.
See that. What should be the last para of this order?
Which order? Order dated?
12th September.
Yes.
12th September.
And let's continue having the original copy of the murder sanction plan. The same will be placed before this court on the next date fixed. If the contemner contend then the murder sanction plan is not available, the alleged contemner shall file an affidavit. Yes,
They
you are
have
not
filed-
appearing.
No, and I do not have any instruction. Only thing, all the documents were already supplied. They say
No,
that the
with regard to the mother sanction plan, the original one, the first one.
revised sanction plan has been given to them.
Revised,
They
not
want-
mother.
Yes, that I do not have any instructions because no one has
So
come
you
to me.
issue
on
the
that.
notice.
Yes, I have to issue the notice. Directly on the.
By an order dated 12 September 2025, this court directed the alleged contemner to place the original copy original or copy of the mother sanction plan, originals or copy of the mother sanction plan of the building in question. And it was also made clear that if the original copy or the copy of the mother sanction plan is not available, the alleged contender shall file an affidavit stating that the mother sanction plan is not available. Full stop. When the matter is taken up for hearing today, Learned Counsel appearing for the contender submit that the alleged contender has taken the brief from him and he has no instructions to appear in the matter. In view of the above, the case is adjourned. Let the matter appear on कब रहता हम लोग का बुध को, मंगल को, बुध को रहता. Let the matter appear on 2nd December. And the petitioner is directed to communicate this order to private respondent to the alleged contender, and to file affidavit of service on the next date fixed so as to enable the alleged contender to engage the lawyer. If in spite of receipt of the notice, if the alleged contender will not appear before this court or engage any lawyer, appropriate order will be passed. Next.
The election 7. Item 7, my lord.
8.
On the 7th. Watch 8.
8.
Ray, my lord, he's before on his legs before courtroom number 8. A short passover may be granted for the timing.
But other Mr.
Mr. Dotto has already concluded, my lord.
No,
So
Mr.
far.
Ghosh was there. He was assisting Mr. Ray. The matter was specifically fixed.
My lord, a short passover for 5 minutes. My lord,
I had concluded, my lord, on behalf of the other my lord, in GA3, it was Mr. Ray who was to, my lord.
He was to argue for another 4 or 5 minutes.
minutes, my
Thereafter,
lord.
I was to reply, my lord.
Needs to be dealt with, my lord. My lord, a short passover may be granted because, my lord, Mr.
When
Ray.
it will be available.
My lord, kindly grant me.
No, one judgment you were saying, no? Cite that
My lord,
judgment.
my lord,
Cite
10
that
minutes
judgment.
passover, my lord, then.
They are procrastinating it, my lord, in this way, my lord. They are procrastinating.
Passover.
Inform.
My lord, I appear for the plaintiff.
Yes.
It may come back to your lordship. This is that eviction suit matter where Mr. Shiv Shankar Banerjee had been addressing for several days.
Argument.
On the last occasion, they said they would rely on another judgment, but my lord, I believe my lord made it clear in the order that in the event they don't do it, I shall proceed with my submissions.
Yes. Well, if we required, it will be after his submission.
No. If it is required, that means you're.
After if anything is required.
But it may come back to my lord. He tried to rely on a previous agreement and said since there was no clause by which the tenant could be removed, that also holds good in this agreement. But to be very frank with your lordship, my lord, I did not quite understand, and I say this with respect, the tenor of my learned friend's application and submissions. Kindly take the plaint. I came with a very simple plaint, which has now reached heights of complication for no rhyme or reason.
Yes.
But it's a very short plaint. I shall quickly take your lordship through it. The plaintiff is the owner of premises number 6, Lion Range, Kolkata 1. By and under an agreement dated 7th May 84, the plaintiff had let out to the defendant a portion on the second floor of the said premises and measuring approximately 12,125 square feet. Under the said agreement, the defendant inter alia agreed to pay to the plaintiff a monthly rental of 12,750 for the suit property calculated at the rate of ₹6 per square feet per month, and to increase the same by 10% every 3 years during the subsistence of the tenancy. It was also agreed by the defendant to pay and reimburse the plaintiff the payments made on amount of corporation taxes, including surcharge, multi-storied building tax, urban land tax, and also other taxes and outgoings as may be imposed either by the central government or state government, corporation or Calcutta, or any other competent authority towards the occupier's share proportionate to the area given on monthly tenancy to the defendant. Furthermore, the defendant also agreed to pay to the plaintiff maintenance charges of 2425 per month with the suit property calculated at 0.20 paisa per square feet per month. In terms of the agreement, the rent of the suit property was increased by 10% every 3 years. My lord, all this is undisputed. He has admitted all this. Inasmuch as at all material times, the defendant's tenancy was a monthly tenancy, after the West Bengal Premises Tenancy Act 56 was repealed, such tenancy came to be governed by the provisions of the Transfer of Property Act. In view thereof, the plaintiff became entitled to terminate the same in accordance with the provisions of the Transfer of Property Act. Not being desirous of further continuing with the defendant's tenancy, by a notice dated 19th July 2008 issued under Section 106 of the Transfer of Property Act, the plaintiff, through its advocate, terminated the defendant's tenancy with the expiry of the month of August 2008 and called upon the defendant to deliver vacant and peaceful possession of the suit property upon expiry of the said period. Such notice was served upon the defendant on 21st July 2008 by hand delivery and also on 22nd July by registered post. Despite the receipt of such notice, the defendant failed to vacate and hand over vacant and peaceful possession of the suit property upon expiry of the month of August 2008. Instead, it continued to remain in wrongful possession. Paragraph 2.
Yes.
My lord, kindly come to the next paragraph. In the premises as aforesaid, the plaintiff is entitled to recover vacant and peaceful possession of the suit premises by evicting the defendants therefrom, inasmuch as the defendant is continuing in wrongful possession and occupation of the suit premises despite its tenancy in respect thereof having been terminated with the expiry of August 2008, the plaintiff is also entitled to claim mean profits. My lord may remember, we have already got back possession. It is now a question of calculation of mean profits from what date to what date. My case in the plaint is very simple. I have come up on the basis of an agreement. He admits the agreement. But of course, by some strange concoction of law, he refers to a previous agreement, which he never agreed to abide by, at least so far as the subsequent agreement is concerned. He gave me notice that he would vacate the premises. Twice he failed. Third time he did vacate the premises. So it is just a question of appointing a commissioner, my lord, to calculate the mean profits. The question is from what date to what date. Before I show your lordship, my lord, the rest of the matters which go very smoothly, kindly take a stand in the written statement. My lord is, sorry.
Yes.
My lord has got it. The defendant states the above suit is not maintainable in law or in fact as framed or otherwise. The plaintiff has no cause of action to file and maintain the suit. This honorable court does not have the jurisdiction to receive, entertain, try and adjudicate the suit. The plaintiff has deliberately inflated the valuation, dehodes the statutory provisions to attract the pecuniary jurisdiction of this honorable court. The relationship between the plaintiff and the defendant is governed by the West Bengal Premises Tenancy Act 1997 and not by the Transfer of Property Act. The agreement dated 7th May 84 was entered into by and between the plaintiff and the defendant in terms of compromise of a previous suit being suit number 661 of 83, wherein it has been specifically recorded that the tenancy in favor of the plaintiff shall be purely a monthly tenancy within the meaning of the West Bengal Premises Tenancy Act. In that view of the matter, the statutory modification and operation of West Bengal Premises Tenancy Act 1997 does not bring the tenancy of this defendant out of the said act. Yes, this is his point. Now, how he suddenly arrives at this point, in view of the clear finding, my lord, and the statute in the West Bengal Premises Tenancy Act 1997, section 3F. The Act will, Premises Tenancy Act will present. My lord doesn't have it.
Yes, yes.
তোমার কাছে বই কপি আছে? Well, look, kindly see section 45.
Repeal. Yes.
The West Bengal Premises Tenancy Act 1956 is hereby repealed. Notwithstanding such repeal, all suits and other proceedings under the said act pending at the commencement of this act before any court or any other authority shall be continued and disposed of in accordance with the provisions of the said act, as if the said act had continued in force and this act had not been passed. Well, our agreement came later. Under 3F, my lord, tenant means any person by whom or on whose account or behalf the rent of any premises are not, but for a special contract will be payable, and includes any person continuing in possession after termination of the tenancy, and in the event of death of any tenant also includes for a period not exceeding 5 years the death of such tenant. So, my lord, having been repealed, all those, my lords, all those reference to sections.
Yes.
And my lord, another thing is 3F. Nothing contained in this act shall apply to. Nothing contained in this act shall apply to 3F. Any premises let out for non-residential purpose which carries more than 10,000 rupees as monthly rent in the areas included within the limits of the Kolkata Municipal Corporation or the Howrah Municipal Corporation, etc. 5,000 as monthly rent in other areas. Well, the admitted rent is 1,56,000. And the act has been repealed. So, my lord, we are totally covered.
Under the 97.
Yes.
Yeah.
And the point which has been argued, my lord, at length and with great elaboration are not even part of the pleadings.
Yes.
My lord, kindly see the written statement once more. Paragraph 7. The purported notice is referred to in paragraph 6. The purported notice by which the tenancy of the defendant has been sought to be terminated is bad in law. How? I'm following the statute.
Because the paragraph 6.
Well, let kindly see paragraph 8. The defendant has committed no breach of the terms of the tenancy, and as such, no grounds for termination of tenancy under the Transfer Property Act is available to the plaintiff. The defendant's tenancy has been illegally and wrongfully terminated. 9. The defendant further states that the plaintiff has committed breach of the terms of the agreement dated 7th May.
Sir, it is an admitted fact they continued enjoying the property.
And even after this date, they continued enjoying the property. In fact,
Till September
my lord,
2023.
they have been in wrongful possession from the 1st of September 2008 to 29th of September 2023. This is the period for which, my lord, wrongful possession was there.
Dated?
1908,
Yes.
that is 1st September 2008 to 29th September 2023.
2023.
And 23. Because possession
On
was
that
taken.
date, they are vacated.
They are vacated. They're vacated on 29th September 2023. My lord may remember those letters. I should show your lordship the letters. On 3 occasions, they offered to vacate and then they did not. They resigned.
Yes.
So, my lord.
Sir, 26 September, not 29th, 26th September 2020. This is the letter, exhibit A.
Okay. Well, lord, my learned Julia rightly points out it's not 29th September.
26th.
26th September 2023.
26th.
Yes.
26th.
Good, Ashok. Answer the admission to the paragraph 14.
Kindly come to the written statement, paragraph 14. With reference to paragraphs 9 and 10 of the plaint, it is stated that the defendant was liable, my lord, the admission. Paragraph 14.
Liable to vacate or hand over the person.
Was liable to vacate or hand over possession of the suit premises to the plaintiff upon expiry of the month of August 2008. So what remains after that? Clear case of admission. And I remember my learned friend on the other side say it with a smile. I don't know what to say in regard to this.
Yes.
Or have failed to do so as a...
My lord, I argued the point on a different score. I said the insufficiency of the notice, my lord. Anyway, let my senior to continue.
Yes.
As alleged or at all. Well, and I think this is all the written statement talks about. Let me show your lordship just those three documents. আমি ওই ডকুমেন্টগুলো দেখাতে চাইছি তো surrender documents. My lord, we have filed a judge's brief of documents in which the agreement of 7th May.
Supplementary?
Yes.
Supplementary judge's brief?
Yes, supplementary documents. Kindly come to Exhibit C in the supplement. Letter dated 1st of April 2022.
Yes.
This is to inform you that the competent authority has decided to surrender the portions under the use and occupation of National Insurance Company Limited at 6 Lions Range, 2nd floor, with effect from 31/5/2022. Since then, they have been contemplating. You are requested to be adequately represented and be present at 2nd floor National Insurance Company Limited, 6 Lions Range at 4 p.m. to receive the possession of the portions as aforesaid. In the event of failure on your part to remain present in the aforementioned day and date, and or to obtain back possession thereof, in such situation, possession shall be deemed to have been handed over by the company from the said day and date, and the company shall stand absolved of all liabilities with respect to the said portions with effect therefrom, which you may please note. Well, the next letter, 26th May, second paragraph, arising out of some unavoidable and pressing circumstances, we would not be in a position to vacate the said premises on 31/5/22.
Yes. This is also exhibited?
Yes, yes, they're all exhibited.
Exhibit?
Letter dated 1st April is exhibit.
That is C.
This is D.
This is D.
And now finally come to E. You take that up.
E, na, sir.
F. 26 September 23. This letter is issued without prejudice to a right in CS 230 of 2008, pending before the Honorable High Court, Calcutta. We submitted before the Honorable High Court, Calcutta, that pending disposal of the suit, we would like to vacate the subject premises and surrender the vacant premises to you without prejudice to our right. Hence, kindly take the possession of the premises along with handover of keys on 29th September.
Exhibit F.
Yes. So it is 29th September, not 26th.
Later handed over.
They did hand over.
on 26. And
Yes.
possession handover on
Letter was 26, but the date was 29.
Letter was issued on 26.
29th handed over.
Yes.
At 4 p.m.
On no complaint basis.
Sir, according to judge's brief, agreement
Yes.
admitted rent.
My lord, kindly, I will just show your lordship from the judge's brief of documents, the admitted rent.
Admitted rent, sir, admitted.
Sure.
No, sir, it is judge's brief.
My lord, kindly grants me a moment. I'm looking for the judge's brief of documents.
Final binding, this one.
Yes, my lord, mine is, I think, your lordship's record is also.
Is there.
Sir, आपने यहाँ पर-
Well, it kindly come to the judge's brief of documents, page 35. Letter dated 8th May 2009. This is marked as Exhibit G.
8th May.
8th May. To show the admitted rent.
Exhibit G.
G. Enclosed, please find a check bearing number so-and-so, dated so-and-so, for 1,38,778.17, drawn on Bank of India, Kolkata. Branch being payment of rent for May 2009. As per court order dated 30th so-and-so, the details are given below. Rent per month is 1,56,000 and odd. Maintenance charges 2,428. And TDS deducted, it comes to 1,38,770.
The
This
rent
is,
is 1,56,000.
and the rent is 1,56,000, which is more than 10,000. So, my lord, in this background, I have judgments with me to show that in the same premises where, my lord, the defendant was occupying, there also they have suffered, my lord, decree for eviction. But here, my lord, they have willingly given away the property, given possession of the property, agreed to the rent, and then, my lord, to turn around and say that we are relying on some other agreement. My learned friend spoke a lot on those agreements, my lord, and gave a lot of instances. But frankly speaking, I humbly submit that, my lord, this is not required in view of the clear pleadings and the clear admission on their part.
Agreement and budget.
And just as a parting shot, my lord, my learned junior says to show the agreement, page 1. It's on the basis of this agreement that they came into the picture.
Yes.
This agreement made the 7th day of May, which is Exhibit A, so and so.
So their contention is that the agreement does not contain any time limit. The extension this monthly
Yes, rent but in
can be-
law, if law, I'm entitled, my lord, to take advantage of the fact that the act has been repealed and this act has come in, and 10,000 rupees. And so he refers to the old suit many times, internal page 2 of the agreement. I just read out that portion where that old suit is referred to. And whereas the period of occupation of the said tenant reserved by registered lease dated so-and-so granted by the landlord in favor of the predecessor of the tenant, Corporation of Royal Exchange, expired on 30th April, and in consequence thereof, the said landlord has filed a suit against the tenant in the High Court at Calcutta, being suit number so-and-so, Turner Morrison versus National Insurance Company Limited, claiming against the said tenant a declaration that the said tenant was a trespasser of the portions occupied by it, and for a decree for actual physical and khas possession of the said premises of the second floor at number 6 Lion Range, Calcutta, and a decree for 6,36,000 and for other reliefs mentioned in the plea. And whereas the landlord has also applied in the said suit for a decree being passed summarily against the said tenant. And whereas during the pendency of the said proceedings, the said landlord and the tenants have agreed to resolve and settle their disputes, and the parties have agreed that the landlord will grant a monthly tenancy of the said portions of the second floor at number 6 Lions Range, Calcutta, unto and in favor of the said tenant on the terms and conditions hereinafter appearing, which tenancy shall be effected from 1st May 1983. Now this agreement witnesseth that the parties here to have agreed as follows. The tenancy in favor of the tenant shall be purely a monthly tenancy
Yes.
within the meaning of the West Bengal Premises Tenancy Act, and such tenancy shall be deemed to have commenced with effect from 1st May 1983. Where is the reference to all those things, my lord, which my learned friend relied upon and argued very vociferously before your lordship?
Yes.
The landlord has granted the said monthly tenancy, and the tenant has taken the said monthly tenancy of all that portions of floor space containing an area of 12,125 square feet on the second floor, shown within red borders in the plan hereto annexed, together with fixtures and fittings therein at number 6 so and so. The rent of the said tenanted premises shall be calculated at the rate of ₹6 per square foot per month, and accordingly the monthly rent calculated the said rate comes to a sum of ₹72,750 per month.
Right from the beginning, about the 10,000 bracket.
So right from the beginning, my lord, it was above the 10,000 bracket.
And sir, all the arguments you made that there is a lease, 11th lease, it's contrary to the
Yes. And my lord, all this 11th month lease and all other points which my learned friend, they're all contrary to the agreement and the lease. Nothing like that exists. As I told your lordship,
tenancy terminate করার এগারোটা দেখো the notice.
the period I gave your lordship the date, 20th, from 1st September 2008 to 29th September 2003. Exhibit B, my lord, is the letter terminating the tenancy dated 19th July 2008.
Exhibit B.
Yes.
B.
What is the date of the termination? 19.
19th July 2008.
Acha, 19. Yes.
My lord has found it.
Yes. Yes.
By an agreement in writing dated 7th May 84, made by and between our client and yourself, our client inducted you as a monthly tenant with effect from 1st May 83 in respect to the portion of the second floor premises number 6 Lions Range, Kolkata, containing a floor space of 12,125 square feet, more described in the said agreement, which is situated within the limits of the Kolkata Municipal Corporation, hereinafter referred to as the said tenant, at a monthly rent of so and so. Well, then I turn the page. These are just factual, admitted things.
So, what is the due as per your claim? Now, 1st September.
My lord, we have in the plaint we have said a figure, but normally in such things, what my lord does is it has to be assessed. A special officer appointed to act as commissioner, who will enter into the arena of controversy and file a report before your lordship, and on the basis of that report, final decree will be passed.
No, that's why. So, from 1st September 2008, he has vacated the 1st September. You vacated on 29.
He has vacated on 29th
So this period,
September.
the special officer is to be appointed.
I beg your lordship's pardon.
For this period, the inquiry is to be
Yes,
conducted.
only for this, because otherwise I've asked for decree for khas possession, and possession I've already
For
got.
a person, you already got there.
Yes.
এই প্যারাগ্রাফটা দেখিয়ে দিন,
Just-
periodটা will be clear.
Well, just the last paragraph of page 13. Thus, we hereby, on behalf of our client, terminate the tenancy granted in your favor of the tenant premises on the expiry of the month of August 2008, that is 31st August 2008, of the said tenancy, and call upon you to deliver to our client vacant and peaceful possession of the tenant premises upon expiry of 31st August 2008, which means, my lord, 1st September. That is why I told your lordship the figure of 1st September 2008
Yes.
to 29th September 2023. But I don't think I need elaborate anymore.
Yes. Anything further? Any judgment?
They have not shown any judgment, and there is a case of admission even in the written statement.
Yes.
My lord, kindly keep it another day. Today I'm little difficulty in. Lordship, I will not take more than 15 minutes of time. Any day.
I am fixing a date. Come both the parties with the written notes of argument.
Very good.
And if you necessary, if whatever the submission, you 10 minutes you complete that.
Because the very argument which I forwarded to your lordship, that the agreement does not contain a clause of termination, and in view of the notice given and the rent received thereafter, these two issues which I said, that is the go by given to the notice, those 2 points have not been addressed by my learned senior.
My lord,
All
I
right,
have
Doctor.
not signed any judgment, shown any judgment. My learned friend, if he has a word or two to say with regard to the facts, he can say so. But I've finished my submissions, my lord. Let my learned friend not go into the same point again and again. That
No,
is my
I will
humble
not.
request.
Of course, I will not go. I will rely on one judgment. I will forward the
Judge,
advance.
in reply, and I will have to reply to that again.
Because on the last, kindly see the last order.
Yes.
You wanted to rely upon the judgment, the court has given time, but you have not neither cited the judgment nor has forwarded to the
Not on any question of the judgment which I will be relying. Only a very common principle of law that the document has to be read in the light of the law which
My
is
lord,
there.
kindly do not expand the scope of the suit, my lord. My learned friend has spoken for at least 5 days, if I'm not mistaken. And I have not even taken 15
Have you gone
minutes.
through the last order?
Yes, my lord, I have seen that.
Yeah, then fix the argue the matter.
One principle of law, Lordship. I will take 15 minutes. I will not cite the judgment, but I will take reference that this is a settled principle of law.
Counsel for the plaintiff has concluded his argument. Counsel for the defendant prays for time to give reply.
My lord will
Case-
not let him cite any more judgments, my lord.
No, I will not allow.
Very-
Case is adjourned.
Today
Let the
injunction
matter
on
appear.
What?
24th November at 3 p.m. Both the parties are directed to come ready with the written notes of argument.
I am deeply obliged. I'm deeply.
At 3
24th of November, my lord.
24th at 3 p.m.
I'm very grateful.
I'm deeply.
Right.
I'm sorry, madam. I'm at fault, madam, but I can finish in 5 minutes, if your lordship permits. I got caught
Since his arrival, my lord, I have been man marking him so that he cannot go away to any other.
Today I've understood how handicapped we have become. How handicapped we have become because of our iPads, my lord. I did not notice for the morning I'm doing matters. Suddenly before a division bench, my lord, it just decided to conk off. And my lord, all my notes and everything is there. I don't know what to do.
As I keep on saying that we were born intelligent, but technology ruined us.
It's true. Especially the younger folks, my lord.
Yes.
Now, my lord, I will just deal with the 3 judgments.
Have you seen any of the junior taking the book and reading?
My lord, they don't. I make it a point in my chamber that I admonish them a lot, but no use.
Yes.
My lord, our seniors used to say, you read 1 point and you learn 100 points when you read a book. But they don't understand. They are not ready to understand. Now, my lord, kindly sees. Yes. 1993, one Supreme Court cases, 636. My lord, he has referred to paragraph 6.
6, 8 to 11, 30.
My lord, kindly keeps note.
6, 7, 6,
19, 6, 8 to 11.
No, 6, 7.
Oh, sorry, 1993. My lord, this is Anwari Basavraj Patil, my lord.
Yes,
1990.
it is here.
It is his judgment.
1993.
One Supreme Court cases, 636.
Yes.
6, 7, 8 to 11 and 13.
My lord, kindly takes note of para 6.
Yes.
My lord, will kindly see at placetum C, if someone is not joined, my lord, then he has to give security, consequences. Then, my lord, in 7, my lord, 29(2) of the Limitation Act, according to him, by virtue of the said provision, all the provisions contained in section 4 to 24 apply to the person under the Act, including the recrimination notice under section 97. Then, my lord, he has referred to 8 to 11, my lord, which talks about the Limitation Act and its applicability.
Yes.
Then, my lord, Para 12.
Yes.
Counsel for the appellant brought to our notice a decision of this court holding that the provisions of section 12(2) of the Limitation Act are applicable to an appeal under section 116A of the Representative People's Act. It is also brought to our notice that certain high courts have taken the view that both section 5 and 12(2) are applicable to the proceedings under the Act. The reference is to Bhogilal Panda. So far as the decision of this court in B.C. Shukla, it is a decision dealing with the applicability of provisions of the section 12(2) of the Limitation Act. Then, my lord, para 13. The division bench then proceeded to examine whether the applicability of section 5 is excluded in the matter of filing of an election petition and came to the conclusion it was so excluded. Now, my lord, may I just pause here for a moment? This is the judgment. My lord, kindly appreciates, my lord, Limitation Act is the act which prevents a remedy.
Prevails a
Remedy.
remedy, yes.
But for other acts which provide for other timelines. And my lord will also kindly appreciate original applications, suit, they are given the timeline by the Limitation Act. My lord, I am trying to draw a distinction between, my lord, an original application under the Representative People Act is the election petition. Other applications are not original applications.
So you mean to say it is the application, election application with the main suit?
Yes.
And the connected application cannot bar under.
No, and that's why I'll read another of his judgments, my lord, where election petitions were not allowed to be filed after a certain period of time.
Correct.
Because of section 86. As I said, my lord, consequence.
Correct.
The consequence is not there. If it is not consequence is not given, then I was beseeching your lordship to read it as directory and not mandatory. That is what I was placing. So this is a judgment on that point, my lord.
Yes.
Then, my lord, kindly sees 2011 1 SCC page 370, my lord. Election Commission, Telangana. 370.
Yes.
This is 2011, one Supreme Court cases 370, my lord. My lord, he has shown para 44 and 45.
Correct.
My lord, 44 sets out the preamble.
Yes.
And 45 says that the Act is a complete code for the conduct of elections by the Election Commission. For conduct of elections by the Election
Code
Commission.
for conduct of election of the Election Commission of India appointed under 324.
Yes. So, my lord, I am saying the representation of people's act has two parts to it, my lord. One is the elections. Another is a challenge. That's a court for adjudication whether election has gone wrong or not, and the petition, the rights given under the election petition. So, my lord, that, my lord, upon incorporation, I mean, just repeating 1 minute. My lord, on incorporation of the CPC, my lord, and my lord, also, my lord, by High Court rules, my lord, that clearly, my lord, is subject to whatever has been stated in the rules and the CPC. And that is why I say, my lord, complete code, then you'll have to give a consequence. And no, after this period, you cannot. Rather, it says, your lordships will have the discretion of providing whatever terms and conditions. But if I have done a fault, my lord, I will beseech your lordship. One will penalize me. Your lordship will direct me to pay cost. My lord will assess, I will pay the cost. But your lordship will also kindly remember, my lord, I'm just trying to point out to your lordship's notice, my lord, under what circumstances come to 2 minutes, 2 days delay, my lord. Well, because I had done my best. As a matter of fact, we desperately came before your lordship to mention so that your lordship remembers us. I am being very candid. After we did not get the gazette, when we said let's go and mention, so that at least my lord will remember that we had given an attempt at least. And my lord, in 2 days' time, my lord, I couldn't have caused any prejudice to my learned friend. I could have understood. I've come after 1 month and tried to reopen. I could have understood. But in 2 days' time, why? What is my no malafide intent, my lord? There for 2 days, I don't come and then come and because I have already spent 2 more days here. I wouldn't have argued then if I'd come at the right time. That is what I submit, my lord. This is a malafide intent. Then, my lord, your lordship's judgment has been referred to. I have also relied on your lordship's judgment.
28 to 31.
Para 28 to 31, my lord. In this matter. The 13th August, my lord. I have referred to this also, my lord, 28, 29, and 30.
Yes.
And my lord, I have referred to para 30. I'm not repeating, my lord. Your lordship has upheld that maximum chances should be given to keep the results as it is, and whatever is required to be done on that. Then last is which one? This is Chandrachud judgment. This I believe not on the last occasion,
No,
but
I had cited it when my lord was sitting in that building prior to the puja vacations. 18.9 SCC, page 808.
I don't know, he just told me I've taken it out, my lord.
No, I just, because I was not
aware.
Remembering, but his junior reminded him.
89.
2018, volume 9, Supreme Court cases, page 808. 18, ballot. I have another copy. No, no copy.
No, it will. 9472.
But it's 808. Maran may have another copy, Bharat. I cited it, Bharat, on the day when the direction for affidavits were filed.
Yes.
May I just, I believe my learned friend has relied on paragraph 9.
No, 7 to 10.
7 to 10. Sorry. It kindly takes para 7. Charan Lal Shahu, a 2-judge bench, held that there is no common law right to challenge an election since it is purely a matter of regulation by the terms of the statute. The right being statutory, the terms of the statute must be complied. 3 judges bench of this court, Lakshman Das Arora, section 81 prescribes a period of 45 days to file an election petition. So therefore, my lord, in paragraph 9, my lord, kindly comes.
Yes.
I'm sorry, first, my lord, kindly sees the set out portion, my lord, from para 7, my lord, of Lakshman Das Arora. My lord, just in the set out portion, my lord, the last sentence, if an election petition is not filed within the prescribed period of 45 days, Section 86(1) of the Act, which provides that the High Court shall dismiss an election petition which does not comply with the provisions of Section 81, 82, or Section 117, is attracted straight away. So, what are the consequence? Yes. Timeline given, if not fulfilled, consequence given.
Correct.
In this case, there is no consequence. In 116 with 41, there is no consequence. Then, kindly sees 9. Haryana Panchayati Raj Act 94 is a complete code for the presentation of election petitions. So it holds that for election petitions a complete code. Statutes are mandatory. Election petition is filed within a period of 30 days of the date of declaration. This period cannot be extended. Provisions of section 14 of the limitation would clearly stand excluded. These have made a specific provisions. Any election that fails to comply with the statute is liable to be dismissed. So again, the consequence is upheld. So because of the consequence, my lord, obviously limitation act will not apply. That's why I'm beseeching your lordship. 2 things. One is, my lord, again, my lord, kindly. My lord, I have tried to show that there was an order from your lordship for publication of a gazette on my learned friends. They were supposed to finalize it. There is a provision in 116 with 41. If they have not done it, then your lordship will be holding either it is correct or it is not correct, the gazette. But if it is found to be correct, then my lord, we will be giving our learned friends some leeway. Sorry, leeway. Therefore, my lord, I am also seeking that leeway. Then I have also made a mistake, other than saying that it would be a precondition for me coming to court. Because my lord, it is very important that when there are no respondents,
Correct.
so it is a very important factor.
Correct.
So therefore, my lord, if
That's why this court has given the observation in the 13th September order.
different key observations. Yes, yes, para 30.
Para 30.
Yes,
So this
I'm
court-
on that. I'm on that, my lord.
Because Mr. Bhattacharya has argued there's no necessary judgment can be passed after
Yes,
the
my lord,
decision of the
that,
court,
my lord,
after
that's
going-
why.
After going through, the court is funded now. This
Absolutely, my lord. And that is why I also relied on your judgment, your lordship's judgment. A case where both are opposite time. That's why I'm saying, my lord, your lordship has held ultimately it should be done, justice should be done, not on technicalities. My lord, the election representative people act provides for this justice to be done by others coming in. So your lordship would kindly give me that chance.
Okay.
This is my submission, my lord.
That's all.
In case of faith,
Oh, my lord. Nazir Ahmed, my lord, I'll just give a recent judgment.
Because it's a complete code, say for instance in the arbitration, it will not be guided by CPC. But in case of procedure, if the High Court is guided,
Because, my lord, as I said in section 87, they have said that the procedure is to be guided by the CPC. So for that part, my lord, will not be.
So it's not a complete code.
It's not a complete code with regard to, my lord, election petitions. My lord, here, my lord, Nazir Ahmed has been followed. My lord knows better than me. My lord, how a administrative authority is supposed to act, that it should be done in that fashion.
Paragraph 14 to 17.
Paragraph 14 to 17, my lord. This is just for the proposition, my lord. As a principle, my lord.
Procedural law, substantive law.
Paragraph 14, 17 on Nazir Ahmed.
Of
No, my lord, this
of the Supreme Court.
my lord, kindly see this.
Of
I've
which-
given a Supreme Court judgment.
Which one?
My lord, Dilana?
Unreported.
My lord, Union of
Mahendra-
India, Mahendra Singh.
Mahendra Singh.
Yes.
My lord, my lord, para 14 to 17. My lord, in para 14, Nazir Ahmed is quoted, my lord.
Yes.
My lord, these are my submissions.
Yes.
My lord, permit me, my lord, I'll conclude today only. But I'll deal with the petitions one by one, my lord. There are two applications, two IA.
Yeah.
So, my lord, I'll deal with, my lord, first of all, the application which was filed on behalf of the respondent number 16, 6, the respondent number 6. But my argument was that what he is trying to seek is in nature of a prayer for recrimination. This is one, my lord, as contemplated under section 97 of the Representation of People's Act. Am I boita though? Amar boita kothay?
GA3. Mr. Datto, your GA3.
Yes.
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 And
But he essentially seeks a recrimination. But why I had cited, Mr. Ray distinguished, my lord, the judgment cited by me, that is 1993 1 Supreme Court cases, page 636. He tried to distinguish that, but that essentially was, my lord, cited, my lord, on two scores. Para 10 especially, which states, my lord, the ratio is that recrimination notice is at par with an election petition and time frame is mandatory. It has not been dealt with, my lord, by any of the councils, my lord, arguing. That is para 10, essentially 7 and 10. So what the respondent is seeking is in the form of recrimination by way of filing this particular GA. And my lord, he cannot take refuge under section 116 because he is already a party. And a lot was argued regarding the gazette publication, etc., that it is not in conformity. And there is an order whereby, my lord, the draft, my lord had recorded that the register original side shall, that the register original side shall check whether it is in tune with my lord's order dated August 2025 or not, and thereafter cause the publication. It is not that, my lord, it has been published by the petitioner or on behalf of the petitioner. The my lord had held, interpreting 116, that the question of abatement does not arise. Para 28, which I relied upon, because before that, my lord had recorded the entire submissions, including the submission that 116 contemplates of a situation, either death of one or any of the respondents, that is one, or a notice from the sole respondent or from the other respondent that he does not want to oppose the petition. Here there was no such notice. So my lord held in para 28 of the judgment that as per section 112 of the 1951 Act, the election petition shall abate only on the death of a sole petitioner or of the survivor of several petitioners. In view of the same, after the death of the respondent number 1, question of abatement does not arise at all. Petitioner has informed the death of the respondent number 1 by an affidavit after serving copy to the other respondents. None of the respondents have filed written statement, nor any notice given that they do not intend to oppose. Because I had drawn a distinction while arguing regarding, my lord, non-filing of written statement as contemplated in the Code of Civil Procedure, my lord, it is recorded at in length, my lord. It starts from para 20.
Yes.
And, my lord, the effect as contemplated in the Representation of People's Act.
Correct.
So, my lord, here an official gazette was published in tune with, in terms of, my lord, section 116 of the Representation of People Act, owing to death of one of the respondents, because it was never unopposed. My lord had fixed it uncontested.
Yes.
And that is why the Honorable Court returned to the finding that that situation of abatement does not arise. Now, my lord, this was also, my lord, not answered, my lord, because while arguing also the maintainability point, I had, my lord, placed reliance on this paragraph also specifically. I had specifically relied on 28 to 32.
Yes.
This was, none of the parties, my lord, argued about, my lord, non-service of notice. My lord, that apart, in so far as, my lord, the issues are concerned, my lord had framed the issues back in April 2025. The issues are, my lord, whether it is in proper form, whether, my lord, the order is dated 17th April 2025. First issue was whether the election petition is in correct form and maintainable. Second was whether the nomination papers of the respondent number 1 ought to have been rejected by the returning officer. Third was whether the petitioner ought to be declared as the return candidate. Because, my lord, there was no argument made also, my lord, on the question of corrupt practices. Here, by way of filing applications, they are trying to, my lord, incorporate a point that no, we want to file recrimination, in essence of recrimination. They're not saying recrimination. That no, she should have been also disqualified owing to corrupt practices. Now, first is, my lord, had relied on Jyoti Basu's case, Jyoti Basu versus Devi Ghoshal. While, my lord, hearing the main, passing that order, my lord. Yes, my lord, may kindly take para 12 once. Para 12 specifically forbids anyone apart from a candidate to raise a question of recrimination. Copy the order, Jyoti Basu, just I will file a mota file.
Yes.
Yes, para 12, my lord, kindly takes, my lord. States that there is another viewpoint when an election petition, in addition to the declaration that the election of the return candidate is void, a further declaration is sought that any candidate other than the return candidate has been duly elected. Section 97 enables the return candidate or any other party to recriminate. That is to give evidence to prove that the election of such candidate would have been void if he had been a return candidate and a petition had been presented to question his election. If a person who is not a candidate but against whom allegations of any corrupt practice are made is joined as a party to the petition, then by virtue of his position as a party, he would also be entitled to recriminate under section 97. Surely such a construction of statute would throw the doors of an election petition wide open and convert the petition into a free-for-all fight. A necessary consequence would be an unending, disorderly election dispute with no hope of achieving the goal contemplated by Section 86(6) of the Act, that the trial of the election petition should be concluded in 6 months. So, my lord, insofar as the petition, the application by the stranger is concerned, on the face of it, my lord, it is not maintainable. He essentially seeks, my lord, a prayer for recrimination, that too on a ground, my lord, which has not been also, my lord, framed as an issue in the election petition.
Yes.
And, my lord, consequence, a lot has been addressed, my lord, by my learned friends on the question of consequence. But the consequence has been stated here in, my lord, the consequence being, my lord, Section 86, subsection 7, my lord. And in fact, but when a special statute prescribes an exercise to be undertaken in a particular way, time being the essence, my lord, it cannot be argued that there is no consequence spelled out. The basic consequence is 6 months. That is why, in fact, section, my lord, kindly take section 87 once. Sorry, extremely sorry, my lord. Yes. 87(1) lays down the procedure before the Honorable High Court. It states that subject to the provisions of this Act and of any rules made thereunder, every petition shall be tried by the High Court as nearly as may be in accordance with the procedure applicable under the CPC to the trial of suits. So this is always subject to express provisions in the Representation of People's Act, my lord. This is always. And thereafter, this is how, my lord, frivolous pleas are to be rejected, my lord. That power, my lord, that was also contemplated of, my lord, by the parliamentarians, my lord, while framing this particular law. The proviso, provided that the High Court shall have the discretion to refuse, for reasons to be recorded in writing, to examine any witness or witnesses if it is of the opinion that the evidence of such witness or witnesses is not material for the decision of the petition, or that the party tendering such witness or witnesses is doing so on frivolous grounds or with a view to delay proceedings. This is the exact case. The respondent was in a deep slumber. Our argument was, my lord, in August, that the consequence will be he will be deterred from filing his written statement. But he always had the right to cross-examine.
Correct.
So he waived that. Suddenly, after publication in the Gazette, though, my lord, benefit under 116 cannot be taken, he springs up into action. He springs into action and says that, no, now I think I have a right, and seeks something in the nature of a recrimination, which again, my lord, as I was, my lord, just arguing, my lord, 93(1) forbids. About the judgments which are being cited by my learned friends, my lord, most of them are on the general propositions of law, apart from Kailash versus Nanku and the judgment passed by the Honorable Coordinate Bench. The Honorable Coordinate Bench was contemplating a situation regarding extension of time to file written statement. Our case is completely different. My lord, I say that the code, that is the Representation of People's Act, it lays down the time frames. Correct. If my lord kindly takes section 86, my lord will find 86 subrule subsection 4 and 5. It speaks about, my lord, the timeline. If someone is not made a party, who should have been made a party, he has to apply within 14 days. So these periods are contemplated. Similarly, my lord, 116, a period is contemplated. However, admittedly, my lord, section 5 is not applicable. There is no question of condonation of delay, my lord, when there is a specific express timeline which has been spelled out, my lord, in 116. No. And my lord, there has been no attempt to even distinguish, my lord, the provision of law laid down, my lord, in 2018-9 SCC page 808, paragraph 10. It states that when a special court, when there is a specific provision by the legislation,
That be all right.
it cannot be extended, my lord. I say, my lord, this is, my lord, hopelessly, first of all, my lord, barred on the face of it, owing to the provisions of the Representation of People's Act. It has been filed, my lord, may kindly recollect, my lord, at the initial stage, the returning officer had taken a personal interest and filed an affidavit when a report was called for regarding preservation. So, my lord had admonished, my lord, such conduct and sought for a fresh report. Thereafter, my lord, they contested, they filed a written statement, the returning officer. Thereafter, suddenly, my lord, when the matter was about to get concluded, they filed an application saying that we should be deleted from the array of parties. So it has always been, my lord, by or through someone, my lord, to obfuscate the real issue. Our case was very simple, my lord, regarding issue number 2. And the argument was, my lord, concluded. But then, my lord, sensing that, my lord, the result may not be palatable, first of all, a writ petition was filed that declared elections immediately by some persons, my lord, of that particular constituency. And thereafter, my lord, these, my lord, barrage of petitions, my lord, these were being filed, my lord. But I say, my lord, none of the decisions, first is 2018 9 SCC page 472 is pertaining to the Arbitration and Arbitration Act, my lord. CPC made applicable to election petition is again, my lord, I had pointed out, my lord, it's subject to, my lord, the provisions of the Representation of People's Act and the rules. I never said, my lord, that the rules pertaining to election petitions of the Calcutta High Court and the Representation of People's Act are in conflict with each other. And what I say, my lord, that the petitioners, one more thing, my lord, they had submitted that I had not taken the point of limitation in our affidavit. Yes. Page 6, paragraph 4, it is a specific ground, my lord, which has been taken. And also paragraph 11, my lord.
Para 6.
Yeah, page 6, paragraph 4 and para 11, my lord.
Yes.
Well, these are my humble submissions, my lord. Only one thing, my lord, that I will be humbly beseeching your lordship, my lord, since I filed my written notes, my lord, on the main, insofar as the main matter is concerned. My lord, may kindly dismiss it, my lord. My lord may not inflict heavy cost, my lord, on them. Otherwise, my lord.
Thank you.
Grateful, my lord. Extremely grateful, my lord, for the patient hearing, my lord.
Counsel for the parties have concluded their argument in connection with GA2 and GA3. GA3 and GA4.
But only one proposition of law, my lord. A person who intends to be substituted, my lord, must have the same interest with that of the person who has died. Yes, the principles are there in 2012, volume 5, Supreme Court cases, page 127.
2012?
2012, volume 5, Supreme Court cases, page 127, paragraph 16 and 17. I was very hesitant to cite it, but the exuberance of my learned junior, my lord, all of them, in fact, my lord, all three of them, they've burned the midnight oil, my lord. They've done it.
Before my lord rises, my lord, bother your lordship, my lord, the matter was, my lord, before Justice Aniruddha Roy, he has released the matter at 4:30 today, just now. We have got it assigned before your lordship. The interim order is expiring today, passed by your lordship. My lord, otherwise, my lord, I am mentioning upon notice to my other side.
Assigned to me.
It has been released at 4:30. He was hearing from 3:30 to 4:30.
He already achieved success by getting it assigned, my lord.
I went to the Chief Justice Millard room and got it assigned before a lordship Millard.
So you have to give the copy to the Mr. Bhattacharya, Mr. Datta, Mr. Ray.
No, I am mentioning upon note.
They have retained this court till 5 p.m.
Yes,
so
yes.
True.
Millard, this was the interim order, Millard, last.
The interim order.
Millard, this is the last order.
Who is for the other side?
Millard, they appeared, Millard.
That one?
Yes, that one, Millard, bank guarantee.
The counsel for the petition submit that the interim order is still today and prayed for action. Counsel for the petition prays for extension of interim. Accordingly, interim order is extended till 11th December 2025 or until further order, whichever is earlier.
Oblige. My lord, the matter, returnable matter, now it is before your lordship only. My lord, give the returnable date, my lord.
But we have filed already, my lord, the written notes, my lord, insofar as the main matter is concerned. Here, my lord, I don't think written notes will be required.